I'm a regular over at the Trial Watch Clips channel, where you go for clips of your favorite judges and your favorite attorneys and your favorite trials and your favorite cases. I'm a regular over at the Trial Watch Clips channel, where you go for clips of your favorite judges and your favorite attorneys and your favorite trials and your favorite cases. I'm a regular over at the Trial Watch Clips channel, where you go for clips of your favorite judges and your favorite attorneys and your favorite trials and your favorite cases. I'm a regular over at the Trial Watch Clips channel, where you go for clips of your favorite judges and your favorite attorneys and your favorite trials and your favorite cases.
Have the defendants.
All right. Hey, folks. I think we had a little mix up in time, but I think everybody's here. And I'm almost afraid to ask, where are we? Go ahead, Mr.
I was just going to say that there has been significant progress made. There's been some, I guess I'll say, stumbles along the way, but significant progress is being made, I think, on schedule. The fire doors that were in question did arrive, are being installed. There are some issues with inspections and building permits that need to be ironed out. I don't believe any due to any fault of the property manager, but my co-counsel has been very actively involved dealing with the property manager, communicating directly with the property manager, and I think is better prepared, informed, I should say, really, to address the issues that are still remaining. But that being said, we do believe we can meet that schedule that was set previously.
Yes, Your Honor. Ms. Ellis indicated fire doors are ordered. As you know, we submitted the plan to you at the last hearing.
Yes.
There were a number of permits that the city was requiring the property manager to pull. Those have been pulled. My understanding is on May 2nd, there were 13 building permit inspections scheduled. 12 of them were passed on that day. There was one that did not pass due to the drywall not being painted at the time. But the
drywall not being painted?
Yes. The drywall. Yes, so the 13th one failed because the drywall was not primed yet. FDIC, the vendor, had a hard time getting the mud to dry with the tenant taking a steamy shower. So it was not able to be painted. They requested to have a photograph of it being primed, sent to the city within maybe, I believe it was like 30 minutes after. They were told that they could not do that. So they had to reschedule it for a new inspection, which I believe, Stuart, was that new inspection done?
It's on for this weekend.
Okay, so that new one is scheduled for this week. There was the soap testing that was to be done on areas. They received a proposal from TK Environmental. The proposal was executed by the ownership, and they're just waiting for scheduling for that from TK. So that is in the works to be completed.
Okay.
There were 2 items with electrical permits for 2 of the units in 721 Clark. The property manager is hiring LR Rolls Mechanical to pull electrical permits and schedule those inspections. Similarly, with a ceiling fan that was in a unit within 721 Unit 206, LR Rolls is being hired to pull the electrical permits for that as well.
But those electrical, they haven't been pulled as of yet, but you've hired somebody to.
Yeah, so the idea is that the company comes in and pulls the permits during that process. So they're working on hiring LR Rolls to do that. There was also, there's this boiler boiler letter and baseboard covers there was a request by the city that we provide them with a boiler letter, basically that would attest to the fact that boilers are in working condition. The boiler letter had previously been sent to the city on March 17th, April 8th, and April 29th. We received a correspondence from the city on the 29th saying that the letter needed to be signed and dated per building, and that the letter did not have the building addresses on it. And so a new letter was provided to the city, and it was indicated that the signature was not a wet signature on the letter, and that the person doing the inspection is not the licensed holder. So we're trying to get in contact with the contractor so that they can communicate maybe with the city directly to get them what they need. But it seems like.
So the 3 boiler letters, are those for 3 separate boilers?
Yeah, I believe that the company came in and looked at all of the boiler covers, or maybe Mr. Beal could speak better to this. Can you speak about the boiler letters and what that is?
Yeah, this is one of the last remaining issues that are gonna cause a problem on, May 20th. The city is requiring a letter from a licensed boiler contractor, to say that the boilers are operational. We provided that letter 4 times over the last 45 days, and it still has not been accepted by the city. And so we're asking the city to accept it in its, most latest iteration. But one of the problems is that the boiler system is very expansive and complex. It has 24 apartments in each building, and there are radiator covers in each apartment that Jerry, the inspector, says if they're damaged, they need to be replaced. But
Well, I don't need to know what the problem is. What I'm trying to figure out is the letters that were sent. Were those encompassing all of the boilers for these particular units, or what were they?
So there's one boiler per building, and we provided 1 letter per building now.
All right. Okay.
So as Mr. Beal indicated, this is going to potentially be an issue coming on the 20th. Because the position is that they want all of these base board covers that deal with these boilers replaced. And that is going to be approximately, I believe you said, about $20,000 a building. And so to the extent that this letter is saying that these boilers are operational, the property manager and the owner are saying that they will replace the boiler covers that are the most damaged, obviously, but to the extent that they're still working properly, it doesn't seem reasonable to require them to replace every single baseboard cover in order to pass this inspection on the 20th.
And to be clear, the city is not requiring us to replace every baseboard cover, but they're not telling us which baseboard covers they actually want replaced. So that's why it could be an issue on the 20th. So the city should either let that go or tell us.
Why don't you sit down?
Thank you.
You don't need to tell them what they need to do. All right. Okay, go ahead.
Also, the city was requesting a letter regarding pest control. It's my understanding that information, we have that information, and if it hasn't been provided to the city, the instruction is to provide it today. I believe that was, I saw it at the end of last week, so that letter will be provided to the city.
Indicating that somebody's been hired to do it, or that it's been completed.
It would be the contract for the pest control, letting them know when they're coming out, how often, services, things like that. So that'll be provided to the city as well. And then as Mr. Beal, I think, indicated as well with regards to inspections that are happening at the property. Another issue that we've run into recently has been scheduling the inspections and having the city come out to do the inspections. We're requesting inspections for several buildings on certain days, and the communication that they're receiving from the city is that you have this window, we're not calling, we're not going to the office, we're not asking for anybody. Somebody be at where they need to be when we arrive. And if we've got 15 buildings scheduled for inspection one day, we don't know where the city is going to come up. So we're dealing with those kind of issues where they're refusing to communicate, and, you know, time is of the essence at this point. Everybody at the property is valuable. So having, you know, multiple employees camp out for a 4-hour window potentially to see whenever the city arrives, as opposed to, you know, a brief phone call and on the way, you know, it's becoming a bit problematic. So we're hoping that permits, to the extent that any additional need to be pulled and inspections need to be done, that this is not going to delay the process. So that's just something we wanted to bring to the court's attention as well, because that was specifically occurred with regard to those 15 that we had scheduled for May 2nd. So. Outside of that, I think that those were the main issues that we wanted to point out with regards to the plan and the progress. There also has been a request for 2 special inspections to occur this week with regards to drywall that needed to be removed. So just in the process of getting the work done, drywall was removed that, you know, they didn't anticipate being removed. So they're requesting special inspections to occur this week so that we can ensure that we're on track for the timeline. There has been no response to that request as of yet, but that request has been made to the city. That would be the primary things we would want to flag for the plan. We do have a copy of the most current list of items from the correction order that were ongoing from the city, which we can provide to your clerk via email.
Yeah.
It gives a layout of what's been done, and then also kind of the plan for getting those things done by the 20th. I just received those, so I don't have a printed out copy, but if that's something the court would like, we can make sure that
Yes.
that's emailed to you all. And that is the ones for 720 and 721. So we can make sure that the court has those.
Wonderful. All right.
Yes, sure. I had a chance to speak with Mr. Myers about all this, and it does sound like there's some progress being made, but it sounds like because of the fact that they're inspecting the other buildings at the same time, as well as other properties that Beal owns, that they haven't had the chance to, you know, get to where they need to be, where they think they're actually going to be on time to make it to the original schedule. I think about half the inspections they've been
What is that?
About half the inspections they've been doing on the Beal properties, or on the Arbor 1 properties, have been for other buildings that aren't these 2 buildings in question. So for that reason, they haven't been able to meet all the requirements that they have to for all the inspections. I think Mr. Myers should probably speak better about this than I can.
Well, come up, Judge.
Yeah.
Yeah, over the last 3 weeks, we have done about 73 inspections at Arbor 1. 38 were on these 2 buildings, so roughly half. 16 were approved, canceled, or not ready, disapproved, so they're failing a little over 10% of all these inspections. They're scheduling inspections for other properties that Mr. Beal owns and not these buildings, which is taking up our inspectors' time away from being able to inspect these buildings, to where next week we have 5, or this week we have 5 open inspections, 1 on Tuesday, 1 on Thursday, and 3 on Friday. The special inspections that they requested on Friday at the end of the day are for times that we don't have inspectors working or that we don't inspect. Because they asked for 1 on Friday at the end of the day at about 4, I think, and then Monday at the end of the day when we don't have an inspector. So we have 8 permits scheduled for this week to be done. There's about 20 that needs to be done, and so we have done whatever we can to make this happen. As far as the inspection, we give everyone a window. We have been told that we treat people differently, but We give everyone the same 4-hour window, for inspections. And then we've also said on several occasions that we're going to always start at 721 Clark. It's the first address. That's not good enough for them, but that's really what we can do. But yeah, it's very concerning that out of
What's
the,
not good enough? What do you mean that's not good enough?
so they would like the exact time that we're showing up, when we really don't know when that is, because the inspections happen all throughout the city. But yeah, so this week we have 16 or 14 inspections scheduled for Arbor One, but only 8 of them are on this building, these 2 buildings. So seems like they're prioritizing other buildings over these 2 buildings.
Why do you say that?
Because if these 2 buildings are the only concern, which we've been told in an email from Mr. Beal that the city's only concern is approving these inspections, they're prioritizing other buildings in the complex
Yeah, but
permits.
what's gonna happen is that if they don't, I don't know if that's a prioritization. It's that this is sort of an ongoing concern.
Mhm.
So if I'm working over here, because that may be my next phase that I'm going to try to get some things done, then I would be trying to do them both at the same time.
But we only have a limited number of inspections we can do in a day. And so by taking them away from these 2 buildings, we're being pulled from those 2 buildings.
Okay. Regarding that,
Your Honor, if I may, I find that statement incredibly problematic because if we weren't doing work on other buildings, I mean, properties actively being cited by the city and other buildings as well. So we're splitting time, and I don't see that as a problem. But as Mr. Myers indicated, majority of those requests were for these 2 buildings. So also, last hearing, Your Honor, you were inquiring with the city with regards to I guess the third-party contractor that comes in and does certain permanent inspections and things of that nature. Since that hearing, we have spoken with one of their representatives, Jeff Hafer, individual who does the building permanent inspections typically for Arbor One. And he's indicated to us that he's having to find other work because the city is not keeping him busy enough. And because Jerry Dunham is now doing all of those inspections. He's a little.
hold on a second. So this is a third party person to do inspections. That's at least telling you that he could do more, but that he's not being requested to do more.
Correct. He's Jeff Schaefer.
Stop there for a second. What, do you know anything about that? Huh?
No.
Okay, go ahead.
Yeah, our property management team spoke with Jeff Schaefer, who is an employee of Code Enforcement Services, CES, the company that the city contracts to do the building inspections. Jeff indicated that he's not being kept busy enough with the work now and has to reach out to others, get work from other municipalities because Mr. Dunham is now doing the inspections that he previously did. This is, on top of the scheduling, this has been an issue for us as well because working with Jeff, the process was, streamlined. We would do the inspections. He would give us yellow cards letting us know the inspection results. We would be able to, continue on from there. We now have Jerry doing those things. We're running into we're not answering the phone. We're not letting you know when we're coming. We're not calling, as well as you're not giving us inspection cards. So we have no verification at a certain point to establish whether or not we passed, which is problematic from a property management perspective. With the city coming out, we want to be able to verify when an inspection is passed and when it's not. So at this point, their position has been that they're not required to give them, but up until this point, we have always received them from CES. So just something we wanted to flag with the court as well, because these are things that are.
Well, hold on. Can this guy do more inspections?
So there are, per our contract, and
Whose contract? With who?
the city and CES.
Okay,
We can do 6 inspections a day. We have done more than that over the last 2 weeks, and we have yet to,
with this company?
with both with Jerry and this company, to make sure we get the inspections done.
All right, get on the phone right now, find out how many inspections he can do in a week. Let's do it right now. Because this doesn't make any sense to me. If somebody can do the inspections, then let's get them done.
Another issue I was hoping to bring to the court's attention.
Sure, go ahead.
So some of the tenants that have been relocated both in and out of court to the township side, they've continued to escrow their rent. And now they're receiving 7-day notices to evict them. One of those people, Miss Natasha Drake, is in court today.
So she's receiving a 7-day notice. With, that they're on the township
On the township side, but she's been escrowing her rent
here.
in this case, yeah.
Okay, and she's escrowing it on her case, right here, right? Okay, so, just so that you know, and we haven't quite worked it out, Judge Washington is aware who would be handling the township cases. She's aware that the escrow is being paid here. How exactly that financial mechanism is going to work, we're not sure. Is the rental amounts the same? Or, well, that's going to be the part of the issue. The other part of the issue is who's going to be paying for that relocation, which is another issue. So
That's a twofold issue because of course we had our hearing with Judge Conkey last week on our preliminary injunction motion, presented by the city prosecutor, that has not translated into an order yet for various reasons. However, if she addressed the issue of rent payments, relocation of tenants, she's made clear that tenants who are requesting relocation assistance can speak before her on 3 days' notice.
can do one.
Can appear before her with a motion on nearly 3 days' notice.
Okay.
She did reserve the issue of various things like emergency repairs, health and safety related repairs for a hearing. It was originally scheduled for 6/6 inexplicably. It appears that hearing has been moved to 6/20. Any tenant desiring to be relocated is to receive a 100% refund of all of their escrow funds, all of their paid rent from 9/17. So that would affect obviously the escrow order of this court once her order is entered, and also the escrow.
They're to receive what?
They're to receive a refund of all of their rent paid from 9/17 if they paid rent
From 9/17.
9/17 of 2024, which was the date of the suspension of the certificates of compliance, and that they would be prohibited from seeking to collect rent while there are no certificates of compliance, because that's explicitly what the order or what the ordinance requires. It also prohibits leasing of buildings at the Arbor property on the city side. Also prohibits all rent collections, that I believe I just said. And so she's looking at relocation on a case-by-case basis and addressing the
Has the,
refund of escrows on a case-by-case basis.
well, I'll wait to see her order on that. Then deal with
There's a
it.
lot going on, obviously. I'm not sure what you were aware of.
Mr. Henry, so what's gonna end up happening is even if And it's gonna be a bit problematic returning escrows because the escrows may need to be paid, or at least these people could end up being relocated to the township side. And now you've got basically 3 courts with their hands in it, trying to figure out what to do. So I think between the 3 of us, we'll have to figure it out.
You said Ms. Drake was.
Ms. Drake is one. I believe it was also Mr. Blankenship. Then there was some that were not in court, like Alina Jordan, Lawrence Grove, and Weena Harris Freeman.
And these individuals have all been relocated to the township side?
They were all originally on the city side, relocated to the township side.
Okay. Township side has COCs.
Correct.
Why are they still escrowing their rent when they are in a?
Because they wouldn't be on that side, but for what's happening on the city side.
I think another issue is they were relocated, given new leases, so they don't know if they have an increase in rent, a decrease, or if it's the same as previously. Some of them have leases that are ongoing, some the lease expired, so they've just been escrowing the same amount that they would pay either to the court or to the city.
And I mean,
I don't need, Mr. Beal, I don't need your comments. Go ahead. What were you gonna say?
so the court has ordered that even if they're on the township side with COCs.
I've ordered them to comply with my escrow order.
Okay.
And where they can either do it to the court or to the city. Because the question really is going to be, if they've been relocated, do they intend on coming back, or should they be paying for where they are? And I guess maybe the way to look at it is, it's one thing if they're in a new apartment, and one can look at that in one way. Or you look at it from the standpoint that if they were placed in a hotel, then would they be paying the hotel bill? No. Right? So is this temporary? And I think and Mr. Henry, you can correct me if I'm wrong, but the real question is this their relocation to the township side a temporary solution, or is that a permanent solution that at some point that's where that person's going to be?
Right, and I think that's would kind of speak to the answer to his question, is speaking with all these individuals to see if they intend to stay in the township side, or if their intent is to, again, be relocated back to their unit. If they intend to stay, then I think that conversations should be had about whether or not they should be paying rent.
Well, and whether or not they have a lease.
Right, and then,
I mean, I would agree with you in that respect. But remember how this all started. It all started because the units on the city side were not in compliance. So these people had to be relocated. The people get relocated, and some of them are put in hotels, some of them are put in other units, with no clarification as to the permanency of any of that. So.
If I may, Your Honor, it seems if somebody's been relocated to the township side in a certified unit, they are certified, that and they wish to stay there, they like their accommodations, and are willing and able to sign a lease or a lease extension, that rent should resume. It's there's no health, safety, or certification issues that would include the landlord from requesting rent for a certified unit that the person intends to reside in.
if they have a lease,
Yes,
but I don't know if any of these people have leases.
That's my understanding that they don't have leases. Ms. Drake, is that correct, that you don't have a new lease?
I'm sorry,
That's correct.
you don't have a new lease, yeah, so, I mean, ultimately, the real issue is, are they intending on staying there? Have they moved? Or have they, I guess, for lack of a better term, have they relocated or have they moved?
Right.
That's really gonna be the issue, as far as I'm concerned.
And we can, obviously, I can communicate with legal services about having those conversations to see if some of these issues could be resolved. Because I think that, this turns on a few of those questions that I don't think anybody has a clear answer to at this moment, so. What the intent of the tenants would be.
Do we get an answer regarding the inspection?
So not quite, but I have an answer that I think will satisfy. We have not denied any inspection at this point. We are running out of time for the 20th. But we have made it work. We might not be able to make it work with the timelines that they want, like end of day Friday and Monday when we don't have any inspectors. But we have yet to deny one inspection. And so
I don't know that that's what I asked.
and I have sent back to our company that does it. And so
Pardon?
I have a call in and a message to call me back because I'm in court, but I have not gotten a call back from CES.
That really dictate in certain respect whether or not the 20th is gonna be able to happen.
And their boots on the ground are telling our boots on the ground the 20th isn't gonna be happening.
What?
So even our boots on the ground are hearing from their people that they're not likely to make the 20th. They're only pulling permits on certain things. Even last week, as you heard from them, there's certain permits that haven't even pulled, they haven't hired the person to pull them. And that's been 2 weeks ago that they agreed to pull those. So we have issues. The city's not the problem here ultimately, Judge.
Well, I think everybody's a problem. Because what I'm hearing is I don't think people are communicating. I think people are getting in certain ways for whatever the reasons are. And that's fine if everybody wants to act that way. I mean, I certainly will let Judge Conkey know what I am seeing on my end, regarding that. But, if, I mean, just by way of example, if one side is hearing that somebody can do more inspections, but for whatever reason, those inspections can't be done, that doesn't make any sense to me. I mean, it's like we're talking everybody's talking two different scenarios here, which makes no sense to me.
Meeting we had here a couple of weeks ago, they asked us to attend, and one of the items that came out of that was insistence on our part and agreement with theirs. There would be a single point of contact. So we didn't have this, he said, she said folklore, from whoever it's being spoken to. We identified who we wanted to have as our single point of contact. And it was our understanding that they would do the same. And, when there's a disconnect like that, again, that we try to address.
How many inspections on 720 and 721 are there this week? Yeah.
8.
That's all that's been requested.
Yes.
Is that correct, Council?
That's all.
That's it.
Yes. 8 has been requested. 8.
You said you had the punch list of what needs to be done.
Yes, I have, 2 documents, that are the rental inspection correction notices, one dated April 3rd, one dated March 31st. And this appears to be the most recent list, and it's laid out by what's been done, and the notes from the property management team as to plan to get those things done by the 20th. So yes, I can email that to Ann.
Okay. And I guess my question is, that list, is everybody operating off of the same list?
Yes.
I think so, yes, Your Honor.
Really? Are we,
I think it's the city's correction order list, so we're working, yes.
is that the latest one? All right. And so the object is to get what's on that list done by the 20th.
Yes.
All right. Mr. Henry, was there anything else?
I don't believe so, Your Honor.
So the issue regarding the working out who's going to be where, how's that? Are you just going to reach out to legal services and try to resolve some of those things?
I'll communicate with, legal services, and we can see what information they can provide us regarding the tenants as to their intent to stay or go, and then from there, I think we can have conversations on, leases and things of that nature.
And if you have a list of who received those 7, 8 notices, we could probably try and reach out to many of those we can to see what their, preference is or what their plan is.
Make a note to, I don't know that I'll see this week, but I'll touch base with Judge Washington just so that she's, or Magistrate Bailey, just to make sure they're aware what potentially could be coming down the pipe on those. Those, and I don't know if you can, if anybody can answer this, those cases would be filed in the name of Arbor One or the village. How would those cases be filed in the township? Mr. Friedman, do you know?
Mr. Beal's using, his other, his regular landlord attorneys for that, Your Honor. And I'm not involved.
Got it.
I'm not aware of it either.
Okay. Then I'll let her know that I have no idea, but they're there. Okay.
Once we establish, whether or not tenants intend to stay on the township side, to the extent that they have been escrowing their rent while on the township side, is that rent then being released as rent to the property?
Say that again.
So tenant A, been on the township side, been relocated for a month. There's a COC over there. We set up a lease with this tenant just to kind of establish what's going on. She escrowed her rent for that month. Is that rent now being released to the property?
Okay, so here, that's going to be a complicated answer because theoretically, if there's a case filed at 14B, okay, on the township side, my preference would be to release the funds to 14 B court and then let Judge Washington make that determination. If there's been no case filed, and this is where it's really going to get sticky, my feeling would be that once all of that's worked out, then somebody would give me the numbers to just figure it out what needs to go here and what needs to go where. That would be my preference. But what's now being indicated is that there may be an order coming down from the circuit court that all the money's to be given back to the tenant, which means that anything I then have would have to go to the tenant to do with what they need to do. Now, I would seek, quite frankly, to try to get a clarification from the circuit court, or have somebody do that, get a clarification from the circuit court as to, in those instances, what should be done.
I think the circuit court order also is a caveat that these monies are being returned if the tenant decides to break their lease and leave. So.
Oh, well, that's wholly different.
Right, so.
What?
That was the point that Ed brought up.
So, okay, but let me ask this, because I'm not sure how one would interpret the order. Is relocating, but then the tenant makes the decision, I'm gonna stay I'm gonna stay now at this new place. Based upon what's being said, that money, the monies that would be held here go to the tenant and not to the landlord. Or is that not your understanding?
I don't think that would be my understanding. I think the tenant relocating, I think we're confusing two issues right now. So.
Oh, I'm not confused, but go ahead. No.
I think that there are some things with Judge Stunkey's order that are very clear. I don't think there's any dispute that it was decided that if a tenant decides they want to leave and break their lease and leave, that they can do that. There's no issue with them breaking their lease and leaving.
And that's really the breaking of the lease.
Right. So.
But a relocation does not fall in that category.
Right. That's where I was leading. We were confusing two issues. So a tenant can decide they want to leave. They can break their lease. However, one is not going to object. If that happens, they can be refunded money that they paid in escrow. That can be refunded rent that's been paid since the CFC period until the time they vacate. And then I believe that they would be returned a security deposit if they paid it. If they decide to vacate and leave. And
got it. Okay. Was there any?
Is that your understanding as well? I just want to make sure. That seems very clear.
So it was more of a emergency motion, so as to help the people that were still located in the condemned units to get out as soon as possible.
Correct.
I think that's why it was specific to those people.
Got it. That makes sense. Okay, so now to people who, and again, I'm going to have to see the written order, but to people who are relocated, but then elect to stay, which was basically what Mr. Henry had brought, elect to stay where they've been relocated to. What's supposed to happen with their escrow? And please don't tell me it's silent on that.
I mean, the order did not speak to individuals receiving any funds back unless they were electing to break their lease and leave. So if somebody was relocated, I don't think that this order spoke to whether or not they would be entitled to any of those monies back.
Okay, and let me just say this. Based on what's explained to me, that makes sense, right? However, and I'm just talking technically, but it's not my order, so I don't know how to interpret it. Somebody being relocated and then the conversation occurs, I'm gonna now stay where I've been relocated. By definition, they then break that lease or that tenancy that they had. And so if that's the interpretation of that, then they fall into that same category. Just thought I'd throw that into the mix. But I don't know if that was the intent of what Judge Conkey was ordering.
And not speak for Judge Conkey, but my understanding of the hearing is that was not the intent. It was only specifically pertaining to individuals who are currently at the property on the city side who want to break their lease and leave the city side.
That may be a fight for another day. It just, because it just has to be some clarification on that, and that's gonna, part of, as I see it, somebody, somehow or another, there's gonna have to be some clarification of that, because what's gonna end up happening is at some point, the folks on the township side are gonna file a case. And then it's gonna be sort of one court, 14A may have the money. 14B has a case looking for the money. And the circuit court has issued some order. So somewhere along the line, that has to get clarified rather than everybody scrambling around trying to, at the last minute, trying to figure that out. Bless you, it seems to me. So, anything else we need to, now that I have this update, anything else we need to do prior to me giving the next date?
Your Honor, Todd Ryan appeared by Zoom. Permission to speak briefly?
Yes, go ahead.
So Todd Ryan, PA1848, representing plaintiff prosecutor in the circuit court matter, not a party, speaking as a friend of the court and informed the court regarding that recent conversation about the scope of the order. That is going back before Judge Conkey as to what exactly was ruled and was not ruled. Both plaintiffs and defendants have submitted proposed orders to the court for the court to finalize. But it was very clear on the record that it did not involve township properties, that the judge was focused, because that's what we presented on the city side. And for the city side, the judge did orally rule that there wasn't a basis for escrow on the city side with the lack of the CFC. But that was purely for the apartments, and that was kind of a necessary precondition to not ordering escrow on the city side alone. Again, that'll be going back before the judge on some other hearings on Wednesday, so it's very possible the judge
Not ordering escrow on the city side. I don't. Okay, that's fine.
And so with the unusual procedural posture here with plaintiff prosecutor not being a party before your honor and their separate claims for the prosecutor than for the tenants, I understand trying to get ahead of it and making the order as consistent as possible, but as I believe Counsel Henry said earlier, this was in the context of a preliminary injunction for emergency relief. And we're going to have a more protracted presentation and regarding where the money should go out of that emergency context.
Okay. So, are you telling me the circuit court has vacated my order?
No, Your Honor. The circuit court orally found that she would not order escrow on that, and there wasn't a basis to do that for what was presented to her. And she did orally say that the tenants could submit this to district court and to the city of Ypsilanti for that court's consideration. But Your Honor, that may not be reflected in either proposed order.
Of course.
And I do have a recording of the hearing available, but to the extent, just thinking out loud here, to the extent Your Honor had questions to present to the circuit court because they impact your case, I wouldn't make a suggestion on that for Your Honor.
That what? You do what?
Oh, I'm I don't want to make a suggestion to Your Honor about what would be helpful for you. I was thinking of the context of like a certified question, but you know, this is a very different kind of procedural posture within district court and a circuit court with different parties before each court.
I just called Judge Cookie if I had to try to figure it out. And then once I see a written order, I mean, I don't think on either end, and I would hesitate to say, not speaking for them necessarily, but with Judge Cookie, Judge Washington, and myself, I don't think anybody's trying to make anything complicated. It's just we need to know what to do. And so that everything is consistent. So, and sometimes that could not be the attorney's objective, but I think it would be the judiciary's objective. All right, thank you. All right. Did we get a call back on that inspector? Okay. So prior to our next date, I want an indication regarding these inspections so that, and if who is it, CES, if they're willing to put something in writing saying that they can do more inspections, I'd like to see that. And I guess I should clarify. Are they willing to do more inspections and how many can they do a week?
And what's the cost?
Well, we'll figure out the cost. I mean, if somebody's got to put some money in there, what? But if somebody's got to put some money in there, look, folks, here's where I'm at with this. And just how I am. I don't like people coming here telling me why you can't do something. Find a way to get it done, and then let's figure out the nuts and bolts to achieve the objective. Because I'm hearing a lot of sort of naysaying coming from both sides about why we can't do something. And that doesn't make any sense to me. All right. So you guys are looking to have this done by the 20th, which is a Tuesday. And let me ask you this, there would likely be, if you're trying to get everything done by that Tuesday, there would likely be inspections that would be happening that day, is what I'm thinking, right? So I don't, maybe the next day would likely be the 23rd, which is a Friday, but what do I have on that?
Let me run.
I mean, I could, if I, it's Friday.
Second grade. You're correct. There's 70 second grades this week on Friday.
Say again.
We have 70 second periods on Fridays.
Okay, so, but the 1 week. The 1 week adjournment from the 16th is gonna happen, but those have become second hearings. So here's my thought. And it's just a guess. Is, have we set 23rd first hearings done?
Yes. Yes, we have.
What do those blocks look like?
And 15 second hearings at 10 a.m.
No, those aren't second, those are first.
Yes, 15 first hearings at 10 a.m.
All right, so here's what we're gonna do. Set this on the 23rd at 11 a.m. Okay. And council, so that you know, I know we have a bit of a delay, but I'll set it at 11 a.m. on that day. Oh, that's not gonna work for Mr. Freedom.
Well, Your Honor, I finished.
Oh, okay, fantastic.
I
Okay.
got a certificate of completion.
Fantastic. Congratulations on that, my friend.
Thank you.
All right. So we'll set it on that day. Okay. And then that way we'll see, and I will just let council know you'll be here in person. I will have Zoom hearings going all over the place that morning, but I will try to get them out of the way and make it as least convenient for you as I possibly can and get you in and out. Okay.
I will be back. in town.
Pardon?
I will be back in town for live hearings.
Yeah, I'm seeing that nice sunny sky behind you.
Yep. It's real.
Okay. All right. Was there anything else from either side then?
No, Your Honor.
All right, thank you. You're gonna get that list to me.
Yes, I'm
We
gonna.
can see where we're gonna go. And I want an update sent to Ms. Weidling regarding that CES inspections.
Okay.
All right. Okay, thank you, folks.
Thank you.
14A stands in recess. Taking that picture. Not this one, but I'll make that switch. All right. Miss Linda. If I don't have a PD to do it. Well, hold on a second. Whose case is this? Oh, then I don't need the waiver at this point. We'll just have to make sure.
The prosecutor, Ms. Thomas, not here. All it's gonna be is
Who?
open circuit court. I'm looking for.
What, nobody's ready? Is that me?
Oh, we're ready, Judge. Just give me a second.
We're ready and now you're leaving.
I'm looking for.
So that was a no, they weren't ready. So, ready now?
Morning, Judge.
Good morning.
I apologize.
No, it's okay.
Fire.
What'd you say?
So I apologize, I was putting out a fire.
That's all right. That's all right. Court does call the case. People, state of Michigan versus Justine Cheatham.
Good morning, Honor Marie Council. Good
Good morning, Rob Jekyll on behalf of Destiny Cheatham, who's on Zoom, and we appreciate allowing her to be on Zoom. Destiny, would you state your name for the record, please?
Destiny Cheatham.
Do you have a camera, Destiny?
No, I don't. My screen is shattered.
Okay, I know her voice, Judge. That's her. What we'd like to do
Or
today.
either you're gonna waive.
Yes, Judge.
Does either party have an objection to her not having a camera?
No. Do you object to her not having a camera?
All right, very good. All right. It's gonna be a waiver.
Yes.
Ms. Cheatham,
Yes.
you understand that you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes,
You understand you'll not have that hearing today and you'll proceed to circuit court for further resolution.
yes,
People also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on a single count.
Judge, we acknowledge the information waive its reading. My client would stand mute.
Defendant having waived formal reading standing mute, court will enter not guilty. Pretrial will be set for July 8, 2025, 1:30, Judge Conkey.
Thanks, Judge. Judge, we do appreciate my client to appear by Zoom. Thank you.
No problem. Yes, 1 moment. Bond will continue in this matter.
Thank you, Your Honor.
Sir, we don't have an information.
I can look for. Yes, yeah.
Yeah, we'll get an information for you.
Oh, thank you.
Got a call from this fellow. It's a PD case.
No, sure.
This flap isn't gonna work. Well, the camera, I can flip the camera, I just haven't. And I gotta remember how to do it. Ann was supposed to have this all set, but she didn't. By the time you show up. I need to put a waiver on there. We were trying to do that hours ago. But, okay, well, hold on 1 moment, I'm gonna take care of Mr. Bird. Court does call the case, people versus Sean Odom.
And then we have people, Your Honor.
Good morning, Your Honor. Morning to the honorable staff. If you please, this court, Brandon Bird, PA 3734, on behalf of Sean Odom. Mr. Odom, can you please state your full name for the record?
Sean Martel Odom.
Thank you.
You welcome.
Preliminary examination. At this time, people are unable to proceed as to count 1, whereas at count 2, the added count 3 on the amended complaint be remanded to district court.
All right, as to the amended count 3, the domestic violence second offense, you waive formal reading of that charge, counsel, and your client pleads not guilty.
Yes, Your Honor.
All right.
Respectfully.
You need a copy of it?
Right, I never seen the amended complaint, Your Honor.
Today?
Yeah.
Oh, no, I'm kidding. Sure. Patience is my number one virtue. Let's see. Did you want me to pass it so you can go over that with your client?
Yeah, let me please.
Okay.
Your Honor.
So I'll pass the matter. We'll take him back, then you can go run and talk to your client. Oh, there you go. And why don't we put the waiver on the record if we could?
Good morning, Your Honor. As I said, on behalf of people, Your Honor, people will waive any potential conflict between this honorable court and the office of the public defender. While people don't believe this conflict exists, people make this waiver in avoidance of any.
Your Honor, Lauren Brown, Deputy Chief Public Defender, our office would likewise waive any potential conflicts. We do not believe such conflicts exist in this honorable court hearing these matters. If a conflict were to arise, we'd waive such conflicts so that this honorable court could hear these matters.
And the court for its part also does not believe there's conflict either in Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to either of those matters. We have nothing. Really? So no, we have nothing. I depend on you to keep us going.
Waiting to hear back.
So it's the other people that are causing the problem. Okay, just threw them right under the bus. What's Warren Green doing? Are you ready?
Very, very.
But you have.
So smooth.
Okay. Mr. Brown, you're looking very dapper, but you don't have anything ready either? It is. It really is. It really is.
Thank you very much. Thank you.
Yeah, very fashionable.
I'm not used to all these compliments.
Oh, don't worry. It's gonna last about 5 minutes and then we're back to normal. Miss Maggie, how are you?
I'm good, how are you?
I'm doing well. Wonderful.
So,
Okay, so finally, she's arrived, so things will get going.
well, we have some.
Miss Billy brings like what? All right, we're gonna turn this camera. Well. And I think they did it in. Well, here's the problem.
Do you want to take that?
Yes, something's gonna have to be done, but. Okay. Is it? No, it's got that thing. Okay. We'll. Oh, cutting it. It's. Oh, I know. Let's not say we did.
So this is just what would have ended anyway. Oh, I see. So you have to make
Oh. Were you all set or you ready to go? Okay. You're all set because Mr. Johnson just walked in, so that's trouble. I'm just saying, so everybody gonna get their things out of the way before he starts. All right, we're gonna bring him back. Don't talk to Warren Green. Court to recall the case. People versus Sean Odom.
Alexander, on behalf of the people, Your Honor.
Yes, Your Honor. Brandon Bird on behalf of Sean Odom. Mr. Odom, can you state your name for the record again?
Sean Martel Odom.
Thank you.
You're welcome.
All right.
Yes, Your Honor. We did get a chance to discuss this with my client. Understandable. We're gonna wait for formal reading, stay on mute.
All right. Court will enter not guilty plea as to that count 3. Maintain his plea of not guilty as to count 2. Count 1 will be dismissed. I'll set a pretrial on counts 2 and 3 for May 28, 2025, 9 a.m. That is Judge Perry at the 15th District Court on the misdemeanor charges. All right.
Permission to address bond, Your Honor.
Figured you would. Go ahead.
Respectfully, we got the misdemeanor today. It's the same complaining witness that's on this case. That just been dropped at the second. So I'm not sure really how far this case is gonna go, but that's something we'll see in district court. Essentially, my client has been in jail for since March.
About a month.
About a month. Roughly about a month now. Now it's pushed back almost 2 weeks, Your Honor, for 2 misdemeanors, which essentially could potentially be probationable for
You got
it's almost like it's almost like he'd be serving a sentence if he stays in jail too much longer. One of these is a 93-day misdemeanor. I understand the other one's up to a year. But respectfully, we're gonna ask for a personal bond in this matter. He understands no contact with the complaining witness. He doesn't want any contact with the complaining witness. My client doesn't want to be sitting in the jail cell like.
Well, he had a personal and then messed that up.
Understandable, Your Honor, but now we're dealing with a whole new set of situations in which my client's been sitting in jail for a month now, almost a month. And I'm pretty sure a month in jail gives you a lot of time to think about where you want to be and where you don't want to be, and how you operate.
Answer the people.
Go back to work. Severe concerns that he could file court orders. He did pick up that bond violation where he was in contact with the victim while out on bond and had another assault incident with her. In this case, he had an assault incident with her and her child, giving the child a black eye. I also think in 15 dealing with this same victim. So I don't believe he can keep himself from being in contact with her and her child, given the facts of this case and his previous history with numerous dismissed DVs and convictions on DV.
Anything else, Counsel?
Respectfully, Your Honor, my client went to the police station. He went to the police station and made a police report in Ann Arbor. That's one of the reasons for the contact.
Right, but here's what ended up happening. He had a personal bond. He didn't follow the conditions. He then came into custody, was arraigned, and the bond was set at where it is now. As a result of his failure to follow the conditions. And then that is even really outside of the other stuff that the prosecutor has indicated regarding the other contacts and other complaints that he has with the victim in the case. What I'm going to do is I'm going to deny your request to reduce his bond. You can take it up with Judge Perry, but at this point, I'll do it that way.
Thank you for hearing me out. Your Honor.
Oh, I'm sorry. Court called case People versus Jalen Kendrick.
Ailey Zend on behalf of the people, Your Honor.
Oh boy. Oh no.
Good morning, Your Honor. Student Attorney Kara Rosengren requesting to practice under Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Hannah Apple on behalf of Mr. Kendrick. Could you say your name?
Jalen Kendrick. So where are you from?
Me?
I know where he's from. I got all that information. I know where Apple's from. Yeah, you.
I attend Cooley Law School, Your Honor.
You do?
Yes.
Oh, a Michigander or you?
Yes.
What part?
I currently reside in Dexter, Your Honor.
So even in Washtenaw County, Michigan.
Yes, Your Honor.
Where are you originally from?
Oakland County, Holly, Michigan.
Yeah. Kind of blew it there. Okay. Where'd you go to undergrad?
Western Michigan.
So you just never left the state?
I actually lived in Chicago for 15 years, Your Honor, so.
Did you?
Mm-hmm.
Didn't like it?
Loved it, but came back for my husband's job.
Oh, he's to blame. All right. Permission to practice is granted. Welcome aboard.
Thank you.
Your Honor, today's date talks about preliminary examination. At this time, people are unable to proceed to count one. I would ask that count two be remanded to district court.
You're moving to dismiss count one.
Yes, Your Honor.
People being unable to proceed as to count one is dismissed. I'll maintain the defendant's not guilty plea as to count two. Pretrial in this matter will then be set for June 9th, 2025, 9 a.m. That is before Judge Washington. Thank you.
Thank you.
Bond will continue. Thank you. Court does call the case People versus Quinard Sanders.
Good morning, Your Honor. Alex Warren, Green on behalf of Mr. Sanders. State your name.
Quinard Sanders. I have a plea form in front of me.
Correct, Your Honor. We are going to be proceeding on a guilty plea. Mr. Sanders is currently executing a sentencing judge waiver and the advice of rights form for the court.
All right. Plea form indicates that the defendant will be pleading guilty to an added count two of attempted resisting and obstructing a one-year offense. On a successful plea to that charge, count one would be dismissed. There's further the agreement of no delayed or deferred sentencing. That's the court's full understanding of the agreement.
That's our understanding, Your Honor.
Is that correct, counsel? Yes, sir. All right, very good. May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name.
Woodrow Sanders. All right, sir, it is this court's understanding that you are going to be pleading guilty to the charge of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. Do you understand that, sir? Yes, sir. You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 1482 District Court. You understand that? Yes, sir. All right. Still wish to plead guilty? Yes, sir. And to that charge, how do you plead? Yes. Now, you understand that by pleading guilty, you'll not have a trial of any kind? Yes. You signed an advice of rights form, is that correct? Yes. Any question regarding any of those rights? No. Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form. Yes. You understand you're giving up your right to appeal of right? Yes. Are you on probation or parole? Parole. Has anybody promised you anything other than what's been stated here today on the record to get you to plea? Oh, yeah. Sorry? No. Has anybody threatened you or forced? No. You're doing this voluntarily? Yes, sir. Of your own free will? Yes. And because you believe that you're guilty of this offense? Yes, sir. On the date of December 17, 2024, at the location 500 West Cross Street, City of Ypsilanti, Washtenaw County, State of Michigan, did you come into contact with a police officer from the Ypsilanti Police Department? Yes, sir. What happened? He asked me to get in the car and I ran. I'm sorry? He asked me to get in the car and I ran.
May I have what, Your Honor?
Pardon?
May I
Yeah,
have
go ahead.
Mr. Sanders, you were approached by a uniformed officer on that date at that location, right?
Yes.
And that officer informed you that he was investigating a crime, right?
Yeah.
And you began walking away, right?
Yep.
And he told you to stop.
Yep.
And you ran. Okay. You knew he was a police officer, right?
Yes.
Okay. You don't dispute that he was acting pursuant to his lawful duties, do you?
Nope.
Okay. Your Honor, I believe that lays a factual basis.
There's a court complied with the court rule. Would it be proper to accept this defendant's plea?
Defense is satisfied.
The court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered in 1482 probation. Sentencing will be
May 28th at 10 a.m.
May 28, 2025, 10 a.m. before Judge Barr. Yeah. Bond will continue.
Thank you, Your Honor.
All right, thank you. Thank you, Mr. Sanders. Court does call the case of People versus Stephen Watson. Pardon?
Mr. Watson.
They got him. Oh, we gotta wait. We're ready in this matter, Your Honor.
Good morning, Your Honor. Katie Rismer speaking for people.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Stephen Watson. Mr. Watson, please state your name for the.
Stephen Watson. All right. What are we doing?
Your Honor, as the court is aware, this time is scheduled for preliminary examination for able to proceed this morning. I would anticipate a motion to dismiss the felony. I would be seeking a remand on misdemeanor, but I seek the court's guidance as well. It's charged as a DD first, and it should be a DD second. I apologize to the court and counsel that I do not have any conflict prepared, but I could move to add a count 3 of DD second or amend count 2, whatever the court's preference is.
Oh. Can we, Ms. Zenda is like an expert
I mean,
at getting, I know, at getting those amended complaints done. And so I think Ms. Zenda might help you out
I
there.
think she's doing the things right now.
Oh, is she? Okay, see? So what I will do then is, and should we do that? I mean, it's my case, so I'll remember, but should we do that as count 3 or just amending count 2? Count 2, we think will work. Okay. So we'll just amend count 2 to reflect into DB second.
Wonderful. Thank you.
And you're waiving reading on that?
Yes, sir.
And I'll just indicate that we'll maintain his plea to the amended count 2 in this matter of DB second. Count 1 would be dismissed as people are unable to proceed. I'll set a pretrial in this matter for
May 19th at 1 p.m.
May 19th, 2025, 1 p.m. That's before me.
Thank you. May we address the issue about?
Sure.
My client was out. He had difficulty, and I believe there were issues with positive drops, with positive testing. My client does have employment. He is hoping that the job is maintained for him, but he does not think it will be maintained for too much longer past today's date. The charge was the felony charge was dismissed because there is no complaining witness. I expect there will probably not be a complaining witness at the court date as well. Based on that, Your Honor, I'd ask that my client's bond be returned to its previous state. My client has indicated that he will follow all of the strictures of the court. He has learned the importance of not indulging in drug use during any time period. I'm just asking that he be allowed to have his bond reinstated. The time he has sat in has taught him a valuable lesson.
The problem is that he was testing positive. That's part of the problem. The other part of the problem is he was supposed to then start CCOP and he didn't appear.
I talked to the agent and working a lot of hours. Told me to come to court and signed up for the CLP or whatever, because I can do intensive outpatient treatment.
So, Your Honor, he did have contact. The problem was at the time he was working a lot of hours and he had gone past the time when he should have been reporting. He did speak to the agent. Agent told him to come to court and then he could start getting into the program then. It's not that he doesn't want to. It's not that he intentionally tried to avoid what needs to be done. He set priorities with working and maintaining himself and his family. And that priority, as it turns out, was the incorrect. He has learned then what the priority should be. And again, it's not like he didn't make contact at all. He did do that. He was working. He'd like to continue to maintain that employment.
Okay, I don't need a response from the people. I'm gonna, at this moment, deny your request. I'll look at it again come the 19th, since it's coming back before me. It's just less than 6 days from now. I'll take a look at it. I would like to see something that's gonna keep him on track, because if he continues to use, doesn't do anything, we're gonna be right back in the same boat. So
I'm not going to use. My job is at risk, and I'm with positive drops, and I can guarantee that. I'm just trying to get back to work. My job is.
I hear you.
Yeah, just like I really learned my lesson. Like, I understand like the importance of not dropping dirty and things like that. And I have learned my lesson. I don't need to be in here. If you give me a chance, I won't let you down. I'm really just trying to get back to work. And
how many times do you think I hear that?
A lot, Your Honor, a lot. And
so tell me what makes you different.
Because I got 6 kids. I got a lot of things going on, and I'm not a person that constantly gets in trouble. I'm done with the drug use. My system is clean, so you have no problems with that. So if I drop today, drop next week before I come to court, everything could come back the same. And you got my word on that. Like,
so if I were to let you out, if I change my mind and I were to let you out, you test dirty or don't follow anything,
I would do the time in jail. I'm not
gonna do it right anyway.
Yeah, but I'm not trying to do that. But what I'm saying is, I come back and plead guilty to everything. I'm just really trying to get back to work, and won't have no problems out of me after today.
You need to get yourself set up with some type of outpatient.
Yeah, and that's what I'm saying. If I go to community corrections today, I can sign up for the intensive outpatient treatment, so I can be able to get on the right track. But there will
tell you what, I'm going to at this moment deny your request. However, if council would contact community corrections, see what they need, I will consider an order to release him with some strict compliance in their program. See if they have something in place for you.
Okay. Please.
So I'm not saying no forever, but I'm going to need something that.
Thank you.
Thank you.
Thank you.
And after that,
You have to turn off center stage. Huh?
Yeah. Sorry.
Just walk in and start throwing things down? What? No, too easy. Not going to say anything. Welcome back. All right. So what are we doing? This one? Got it? Okay. Court calls case People versus Timothy Stevens.
And on behalf of the people, Your Honor.
Oh, you're back.
Student Attorney Kara Rosengren, on behalf of Mr. Stevens, Your Honor.
Stevens. Your name, sir? Timothy Stevens. Thank you.
In order to the concept of preliminary examination, at this time, the people are unable to proceed to counts 1 and 2, as that count 3 be remanded to the district court.
So you're moving to dismiss counts 1 and 2?
Yes, Your Honor.
Counts 1 and 2 are dismissed. I'll maintain the defendant's not guilty plea as to count 3. set a pretrial in this matter for
June 5th, before Judge Rush Hour.
June 10th?
Fifth.
5th, 2025, 10 a.m. I'm sorry. 10 a.m. before Judge Fresh Hour.
Thank you.
Yeah, on continue.
Thank you.
Thank you. She's a lot nicer than you, Apple. I just thought I'd throw that out there. She didn't give me a lot of argument about stuff. Isn't that true? No? What, man? It's so sick. No, she's really not. She's okay. That's it? That's all we have ready? What are all these people doing here?
Came to see you.
Is that what it is? Okay. Well, I guess I'll take a break and wait for more to get ready and then come back. She's leaving? Does she have to go with Apple? I like her better. Better? Well, okay, better may be the inappropriate word. Dismissal? Okay. Court does call the case, People versus Deborah Gilmore.
Katie Rosmerski for the people.
Yes, Your Honor, Brandon Bird on behalf of Deborah Gilmore. Ms. Gilmore, can you please state your full name for the record?
Deborah Gilmore.
Morning, Your Honor. People are unable to proceed at this point.
All right.
Respectfully request dismissal, Your Honor.
So I request a remand for this meeting.
All right. People being unable to proceed as to count one, that is dismissed. I'll maintain the not guilty plea as to count two. I'll set that for a pretrial on
June 9th at 9 a.m.
June 9th, 2025, 9 a.m.
Yes.
9 a.m. before Judge Wash.
Thank you, Judge.
Thank you, Bond. No continue. Thank you. That's it. Okay, then I'll stand in recess and you'll let me know when we're ready on other things. So court's in recess. All right. Okay. Oh, we got new equipment. I didn't know how to work it, so. Court does call the case, People versus Brandon G.
And is it on behalf of the people, Your Honor?
Assistant Public Defender Ben Dunaway on behalf of Mr. Gevers, who is standing to my right. Brandon, would you state your name for the record, please? Brandon Gevers. Your Honor. Yes, Your Honor.
So you're waiving your right to a preliminary examination?
Yes, sir.
You understand that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand that you'll not have that here. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on count one with two following.
Your Honor, we will waive the formal reading and stand mute.
Defendant having waived formal reading, standing mute. Both counts. Court will enter a not guilty plea. Pretrial will be set for July 17, 2025, 1:30. Judge Slay.
Your Honor, could I address Braun briefly?
He's out.
He's out, but he's on a tether, and the complaining witness apparently lives thousands of miles away. So I don't think the tether serves any purpose, and we'd ask the court to get off.
Your Honor, I just have concerns given the facts of this case. I'll leave it in the first discussion, but I just have concerns given the high value factors in this case of strangulation. But she does reside out of state, Your Honor.
They're not in any proximity to each other.
No.
At all. It's just a GPS location track.
I would ask for, speaking with the tether until tomorrow, she is in state today. So I would have concerns for safety while she's here, and ask if the tether be moved when she's back out of state.
His bond will continue. What I will do is I send an order. We'll remove the GPS tether effective Friday.
Yes, sir.
Correct.
Thank you. Thank you, Judge.
Thank you.
Court does call the case People versus Sierra McCoy Nobles.
Good morning, Your Honor. Edward Drukes on behalf of Sierra McCoy Nobles.
Your name, ma'am?
Yeah, I'm going over.
Thank you. It's a waiver.
That's correct, ma'am.
Ma'am, you're waiving your right to a preliminary examination?
Yes,
And you understand that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
yes,
You understand you'll not have that here. You'll proceed to circuit court for further resolution.
yes,
All right. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on counts 1, 2, and 3 with 4 following. Mr. Jurgens.
Your Honor, we acknowledge receipt of the information, stand mute, waive reading, and ask for pretrial date.
Defendant having waived from a reading, standing mute to all 4 counts. Court will enter a not guilty plea. Pretrial will be set for July 17, 2025, 1:30 before Judge Slay.
Thank you, Your Honor.
Bond will continue. The cases of the people versus Brandon Carter. Didn't mean to wake you. No.
All Brown Deputy from Public Defender King, on behalf of Mr. Brandon Carter, it has been discovered that Mr. Carter has been lodged at the Monroe County Jail.
Oh,
But he is unable to make this court date. He'd love to, but
so he's currently lodged there?
that is my understanding.
Is that also the people's understanding?
My officer in charge.
Okay, so do we know how long he will be there?
No, I do not have that information as of yet, Your Honor.
We don't.
All right, well, why don't I do this then? I'll find good cause to adjourn the preliminary examination. I can set it for the 3rd or the 24th of June, which would 24th. June 24th, 2025.
You don't have.
Then this is all messed up. Right? Oh, I can't. You're right.
Correct. You have the 17th in the afternoon.
I the 17th of,
Yes, of June, because of June.
oh,
Hang on, okay.
June 17th, 2025 at 12 noon.
Would the court consider just a nominal bond in the event if he were to be released, at least he wouldn't drift off into the ether because he wouldn't necessarily have notice of this date? Obviously, we will work to break him, but I don't know. He may get out of Monroe County Jail between now and June 17th.
Any response?
A very, very nominal bond, Your Honor. Like $10?
Brown, when have you ever known me to set a $10 bond? I think I did once. Still haven't seen that person. I'll set bond in both cases at 1,010%.
Thank you, Your Honor.
Thank you. Well, are we ready to go on something? Johnson's over there hiding in the corner. He's ready on this?
Yes.
He's over there hiding. That's not.
I'm not having, I'm just saying out your way.
What? Staying out my way? Why? I am one of the most enjoyable people I know. So why don't we, what we anticipate 3 witnesses on this one? Are the people ready to go on that?
I expect one witness on the phone.
You expect 1? Okay. And you had 1 or 2?
I have one, but Mr. Gaddy is off today, so he's not here.
Is he council approach? Versus Lawrence Buckner.
Andrew Childers appearing on behalf of the people, Your Honor. Good morning, please, Honorable Court, Kareem Johnson, on behalf of Mr. Buckner, approaching to my right.
preliminary examination?
Proceed to intend on calling one witness, and if you'll call the first witness.
You may.
We'll call Amy Hudson to the stand.
Is he on the phone again? Is he on his phone or no? Because you did that at the. Pardon? Council approach, please. Yeah, every sworn.
Raise your right hand. Do you solemnly swear to affirm the testimony you about to give to be the truth, the whole truth, and nothing but the truth, so God? See, state and spell your first and last name for the record.
My name is Amy, it's A-M-B-E, my last name is Hudson, G-E-S.
All right, you may inquire.
Thank you, Your Honor. And just one other matter. My officer in charge, Deputy Von Heath, is present in the courtroom. He's the only other witness I have present. I don't intend to call him, but he is present.
All right, good.
Ms. Hudson, directing your attention back to the date of April the 1st of this year, 2025, were you in this courthouse testifying in a preliminary examination on a different matter?
Yes.
Okay. And was that in this very courtroom, courtroom C?
Yes.
Okay. And who was the judge at the time? Judge Washington? Okay. And was the defendant in that case, based on your understanding, Ms. Hudson, Mr. Buckner?
Yes.
Is he present in the courtroom here today? Can you identify an article of clothing that he's wearing?
He's wearing.
Okay. Your Honor, may the record reflect in-court identification of the defendant?
Without objection, record shall so reflect.
And I don't want to get into the facts of that case, but you were some sort of witness in that criminal case. Was that a criminal case?
Yes.
Okay. And you were a witness in it?
Yes.
Okay. And had you testified before Judge Washington in that matter on the date of April 1st, 2025?
Yes.
Okay. At some point, were you done testifying?
Yes.
Okay. After you were done testifying, what did you do?
I went and sat back down while they called up the next witness.
Okay. Where did you sit down?
I sat about where I was sitting when I stood up today, maybe one right.
Okay. So we're making a transcription of this. So I'm going to have to be.
On the right-hand side, probably in the third row back.
You're pointing in the courtroom. So you remained in the courtroom?
Yes, remained.
Okay. So you sat down in what we would call the gallery of the courtroom from where you are sitting in the witness stand on the right-hand side. And you said about the third row back.
Third row back.
Okay. And you did that while another witness was testifying. Okay. And at some point in time, did that witness stop testifying?
Yes.
Okay. What happened after that witness stopped testifying?
The judge asked for some more information and then she called for a break.
Okay. The judge stood up to take a break? Okay. Is that a yes?
Yes.
Thank you. It's okay. And what happened when the judge stood up to take a break?
When they called the court for recess, he was on the left-hand side.
Who is he?
Left-hand side. He stood up. He was around two people that had already started to be in the row.
I'm going to just stop you right there. So you've said the left-hand side. That would be the left-hand side of the courtroom from where you are seated in the witness stand today.
Yes.
Okay. That would be the side that the defendants normally sit at?
Yes.
Okay. Where was the defendant seated?
He was in the first row back.
In the gallery?
In the gallery.
Okay, so he was not seated at counsel table?
No.
Okay. So the judge got off the bench and exited the courtroom?
Yes.
Okay.
Yeah, the judge, she did not exit the courtroom right away. She stood up, as they were calling. There was two people up front talking to her. And then when she got done speaking to them, that's what they called the recess. And he stood up.
He being the defendant?
The defendant, yeah. Went towards the middle. There was two people already going to go to exit. He waited until the sound went out.
Okay, when you say how do you know he waited until the sound went out?
Because he turned around and he looked. He stopped.
Objection, speculation.
I'm going to overrule the objection. I'm going to let her.
He stopped. He looked back. The minute
Hold on. Look back at
At the
Wait.
screen, he looked back at the screen to make sure the judge, to make sure that the judge.
I'm gonna just,
Okay.
I'll stop you there. We're gonna unpack this a little bit. And Judge, I understand the court's concern. So you observed the defendant. You said he stopped. Where did he physically stop?
In the middle.
In the middle aisle? Okay.
Yeah.
Was he in the middle of the aisle, close to what we would, the back door of the court?
He in the middle, like closer towards this side of it.
Your motion, the right side.
The right side.
Okay.
Yes.
But I'm asking you, distance-wise, was he in this area or was he in the back part of the?
No, he was closer towards
The front, okay. You are still, fair to say, you are still seated in the third row
still seated.
on the right, your right side of the courtroom,
Yes.
okay. When the defendant stopped, is he looking at you or is he looking somewhere else?
When he first stopped, he was looking like straight ahead.
Straight ahead.
And then he
And straight ahead toward, yeah,
towards the exit door.
towards the exit door?
Yes.
Okay,
And then when he stopped, he turned around and he looked.
and in what direction, when he turns around and looks, in what direction is he looking?
He's looking to see if the judge is.
I'm not, and so that's, I'm not asking you. You can testify to things that you see, things that you hear, things that you witness. You can't testify to what someone else is thinking.
Right.
Okay,
No, he
so,
turned in the direction as to where the judge stand is.
okay, so just so we're clear, the defendant was looking towards the back doors of the courtroom. He then turned around and is looking in the direction of where the bench and the TVs are.
Yes.
Okay.
Yes, the bench and the TV.
At some point, does he then turn back around to look towards the back door?
Yes, he does.
When did he do that?
The minute the screen started making that sound.
Like a white noise sound?
Yes.
Okay.
Yeah, like
And
it's no longer.
And I will direct your attention right. Okay, go ahead. I'll direct your attention right now. There are screens on in this courtroom. You see those?
Yes.
And they're depicting the court and yourself in the witness stand. Is that correct?
Yes.
Okay. Did the screens look like that when the okay. What did they look like if
They
you look?
were like, as if the cable went out, they were, there was nothing there. It said private.
Okay, it said private.
There's a black screen with private written in white.
Yeah,
Okay.
yes.
At that point, once the screens changed from showing the video of the courtroom to this private, what did the defendant do?
He walked on to the right-hand side, stopped to where I was sitting and, made verbal threats.
Okay, he said something to you?
Yes.
What did he say to you?
He called me.
I'm gonna stop you right there.
Yes.
Hold on a moment. You mentioned something and I just need to clarify this. You said that there was static.
Yes, sir.
What was that you're talking about?
There was no more pictures showing. It was just a like when you call up the lawyers to speak to you, the screen makes a noise. It makes it makes a noise. I don't know how to describe it. It's not a silent noise. It makes a noise to where it's not recording anymore. Do you want me to sit down so you can turn it off?
No.
Okay.
I'm pretty much here every day. I'm just trying to figure out what you're talking about. You're saying it made a noise.
Yes, the screen went blank, and it's not like it's crushing out a noise. Like there's a noise
Coming out of the speakers.
Yes, coming out of the speakers.
Was it a constant noise?
It started, and then I'll be honest, I don't know if it was or not.
Gotcha. Okay, just one other thing.
That's fine.
When you said Judge Washington was talking to two people,
Mhm.
Was she talking to two people in front of the bench or two
Yes.
people behind the bench?
No, 2 people in front.
So she was speaking to two people in front of the bench. All right. At the point at which she's doing that, can you hear that conversation?
No,
Okay, at the point at which she's doing that, do you hear anything in the courtroom?
no. I mean, I can hear people talk, but not up front. It just is what, people may be saying as they're sitting on the gallery.
Right, but do you hear anything else?
No,
Okay. And she had that conversation and then turned around and left.
yes, yep, they call.
At the point that that happened, what was on the screen?
Before, when she got done speaking to them,
Not as she's talking to them,
it's,
what's on the screen?
there's nothing on the screen. And then when she got done speaking, then the video came back up before they called recess.
And when you say the video came back up, the video like it is right now?
Yes, and it
Okay.
just showed her on the bench. There was no one on the stand.
Okay, go ahead.
So at some point, as we've discussed, the defendant then turns and is walking, now facing back towards the back door,
Yes.
which would also be in the direction that you are in relation to the defendant.
I think he's just recapping what she's saying, so I'll overrule it. Go ahead.
Yes,
Okay. And you had previously said the defendant said something to you.
Yeah.
What did he say to you?
he called me a lying bitch and told me that that he was gonna get even, he was gonna get me. The last thing he was gonna get
Did you to that?
me. No,
How did that statement by the defendant make you feel?
correct?
After he made that statement to you, where did the defendant go?
He turned around, looked back one more
And
time.
I'm going to stop you there just so we're clear. So at the time he's talking to you, is the defendant looking towards the back of the courtroom or the front of the courtroom?
He's looking he's looking at me.
Right.
At the accent.
Okay, so he's facing away from where the judge would sit.
Yes,
Okay. After he makes that statement, you said he turns around.
yes.
Okay. When he turns around, in what direction is he now facing?
He's facing back towards the front where the judge would be sitting for
Okay.
this area.
At the time he turns around, is the judge on the bench?
No,
Okay. If you recall, at the time he turns around, who would be on, and I'm motioning on the other side of the bar, who were there attorneys or people present?
yes,
Okay.
his lawyer was still on the left-hand side. You guys were still on the right-hand side.
You guys being someone from the prosecutor's office?
Yes. And there was one officer also on the right-hand side, and there was one officer sitting out in the gallery, like 2 up from me.
Okay. So the defendant makes a statement to you. He turns around and he's now facing back in the direction of where the judge would sit. And what happens next?
The minute he saw that his lawyer was coming out, he turned around and took out the exit door.
Okay.
So again, speculation of what my client saw.
Okay. I would agree. So his lawyer, what you saw, ma'am, was his lawyer starting to leave and then he left.
Yeah. The minute
That's
he
what
saw-
that's what you saw.
Yes.
Okay, thank you. I think that corrects it. That's what. Go ahead.
And did you remain seated in the gallery of the courtroom or did you exit the courtroom at that point?
I remained seated.
Okay. And at some point after this fact, did you bring what had happened to someone else's attention?
Yes.
And who was that?
It was one of the police officers.
One of the police officers present in the courtroom?
Yes.
Okay. After you made contact with the police officer, did you have any further interactions with the defendant, Mr. Buckner? Okay. Certainly not in the courtroom,
Right.
correct?
Right.
Okay. anything in the hallway of the courthouse?
No,
Okay.
no.
Mayor, one moment, Your Honor.
Ma'am. While you do that, ma'am, you said you were seated in the third row. How far in on that third row were you?
Right there where the gentleman is with the black sweatshirt.
So you were seated on the end
Yes.
toward the aisle.
Yes.
Okay.
I have no further questions, Judge. Thank you.
Cross-examination.
Okay, ma'am, so you were here to testify, and if you remember, was that in case number 25 FB 1106, if you know?
I have no idea.
Did you get a subpoena to come to court and testify in that
No.
case? In that case?
I did not get a subpoena.
Okay.
They asked me to come and testify.
Now, it's my understanding that you're indicating that you are
Picking
seated
him up. Picking him up.
in the gallery courtroom right here.
Wow. Okay, yeah, gotcha.
Is that correct?
Yes.
And you said that there's a member of law enforcement 2 rows up, sitting right here, where there's an individual with a sheriff's shirt.
Yes.
And your testimony to Mr. Buckner comes down the hall, the aisleway, stands at that same pew where the law enforcement officer was and issued a threat to you, which would have been within 15 feet of the law enforcement officer.
I never said that. I said he stopped at where I was sitting and said something to me. I never at any time said anything that he stopped where the police officer was sitting at the pew.
So when he stopped, he was at your row,
Yes.
but there was still a law enforcement officer 2 rows up.
Yes.
Was there other law enforcement officers in the courtroom like there are today?
One sitting up in the corner, up here on the right hand side, where the gentleman is with the glasses.
When any of, I'm sorry.
Sitting where?
The gentleman with the glasses over here?
Mr. Bird?
Yes. That's where the other.
Oh, on this side. On this side?
On this side.
On the right. Okay,
Yes.
go ahead. Go ahead, counsel.
When this statement was allegedly made, none of the law enforcement officers in the courtroom jumped up and said anything?
No.
Now, you indicated that after you testified, you stayed in the courtroom.
Yes.
Was there a sequestration order that, was there an order that you leave the courtroom after you finished testifying?
No.
Okay, so you heard the testimony after your testimony.
Yes.
Mr. Buckner's lawyer at the time challenged the accusations that you made regarding Mr. Buckner, correct?
In which case?
In the case you were there to testify about.
Your Honor, I would object to what that other lawyer did. That would be hearsay.
I'm not asking for
Well,
what,
she's asking, I'll overrule that. I mean, he's not asking what she said. He's just asking what her impression of what he did.
right.
So, go ahead.
His lawyer in the case you were there to testify on was challenging you on the assertions, allegations you made about Mr. Buckner.
For that case?
Yes.
Well, I mean, I don't know if he was challenging me, he was just questioning me as
Okay.
much as you are.
And there was another witness that came up to testify after your testimony, correct?
Yes,
You heard that witness's testimony.
yes,
You were there when the preliminary examination ended, correct?
yes.
That Judge Washington, found that there was no probable cause that Mr. Buckner committed a crime. Correct. Well, Your Honor, the relevance is they've charged my client with intimidating.
I'm going to overrule the objection.
Yep.
Go ahead.
Judge Washington found that there was no probable cause to believe that Mr. Buckner committed a crime after you testified, correct?
She also stated that it can be called back up if they get the proof that they need.
Okay, which is fair. All right. So after you made accusations about Mr. Buckner pointing guns at people, correct?
What does that have to do with this case?
Ma'am, I don't.
Answer the question, ma'am.
Yes, I did.
You made accusations that you saw him deliver crack from a great distance away? You didn't make the accusation? Did you make an accusation that you saw him point a gun at somebody?
Yes.
Okay. No further questions, y'all.
I have no redirect, Judge. Thank you.
All right. Ma'am, how long did it take you to report this to somebody?
Within minutes.
Where was Mr. Buckner when you reported this?
He had walked out of the courtroom
How long after he walked out of the courtroom did you report it?
within probably 2 minutes, if even that,
To whom?
to the police officer passing by.
Which police officer? Is that officer here today?
Yes,
Okay, and that's who you reported it to?
yes.
That interaction, and if you look back on the right-hand side where the gentleman seated in the black shirt is, you're saying that's where you were sitting.
Yes,
When Mr. Buckner came down the aisle, you'll notice that the back row is basically a handicap accessible row or a non-handicap accessible row. You see that where it extends out?
yes.
How close was Mr. Buckner to you when he's making these comments?
He was past where the gentleman is sitting with the black sweatshirt, and he was in between that row and the woman sitting right behind him. And he leaned back and
he leaned back.
He was, you know, yeah, turned his head back and spoke to me.
So because that's a little bit different than what you told me before, because you're saying that he was where the gentleman seated in the black
Right.
he was past him toward the door.
No, right, there's right where he's sitting, right there, at that spot right there. It's like there's a spot, you know, where you, not where you would enter, but where would be if you're standing beside. So closer towards the opening of the back row.
So he's standing closest to the opening of the back row.
Right, but he's beside where the gentleman is with the black section. And that's right.
But he's over on that side of the courtroom?
Yes,
So ma'am, are you telling me he's no longer in the middle aisle?
no, he crossed from the middle aisle to over to stand closer towards the right-hand side. He's no longer in the middle. He's standing like as if you're having a one-on-one private conversation with somebody.
And how loud were these comments you say he was making?
They were not very, I mean, other people were walking out of the courtroom. I could hear them, and it's not like he was screaming them. They were normal voices.
When you testified in the previous matter, was there a victim's advocate assigned to you?
Yes, there was a victim's advocate.
Okay, so after you testified, did you talk to that victim's advocate?
No. They asked me to just go sit into the courtroom.
I want to go back, ma'am. At the time that you say Mr. Buckner got up, what's on the screens in the courtroom?
The screen was still on where you could see where the judge was sitting. And then she called for a conference. And then the screen went blank. And then the screen went back up to where you could see where the judge was sitting, and then she called for a recess.
And then what happened to the screen when she called for a recess?
And then the screen went blank and said, you know, right, it didn't show any pictures, didn't show any people anymore.
Prior to the judge taking recess, was it Mr. Buckner's other case that was being heard, the case that you were there for?
That case had been heard, and then honestly, as the another case was heard, there was a witness, but I think he was sitting out in the galley, and I think that they had started to call for another case. Because I don't think that.
Had your case that you were there on, had it concluded at that point?
Yes, because he was sitting out in the galley.
Okay. So then my question is that case had concluded,
Yes.
the judge had made a ruling.
No, she had asked for some more information, and they had set it aside for a minute and was going to call it back up.
And so had they called another case?
Yes.
Was Mr. Buckner's attorney on that case?
No, he was sitting on the left side, where the gentleman is. He's behind the lawyer right now where the glasses is.
So he had moved back to the chair.
Yes.
But during Mr. Buckner's case, he was at the table with Mr. Buckner.
Yes.
From that period in time, that case ending until the judge took a recess, actually, how much time was there? Mr. Buckner, you said was in that first row, right?
Yes.
How far into that first row was he?
Like right on the end.
So he's right on the end, seated where I guess the young lady in the pink would be.
Yes, I'm sorry.
Sorry to use people as props, but that's where he was sitting?
Yes.
Okay, so he's sitting right behind his attorney.
Yes.
Okay. And then at some point he gets up
Yes.
and walks back. Were you the only witness that had testified in that previous case?
No, it was me and one police officer,
Okay.
but I was the only.
Where was the police officer that testified?
He was sitting over, on the right-hand side where the gentleman is with the glasses.
Did he testify before or after you?
After me.
He testified after you.
Yes.
Was there another witness then?
They stopped because the judge asked for information. So they were pausing it to see if they could collect the information that was needed to proceed with the case.
So just so I'm clear, you were the first witness to testify, right?
Yes,
The next witness was a police officer.
yes,
And all during that time, Mr. Buckner is at the table where approximately where he is right now.
yes,
Then at some point, there's a break. Mr. Buckner leaves the table and is seated in basically the first seat in the first row behind defense counsel.
yes,
Then another case is called,
yes.
right? And was it the attorneys? Was it the attorneys on that next case? Was that who the judge was talking to?
Yes. I don't know if it was I mean, it was someone from the state and then someone representing that person. So yes, that's who the judge was talking to.
They were the attorneys on the next case.
Yes,
Okay, and the judge spoke with them.
yes.
As the judge is speaking with them, what do you hear in the courtroom?
The noise coming from the speaker and
What noise?
the, whatever that noise is. I don't know how to describe it.
Okay.
But just so we can't hear what's being said up here at the level.
Okay, so you hear that.
Yes.
At the point that you hear that, where is Mr. Buckner?
Still seated.
Okay. The judge then leaves that session, gets up to walk out.
Right, but the screens turned back. When they went back towards their tables, the screens went back to where you could see the judge. And then they called recess.
All right. At the point that they call recess, where is Mr. Buckner?
That's when he stands up, goes towards the middle, of it, and then there's two people. He goes, and then that's when he stops. There's two people getting out like in the next row.
How many people were behind Mr. Buckner in the gala?
Honestly, I don't know.
How many people were in, was there a person sitting behind you?
I don't think so.
Was there a person next to you?
No.
Was there a person in front of you? Which would have been in the second aisle?
I don't. If there was, I think.
Didn't ask that. Do you know whether or not, okay, do you know whether there was a person 2 aisles up?
Yes.
Who
That's the
was,
police officer.
and how far over was the police officer? You're saying where the gentleman that just sat down in the blue tie would be? Mr. Warren
No,
Green, that's you.
further over. He's probably where the other officer is, if not closer towards.
So he's further over toward the wall.
Yes.
Is there anybody else in that row that you recall?
No.
Is there any, so where you are, you're saying there's nobody in your row?
Not that I remember, but I'm not that I remember.
Behind you, you're indicating that there's nobody behind you in that row.
Not that I remember.
In front of you, the row would be directly in front of you. There's nobody in that row that you recall.
Not in front of me, there was someone down.
There was what?
There was someone down closer towards like where the gentleman is with the blue tie. There was two people right there.
There were two people right there?
Yeah. They weren't towards the edge, they were like in the middle down.
When Mr. Buckner allegedly makes those comments, do they turn around?
I was not paying attention. I just put my head down and just let it happen.
Council, I know, council approach briefly. This is too much. There was a. All right, let's go get that first. So what I'm gonna do in this case is, and I talked with council, I'm gonna take a brief break. Get some information, get it to council, and then, continue the hearing after that.
May this witness be the court, obviously appropriate if the court wants to inquire based on reviewing the video.
Yeah, I don't want this witness excused at this point because I may have questions and the video also may give rise to questions from Mr. Johnson. All right. So we'll pause in this case. You may step down, ma'am. And I'll call you back up. And court's gonna take a brief recess. And I know people want to talk to me, but court's gonna take. Sure, yeah, but court take a brief recess.
All rise.
None of that was caught. All right. State of Michigan versus Lawrence Buckner.
Andrew Childers appearing on behalf of the people, Your Honor.
Good afternoon, Kareem Johnson, on behalf of Mr. Buckner.
All right. We had finished that witness. Do people have a motion?
And I guess just for clarification, I don't think we technically finished the witness.
That's true.
So if the court is satisfied, I have no further questions for that witness.
Okay.
No further questions, Your Honor.
All right. Very good.
We'll have no further witnesses if people address.
All right. Any witnesses for the defense?
No, Your Honor.
All right.
Your Honor, at this time, the people would move to bind the defendant over as charged on the one count of witness intimidation based on the testimony of our one witness. Obviously, the court has provided both myself and Mr. Johnson copies of the video. Because our county issued laptops don't have CD discs, wasn't able to watch it myself, but I know the court has watched it, and I trust the court's judgment in reviewing and will respect the court's decision in that. And so, thank you.
All right. Sure.
Your Honor, for the testimony, reasons stated on the record, through cross-examination, and video that I asked to be admitted as defense exhibit A. I'd ask the court to not bind this matter over.
All right. The court will admit without objection exhibit A. In this matter, the court was very specific in questioning Ms. Hudson with regard to where she was at particular times and the like to try to get a sense and feeling as to where Mr. Buckner would have been at any given time. The long and short of it is when I review the video, it is clear Mr. Buckner is not seated in the first seat. He's actually seated in the second row back. And he's sitting there. We can pick up Mr. Buckner and I'm looking at it. When I time what portions of the video, well, let me make this clear. There are points at which when the court goes into recess, there is no video. So in looking at it, best the court can as to the timing of when the events would have occurred, it is clear we see Mr. Buckner in the courtroom at a particular point. No doubt. He's in that second row sitting there. He's second row, basically second seat in. At the point at which Ms. Hudson indicates that this occurred, Mr. Buckner is not in the courtroom. And that doesn't mean that it may not have occurred at another point. However, the testimony that I have in this case, it couldn't have happened. Mr. Buckner would not have been in the courtroom at that point in time. So with that finding in the court having reviewed that, the court's going to find that there's no probable cause to bind this defendant over on this charge. These charges are dismissed. Thank you. Yeah, you don't want to take it and keep it?
No, sir.
Yes. Go over. It'll be entered in the system. We'll call over and make sure that just get over to community corrections.
I got to go to the other courthouse, and I got to be there too, so I can just walk across the street.
To do what?
Tether off.
Yeah, you can go over to community corrections. All right. If they give you a problem, tell them to call over to my court and we'll let them know. All right, thank you. For Mills. While we're bringing that out, let me have their case, Slandy's case, and the 11 o'clock.
Yes, I'm sorry.
I told him I'd call them. Hang on one second. Court does call the case of the people versus Jillian Carey.
After one of the people.
Good morning, Your Honor. Michael Bellotta, on behalf of Jillian Carey, who's present to be in court.
In this matter, record should reflect that a bench conference in this case, so.
That's correct, Your Honor. We spoke at length in chambers about this case and its potential alternative resolutions thereof. So we are requesting an adjournment to June 17th to allow for a time to explore those potential alternatives, as well as to have hopefully sufficient time to have expert witness Kevin Purvis testify.
Yes, that's correct, Your Honor.
All right. I will adjourn the preliminary examination then to June 17th, 2025. That's at 12 noon. All right.
Yes,
on that.
thank you, Your Honor.
All right. Thank you. Bond will continue. Thank you.
Yeah.
Court calls the case of the people versus 5A Mills, 3 cases.
Andrew Childers appearing on behalf of the people.
Good afternoon, Your Honor. Kevin Basan, P71061, on behalf of Mr. Patrick Mills, coming to the podium. Mr. Mills, please state your name for the record.
These are all going to be waivers.
That's correct, Judge.
All right. Mr. Mills, it's correct that you're waiving your right to have a preliminary examination in these matters?
Yes, sir.
All right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed. You understand that? Yes, sir. You understand you will not have that hearing and that you'll proceed to circuit court for further resolution of these matters?
Yes, sir.
People also waive their rights?
Yes, Your Honor. Thank you.
Preliminary examination having been waived, defendant is bound over to circuit court on all the felony counts with the misdemeanors following. Counsel, you acknowledge receipt of the information?
I do acknowledge receipt of information, Your Honor.
You waive their reading?
And we do waive a formal reading, Your Honor, this time.
And your client stands mute to
And
this.
stands mute, Judge, yes.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in these matters will be set.
June 2nd at 1:30 PM with Judge Simpson.
June 2nd, 2025, 1:30, Judge Hammoud.
And Judge, I know we just did waive the exam, Judge, but may I briefly address mine, Judge?
You may. Go.
So my client has been in custody since the arrest in this particular matter. I understand that these are serious charges, Judge, but I would also note that my client technically does not have a extensive or criminal history, Judge. His family is in court today. His bond right now is $500,000. Your Honor, I'm asking for a significant bond reduction. He's been unable to post bond. He was working prior to being incarcerated, Judge. His employment is definitely in jeopardy. Again, Judge, I know one of the charges is a capital offense. But, Your Honor, I'm asking the court to at least consider, if possible, Judge, a $100,000 bond in this particular case, Judge, as opposed to $500,000. I believe that that's still a significant bond to post. If he's able to.
How much did you say?
I'm asking for at least $100,000 as opposed to $500,000.
All right. I'm sorry, I interrupted.
Oh, and so Judge, I just think that that's still a significant bond to post if he's able to post it. But Judge, $500,000 is unattainable at this time, and I also believe that at this time it's excessive given the circumstances, John.
Yeah, the people respectfully request that the bond remains currently set. The most troubling is that there are two. There's an armed robbery, which is a capital offense that people were able to proceed today. We brought in the victim, the Marine Corps from North Carolina. He's president of the courtroom, and So that is obviously a capital offense. It did involve in that instance, the defendant in possession of a firearm. The oldest case involved a LAWNet investigation. It subsequently conducted a search warrant. The defendant was ultimately found in possession of distribution quantities of methamphetamine, firearms, as well as 3D printers, items used to make what are commonly called ghost guns, as well as clock switches to modify the guns. And then when the police went to arrest him on the older warrant, this was back about 6 weeks ago, the defendant attempted to flee, was in his vehicle, involved in a pursuit involving both the state police as well as Pittsfield Township Police Department, and was again found in possession of a Glock with a magazine and more controlled substances, and the search of that yielded other items associated with the modification of firearms for the ghost guns. All of that is both very troubling from a community safety standpoint, as well as the defendant's potential posing a flight risk. So I would ask the following things currently set.
Anything else?
Judge, even if the court would impose a tether, Your Honor, or house arrest, just the opportunity to at least post a bond in this case, the $500,000 is excessive. And again, Judge, with everything the prosecutor just mentioned, $100,000 cash bond is still a significant bond to post a stake in his bond that he wouldn't not comply or be a danger to the community or be a safety risk in any way, shape, or form, Judge.
Well, I would consider the defendant to be a safety risk given at least the allegations that are contained in the as represented by the people in this case. I think that given all of the circumstances, this bond is set appropriately. I will deny the request for a bond modification in this case. You can take it up before Judge Booth.
All right, thank you, Judge.
Thank you. Court calls case of the people versus Julian Tabron.
Thank you, Your Honor. Alex Warren Green on behalf of Mr. Tabron. Mr. Tabron, state your name.
Julian Tabron.
Sure. I have in this case a plea form that indicates that the defendant will be pleading no contest to an added count 4 of larceny 200 to 1,000, the 1-year offense, and also an added count 5 of breaking and entering illegal entry, a 90-day offense. Upon a successful guilty plea to counts or no contest pleas to counts 4 and 5, counts 1, 2, and 3 would then be dismissed. That's the court's full understanding of the agreement.
It's our full understanding, Your Honor.
Yes, sir.
All right, very good. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony about to be the truth, nothing but the truth, so help you God?
Yes.
State your name.
Julian Tabron.
Put your hand down. Sir, it is this court's understanding that you're going to plead no contest to 2 charges. Is that your understanding?
Yes.
First of all, it's this court's understanding you're going to plead no contest to the charge of larceny 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased if 3 times the value of the property taken. If that's greater than 2,000 maximum fine. You understand that?
Yes, Your Honor.
The other charge is the charge of breaking and entering illegal entry. That's a misdemeanor punishable by up to 90 days jail, $500 fine plus court costs. You understand that?
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes, Your Honor.
2 things about it. I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest these charges. You understand that?
Yes, Your Honor.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
Mr. Warren Green, the basis for the no contest plea.
Potential civil liability, Your Honor.
All right. Sir, to the charge of larceny, 200 to 1,000, how do you plead?
No contest.
To the charge of breaking and entering, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form?
Yes.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights of that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No. No, no.
Has anybody promised you anything other than what's been stated here today on the record to get you to pay?
No,
Anybody threaten you or coerce?
no, Your Honor.
You're doing this voluntarily
Yes,
of your own free will?
yes.
All right. Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 25395. Any objection to the court having reviewed that report?
None from the defense.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine a defendant's guilt of this offense. Counsel, have I complied with the court rule and would it be proper to accept this defendant's plea?
Yes, Your Honor, there is an additional agreement that I failed to mention earlier. As it relates to restitution, the defense would stipulate to restitution up to the amount of $7,030. Your Honor, there's outstanding property that is going to be returned. We have agreed with the prosecution that property will be returned to the Pittsfield Police Department so that it can make its way back to the owner. And restitution may reduce from that point, but at this point we stipulate up to the $7,030.
That's a correct statement?
Yes, sir.
All right, just since it's coming to me, I just want to make sure I understand this. The maximum amount is the $730. $7,030. As property is returned, that somehow is going to be evaluated and it will come off of that amount.
The laptop, if it's returned, with lower that.
Pardon?
I said if the laptop is returned, it's lower that.
The laptop is valued at about $1,000, Your Honor, so we anticipate that the people's request will modify to $6,030.
Got it. Okay, so it will not, okay. I just want to make sure I'm clear. It will not go below $6,030, but it won't go higher than the $7,030.
That's our understanding, Your Honor.
With that, all right, so let me. Okay, have I complied with the court ruling?
Yeah.
The defense is satisfied.
Court will accept the defendant's no contest pleas. Counts 4 and 5, counts 1, 2, and 3 are dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be
June 11th.
June 11th, 2025, 9 a.m. That's before me. Bond in this matter will continue. Thank you. All right, Mr. Cabron, on your way out of the courthouse, on the left-hand side will be my probation department. You can stop in there to start the process. All right? Okay, thank you.
Thank you, Your Honor.
You know, the cameras, yeah, it's gonna have to be flatter somehow, but, the problem is that the camera's at the top, not the side.
So my understanding is we're down to the last 3 defendants and we're holding on all.
Only on all of them? See his phone?
He's part of the problem.
Okay. Thought I'd ask. Okay, who else is?
So this is Ms. Senda and Mr. Bird. We also have Ms. Zelkovich. The other 2, Ms. Douglas and Mr. Brown, and
Miss Douglas and Mr. Brown?
yes.
Oh, that's gonna be funny. No, I'm kidding. All right, well,
And then Ms. Douglas and Mr. Warren.
seems to be a common problem here, Miss Douglas. No. All right, let's,
Mr. Bird.
is Miss Adara? Oh, there she is. All right, let's do that. Get counsel out. How many witnesses?
We need 2 on the R&O file, 1 on the home station.
Got it. Court does call the cases of the people versus Devon Gibson.
Ally Zinn on behalf of the people, Your Honor.
Yes, Your Honor, please examine the court again. Brandon Bird on behalf of Devon Gibson. Gibson, can you please state your full name for the record? David Gibson.
All right, thank you. All right, there are two cases here, set for preliminary examination. We're ready to proceed.
Yes, Your Honor. And at this time, the people will be withdrawing their motions for forfeiture by wrongdoing and would be ready to proceed.
All right, very good.
I'm ready to proceed, Your Honor. I do think it's a little preliminary matter that you might want to discuss before taking the record. We won't have, the only complaining witnesses that we have is police, and the people did make me aware that they were trying to introduce a couple 911 calls. So I believe.
Could we approach, Your Honor?
911 calls on what?
Could we approach, Your Honor?
Counsel, you may want to, while you're talking to your client, press the button on that, and you gotta hold it down, because it's gotta be green, so we can't hear you.
Just hold it. Great job.
You ready?
I still relate to the 911 calls in.
All right, very good. All right. Ready to proceed on this? You may proceed.
Thank you, Your Honor. We start with the case. Name is 1110.
Yes, sir. Yes, ma'am.
Thank you, Your Honor. The people would first call Deputy Gerwig to the stand, Your Honor.
Sir, please come forward and be sworn.
If they see, raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so. State and spell your first and last name for the record, please.
Deputy Brian, you're a liar.
Good afternoon. Deputy Gerwig, what do you do for a living? And how long have you been employed there?
3 years this year.
And I'd like to direct your attention to March 14th of 2025. Were you working that day? What shift? And were you in a marked patrol car? And were you in uniform? And on that date, were you dispatched to the area of 8517 Cargo Drive? And is that in Ypsilanti, Washtenaw County, Michigan?
Yep.
And what was the nature of that dispatch?
It came out as a domestic incident. Caller was third party with the father of a female, saying that his daughter and her boyfriend were getting into the apartment.
Okay. And did you come into contact with anyone on scene? Who?
The caller, well, I identified his caller as, his friend.
Okay. And how did he appear to you?
He was upset, visually upset. He did have blood on his forearm.
Okay. And did he want to report an incident to you? And when did this incident occur in relation to the statement he gave to you?
Just almost before, probably 5 to 10.
Okay. And was there anyone else in the residence at this time?
At the time.
Okay. And you said a 911 call was placed?
Correct.
And do you recognize this? And what's contained on this flash drive? And did you review the contents of the flash drive before this hearing? Okay. And did you recognize a voice on that call? Whose voice was it? Your Honor, the people would move to admit People's Proposed Exhibit 1.
The objection or voir dire, I think by stipulation here.
Okay.
All right. Exhibit 1 is admitted.
Thank you, Your Honor. Can I plug it in?
Yep.
Okay. Oh, man.
And what's happening?
I think you should go.
I don't even have a phone on with your daughter. What's going on with your daughter?
Maybe you should be.
Is it an apartment number two or is that a house?
No, that's the address, townhouse.
And when you say she's into it, is it somebody arguing?
But, yeah. Yes, I'm telling you, though, one of them, because I'm running all over me.
Okay, hold on, has somebody that's physically assaulted? They did each other? And do they need an ambulance?
No, they can't hear me because it's still fighting my house.
Has anybody been seen or treated today?
What's
What's your name? We've got the phone in, okay? Where are they now? Where are they now? What is the male name? How do you spell that last name? Almost getting them out of the way. Let it just G-I-V-S-O-N. What's his first name? Spell that for me. I don't know how old he is. Say that again.
What you do because when you have a call, I told them you go.
What, are they on foot or do they have a car?
They're in the car.
What kind of car?
It's brown apple.
Okay, don't on foot?
Yes.
What's he wearing?
Black shoes, black wings, and black and
Black and white shoes?
yes.
And you got with him?
Yes, yes, as soon as you on time, I can do this.
And what did he wear?
Booties, a gray shirt.
Gray t-shirt.
Gray t-shirt. What's wrong with this one?
And she have a lot of speculation. Her name? Spell that last
P-R-I-A-T-E.
Okay. Do you know which way they headed or where they're going?
I can't get the dog. So, from the dog, come back, I'll be in the office.
Well, lock up the dog before police get there.
I'll be there. I just can't do it anymore. Go back to the dog, he can come in. I'm just kidding. I can't do it. I can't do it. You don't make a mistake. I can't do it.
Do you want us to have answers for your daughter?
Yeah, you don't know. Because pick and pick her up, because pick her up and she fell like that.
Are you got everybody to when they come back or they change their or they get their like the total for their
So going back, you said Lucius wanted to report an incident. What incident did he want to report?
The assault between his daughter and Kevin.
And what did he say happened?
So Kevin picked her up, slammed her in her head.
Here, so.
In your it's a present sense impression of what he just saw happen after police got there.
Better go loud in. Go ahead.
So he reported, what did he want to report?
Her assault with his daughter and her boyfriend.
And what did he say happened?
That his daughter was sent his boyfriend and picked her up and slammed her on the head in the apartment.
And did he say anything else happened?
That they got into it, that he was, he tried to break them off.
And did he say what happened to Lucinda after she was slammed to the floor?
Said she lost consciousness. She was just laying there.
Okay. And when you arrived at 8517 Cargo Drive, did you take any photos of the scene? Your Honor, may I approach the witness of people's proposed exhibits? I guess I have to change these. 2 through 4.
Yes, you may. Let me just ask this, officer. When you arrived there, who were you speaking?
I'm Caesar.
Pardon?
I was talking to the father, Evan's girlfriend's father. Yes.
All right.
The person I called.
And how did he appear at the time that you?
He was distraught, upset.
All right.
Trying to tell us what was going on. He had some, appeared to be what on his arms.
All right. And that was approximately, I think you said 5 to 10 minutes after the incident had occurred. All right. So just so the record is clear, I'm allowing it either of the present sense impression or as an excited utterance, and that he was under the stress of the situation at the time. So go ahead, Coach.
And may I approach the witness?
You may.
And what did I just hand you?
Picture of the scene of the residence that I took.
And are these a fair and accurate representation of the scene as you observed it on March 14th?
Right.
Your Honor, the people move to admit exhibits 2 through 4.
Any objection or voir dire?
Oh, objection.
Exhibits 2 through 4, 2, 3, and 4.
Correct, Your Honor.
2, 3, and 4 are admitted.
And may we publish them to the court, Your Honor?
Yes, sir. Okay. Thank you, sir. Go ahead.
And do you know Devin Gibson? Is he in the courtroom today?
Yeah.
Can you briefly describe where he's sitting and something he's wearing?
Sitting left, to the right of you, wearing an orange.
And Your Honor, please let the record reflect that this witness has made an in-court identification of the defendant.
Record shows so reflects that objection.
So during that same shift, at some point, did you find yourself at 8695 Spinnaker Way? And how did you come to be at that address?
A separate caller, in no relation to the original call we were on, saying that there was male and female in the locker room that's arguing.
Okay. And what happened when you got to that address?
We made contact with later that Devin and was sent out.
Okay. And did you interact with Devin when you arrived on scene? And did additional deputies arrive on scene? What other deputies?
Deputy Russell, Sergeant Howe, Deputy Hill.
Okay. And what interaction did you have with the defendant when you arrived?
He was not educated. He was in the line with, who was active.
Okay. And did you take any action toward the defendant at this point? What action did you take?
And it was an attempt to detain him pending further investigation.
Okay. And at this time, were you wearing a department issued body worn camera? And was it activated in recording? And do you recognize this?
Yes.
What is this?
This is
And is this a fair and accurate representation of what you saw that day?
yes.
Your Honor, people would move to admit people's proposed exhibits. It's 2 clips from the body camera. I believe 5 and 6.
Any objection or voir dire? Exhibits 5 and 6 are admitted.
Thank you, Your Honor. May we publish to the court?
Yes.
And then I just put her ass on, bro. I was like, oh, they all over the baseball, bro. And all over the first quarter, bro. I put it in my six pack, bro. Take them all, bro. Bro, I'm not this shit right there, bro. No, Y'all put me straight, y'all put me straight, bro. I was in the city, jump my house or finger off, bro. I was in the city, I'm gonna watch her finger off. Why don't you treat me like this, bro? Why don't you treat me like this, bro? Why don't you treat me like this, bro? Why do I do me like this, bro? I need better for this, I'll make fun of them. Why do I work like this, bro? Why?
So after you arrested the defendant, what did you do next? And then what happened next?
He began to kick the back passenger door.
Where were you taking him once he was put in the patrol car?
Bill.
Okay, and so what happened when he was being transported?
He kept kicking the back window. Once he kept asking him what his charges were gonna be. We advised him that one of the charges was gonna be property in the vehicle because he on scene of Spinnaker, he kicked the door so hard, he bent the door off his frame. Once he was advised of that, he said that if he's going to jail for damaging property, he's gonna damage property and kick out the back.
Okay, and at this time that this occurred, was your in-car camera on at the time? And it was on and activated? And do you recognize this video? What is this?
Our cameras of the years.
And is this a fair and accurate representation of the video that your in-car camera recorded of your patrol vehicle?
Yes.
Your Honor, people would move to admit people's proposed exhibits. I'm sorry, I think I lost count. Were we at
We did seven.
7, 8, 9, 10, 11, and 12?
Okay.
And these would also be in clips, Your Honor.
7, 8, 9, 10, 11, and 12 are.
Thank you, Your Honor.
That's shit weird, bro. That's weird as fuck, bro. Y'all gotta clean that shit. I want that shit on with you, I think, too. Real shit. That shit weird as fuck, bro. Don't you walk in, put a whole blood on my face, bro, and all this, take me to jail for a fucking empty on me, bro? God said, for one of them, so for the domestic violence, for one of them, resisting arrest, so you wanna, hold on, man, y'all, y'all don't keep up, bro. And you try to bitch, you kick bitch, I know why you don't like me, because you used to cut off my off, and you're a fucking chick, man. You're a fucking chick, man. You're weird, nigga. But you was the main one twisting my arm and doing that lame ass shit. But y'all don't proceed to fuck with all that shit, bro. Without that ass, something wrong, bro. Hold on, fucking again, bro. That's it, right in the shit, bro. And I gotta, yeah. Let's go get the fuck away, I'm fucked up. Stop weird ass shit, bro. I'm still putting on my, and I got no medical for shit. Oh. For the DOP? I'll say, do I have the DOP on you? So I got it, right? Yes or no? The DOP. Yes, I know somebody was right out the window there, right? Right? I'll choke. See, why y'all wanna do stuff like that to me, bro? Why y'all wanna do? We know I'm gonna jump out. I'm jumping out. I'm jumping out. Yeah, nigga. Yeah, nigga. Why y'all wanna do that to me? Why y'all wanna do that to me, no? Why y'all wanna do that? I'm swinging out. Yeah, nigga. Y'all weird as fuck.
And your apologies, it would be, the last one would be exhibit 11, not 12.
11.
Correct. So after this, was your patrol car damaged?
Yes.
Did you get an estimate for the cost of those damages? About how much was that estimate? And did you provide this estimate to the people? Your Honor, may I approach the witness of People's Proposed Exhibit 12?
12. Any objection to 12?
Oh, Judge.
12 is admitted.
And may we publish that to the court, Your Honor?
Yes, sir. Got you calling up.
Your Honor, may I have a moment?
You may.
Thank you. Nothing further from the people.
Cross-examination.
Officer Gerwig,
Yes, sir.
you said Mr. Printup told you that what did Mr. Printup tell you again?
I've seen
When you came on the scene to talk to him?
that his daughter, sorry, the names are real close together. His daughter Lucinda and her boyfriend Devin got into us all.
You said he told you they picked you up and slammed him too, right? Why didn't you put that in your report? Would you like to refresh your memory?
Yeah, I've had it in there.
You say
I said, if you're asking me about it, I'd take it from that in there.
it's not. So why didn't you put it in your report if that's what he told you? That seems like a pretty big detail.
He told this. Or he talked to my partner.
So basically, what he told you was they both were fighting, correct?
Right.
And he never told you who started it, correct? He never, he never said, was my client trying to protect himself or was he the aggressor, correct? You knew there was blood, but you didn't know where it came from. He never said that the blood came from his daughter. But that was the assumption, correct? Now, when you came on the scene where Devin was, how many officers were there already?
The second.
Second.
Not the where his dad was, the one.
Right.
Second call.
Second call.
Everybody that was already showed up on the first one, so. Okay, 4 after me.
It was 4 after you
I believe so.
or 4 before you?
After, well, what?
With you. Okay, so you were one of the first on the scene. And was Lucinda there when you came?
Which time? Initial,
To arrest Devin?
I believe that was her.
You believe that was her? So you want to know who Lucinda was if you seen?
Not at the first time, no.
Got you.
After the investigation,
And how many times have you met Lucinda and Lucius? Print up.
my partner has,
How many times have you met them?
have I met them once before?
You say once before?
Possibly, yes.
When's the last time you talked to Mr. Printup, Lucius Printup?
For this,
Before this court date?
I haven't.
You haven't? When was the last time you talked to him before you were on the scene with him? Before you pulled up on the scene to talk to Mr. Lucius to investigate the situation before you went to go arrest Debbie? When was the last time that you talked to Mr. Printup? You said once before that, correct?
Correct.
When?
Said I did.
I said when? When was the last time? When was, you don't understand the time, you don't understand the time frame? I'm asking you, you said, this is what I'm trying to get to. How long have you known Mr. Printup? Because you said you remember his voice. You said you would know his voice.
From the phone call and speaking.
From the phone call and speakers. How would you know his voice from the phone call and speakers from something that happened a month ago? How many other people have you arrested?
Everything I know his voice, which I just told you from the scene, I know his voice from phone calls.
So you got that good of a memory?
I want to talk to him on the scene, and hear a phone call, then it would be correct, yes.
Gotcha. But you forgot to put the body slam in the report.
A question or?
I'm sorry, young. I'm sorry. That was commentary, young.
Okay, I don't need it.
I know, and I apologize. Now, when you came on the scene, were you all trying to arrest them? Was it a collaborative effort of all the officers there? Yep, to arrest my client.
Or just contained.
When you did arrest them, was there, right?
Well, that are resisting us, that, yes, all of us did.
Did he assault any officers individually? Did he assault you individually? Did he resist you individually, or were all the officers being resisted?
Resisted my partner.
So he was resisting the collaborative effort that you all were using to try and arrest him. Would that be a correct, accurate statement? Did he ever assault you? I do understand, he did say a negative comment. He did say a negative comment to you.
About my agent descent, that's correct.
He did, and which is reprehensible. But did he ever threaten you because of your age and descent?
Oh, my agent descent? No, he never.
Did he ever, threaten to damage any property you had because of your age and descent? So it basically was a statement, out of my client's anger and the excitement of the situation.
A very derogatory statement. Yes.
No, very derogatory. And I'm not gonna take that fact from you, I'm sorry that happened.
I get what you're saying, yes, there was nothing in relation between, he's saying he's damaged anything of mine because of my age and descent. No.
Got you. All right, no further questions, John.
All right, anything else?
I have one moment, Your Honor.
Right.
Just for the people, Your Honor.
All right, you may step down. Thank you. Oh, your next word.
Thank you, Your Honor. People called Deputy Samaha, Your Honor.
Please come forward and be sworn.
Raise your right hand. Solemnly swear to affirm. State spell your first and last name correctly.
First name, Deputy Samaha, spelled D-E-E-N-A, last name spelled S-A-M-A-H.
Give me that again. I'm sorry.
My last name?
Yes, please.
sir. S-A-M-A-H-A.
That was easy. All right. All right, go ahead.
Thank you, Your Honor. Deputy Samaha, what do you do for a living? I work in the Washington County Sheriff's Office.
And how long have you been employed there?
For over 2 years now.
Okay, I'd like to direct your attention to March 14th of 2025. On that date, were you working?
I was.
What shift?
The name check.
And were you in a marked patrol car that day?
I was.
Were you in uniform?
I was.
And during that shift, did you find yourself at 8695 Spinnaker Way?
I did.
And how did you come to be at that address?
The call came out and deputies Hill and Berwick were responding to that address. And I started making my way over there just to back them up.
Okay. And did you come into contact with anyone at that address?
Not at that address, Deputy Berwick at the time gave us the description of the two, male and female, and we went to BOL, which is pretty much still for them in the area.
Okay. And did you find anyone matching those descriptions?
I did.
Okay. And when you went to 8695 Spinnaker Way, was there anyone you came into contact with there?
No.
Okay. And when you say Lucinda, who's Lucinda?
So initially when I arrived there, she was, from my knowledge, the victim at the time. She was bleeding from her finger. I had no context whatsoever at that time. I just made my way back to the laundry room where she was, and she was like washing her hands.
Okay. And how did she appear to you?
She was definitely in distress, hysterical, kind of all over the place.
Okay. And what did you do after coming into contact with Lucinda?
I escorted her out of the building and towards my patrol vehicle.
Okay. And when you got to your patrol vehicle, how did she appear then?
She was bleeding from the finger, so we tried to clean her up. Essentially, she was able to carry her own body weight. Then she just kind of started going in and out of consciousness on me. At that time, I had her sit in the back of my patrol vehicle. I had my door open. She was not coherent, was not able to give me any statement. And she, again, just could not carry her own body weight. So at that time, my priority was to stabilize her head so she wouldn't hit it.
Okay. And what happened after that?
We requested HVA and they arrived and they disposed.
Okay. Nothing further for this witness, Your Honor.
Cross-examination.
I'm sorry, so, how do I pronounce your name? So I get it. Samaha. Nice to meet you.
S-A-M-A. Okay. I got that. Go ahead.
Oh, no, I was about to ask that question. Now, how many officers were there by the time you got to the scene?
When I arrived, there were 4, possibly 5, if I remember correctly.
Got you. And okay. Did you interact with both Mr. Gibson and Miss Printup or just Miss Printup?
Just Ms. Printup, sir.
You never seen Mr. Gibson put his hands on Miss Printup?
No, sir. So I arrived after the fact. I was not there, no.
And you say she was in a hysterical state? Did she ever tell you, that my client put his hands on you?
She did not give me a statement, no, sir.
She didn't give you any statement? Did she tell you that he didn't do it? He didn't do anything?
So from what I can recall properly, she did not give me any statement at all. Again, she was kind of in that state of going in and out of consciousness, so I just stopped questioning. We didn't get any further, no statement, no questioning. It was just kind of making sure that she did not hit her head at that point.
Did you see any injuries on her head?
Not on her head, no.
The only injury you seen was on her finger.
She was.
So, is it safe to say you don't know why she was feeling the way she felt, or?
That is correct. I could not tell you what she felt the way that she felt.
All right, thank you. No further questions, Dan.
Any redirect?
No, Your Honor.
All right, thank you, Dan.
Thank you, Your Honor. No further witnesses for the people, Your Honor.
Right. Witnesses, all right.
Next one.
Well, what do you want to do?
Well,
Well, what do you tell me?
all right, we'll do this.
No, you don't tell me. Go ahead, do the next case.
Do the next case?
Want to do the bind over on this one?
Please.
Go ahead.
Okay, Your Honor, at this time, the people would motion for bind over. The court heard testimony from Deputy Gerwig saying that when she's reported an incident where the defendant slammed the victim onto the ground, making her hit her head and lose consciousness. The court further heard from Deputy Strong that after this event, she had a cut and also was unable to hold up her own body weight, hold up her head, was incoherent from this injury that she sustained from the defendant. The court further saw body cam footage as well as the in-car footage of the defendant resisting the arrest of the officers, refusing to put his hands behind his back, 10 seconds away, refusing to walk to the car, fighting with officers while he was being arrested. The court also saw in the car the defendant spit on the car multiple times, as well as kicking out the window and causing extensive damage, over $2,000 to that patrol car. So I believe we have met the burden of probable cause in this case and to ask the court to bind over.
Response.
Respectfully, Your Honor, when it comes to the assault with intent to great bodily harm, domestic violence, my client, first of all, we don't have any witness to witness it. The only thing we have is tape and the officer statements and the officer statement and the 911 tape in which you could hear him clearly say they both are fighting. We don't know who was the aggressor in that situation. Unfortunately, I can't cross-examine anybody to find out what was going on. We do hear on the phone where he said, he picked her up, my client, picked this print up and slammed her, but we don't know what that means. I can't cross-examine him and say, how was that? Was she trying to hit him? Did he grab her? And that happened. Was it in self-defense? We don't have any of that in front of us, y'all. Respectfully, when it comes to the resisting obstructing police officer, I think we got one resisting obstructing for the most part. In Michigan case law, it has to be an individualized attack on each officer when they charge it in different counts. In this case, this was one situation which a group of officers were attempting to arrest my client. It's not like he kicked one officer, punched another officer. It was one big, and I wouldn't even say it was assault. It wouldn't even go to the assault part, more the resisting part. He was potentially resisting arrest. He was actually frightened, and I wouldn't even call it resisting arrest. He was just frightened. But if we're gonna call it that, he was frightened arrest from multiple officers at the same time. So I would just say that wouldn't be against four different officers. Is one.
You have that case law?
I do, Jan. I'm glad you asked.
All right.
Give me 1 second. I did a lot of research on this case.
Okay. Only does you good if you can find it.
Say,
Nothing. Yeah.
oh, no, it's there. I wouldn't lie. I wouldn't present.
No, I know. I'm just asking, you need to show it to me.
I know that's right. We do got, is there internet I got on in here?
Pardon?
I need my internet to work.
No. I don't know, mine's working, so. You can't, there's a public access, you should be able to access it.
Hard to put it on. Usually I got cellular data. But my internet's not working. My cellular data's not working.
Did you get your internet?
I did, yeah.
Okay, good.
I'm looking for it. I guarantee you I got case now.
Okay.
If you go to people rewards, 314 mishap,
314 mishap.
399, 2016.
And what's it say?
It says, the holding is multiple counts of resisting obstructing where appropriate, where the defendant committed distinct acts against multiple officers. Let me see, first two convictions where the conduct was one continuous act that affected multiple officers.
Sounds to me like you said it's appropriate then to charge.
It's not appropriate to charge, Donna, and the ethnic intimidation, you really can't do that because with ethnic intimidation, he didn't do it act because of Mr. Gerwig.
I think actually Deputy Gerwig, he stated accurately, it would not amount to ethnic intimidation.
Right. Now, it was a horrible thing.
Absolutely reprehensible and hurtful and beyond the pale in terms of what another human being should say, but it may not constitute a crime. You're right.
I agree. So I think we only got about one count of resisting obstruction. Resisting obstruction. At the most, no ethnic intimidation, and we don't have witnesses here in which I can cross-examine anything that was being said. The biggest thing we heard is that they both were fighting. That was consistent. That was consistent in the report from Deputy Gerwig. That was consistent in the statement from off of the 911 call. We did also hear that he picked her up and slammed her. We don't know the reasoning behind that, and we don't know what that means. I'm not able to talk to Mr. Printup and say, did he pick her up because she was hitting on him like this and dropped her? I'm not able to do that, Your Honor. So respectfully, we're asking to not bind over all the charges, but I would understand if there is one resisting obstruction charge.
One?
One.
Okay.
One. I understand in the malicious destruction.
At what point are we talking about the resisting obstruction? Are we talking about in the hallway where at least I saw 3 distinct incidents? Are we talking about going down the stairway, which once at the bottom I saw another incident? Or are we talking about at the car when he refused to follow the officer's instructions?
I would call that.
Which resisting and obstructing would you say is the one?
I would say, well, I can't say. I say if anything. That's why I put if anything. But I don't see 3 different distinct acts, Your Honor. I see it all as one continuous act of the police trying to arrest him and put him in the car. That's how I see it. Once they got the cuffs on him, they got him up. He walked out.
Okay. Yeah. I see how you may be looking at it. I think you're wrong, but okay.
Right. That's how I'm looking at it. Respectfully, that's what we ask, you know.
All right. Anything, I don't need any additional argument, but is there an argument from the people? All right, the court, after all of the evidence in the case and seeing the exhibits and the videos, would find that the people have indeed sustained their burden as to the majority of these counts. As it regards count 1, the assault with the intent to commit great bodily harm, less than murder, not only by the statements, but also when Deputy Smaha shows up afterwards, her interaction with Ms. Printup buttresses that case of her getting dropped on her head, because first of all, she has a cut. There's the blood that's in the apartment, but then also, as described by Officer Maha, her inability to carry on a coherent conversation. And as the deputy indicated, she was looking to destabilize her head. It's obvious that something had occurred given the statements that were made. I think that people could show, and a reasonable fact finder could conclude that there was an assault with intent to do great bodily harm done on Ms. Prentup by this defendant. So therefore, the court will bind the defendant over on that charge. Count two, the malicious destruction of fire and police property. I don't think should be any dispute. One can watch the video and see definitely that that's exactly what he did. He did almost $2,500, $2,600 worth of damage to that vehicle in his little fit of rage that he went into. With regard to the resisting and obstructing, as contained in counts 3, 4, 5, and 6, the court, while understanding what the defendant is saying, if it were this one event in there, it could be charged as only, or properly found to be only one. But when one looks at the video, one can either do this by officer or the separate events that this defendant engaged in as they are trying to take him into custody. As I indicate, you just need to look at the acts of the defendant and what the officers had to do, because there are some officers that aren't even engaged with the defendant initially, but have to then engage, which he then resists, that are happening in that hallway area or that vestibule area. There is then additional resisting and obstructing as he's coming down the stairway, and other officers have to jump in to try to get him to do that, particularly when he gets outside. He is walking after they've had to carry him down. He then goes into another event where he stops moving, and they have to then move the officer. The officers have to move him. And then finally get him to the vehicle. Sitting there, they're trying to get him to just put himself into the vehicle as they have sat him in the doorway, and he is refusing to do that. And then the officers have to re-engage with this defendant to then put him in. So whether it be by officer or whether it be by event, as the court has laid out, I think the charges of resisting and obstructing, and quite frankly, I think that there could be more, but I will bind the defendant over on 4 counts of resisting and obstructing. With regard to, and I already stated it, with regard to the ethnic intimidation, I think it's one of the most despicable things this defendant could have entered into. Obviously not your finest moment, but also just say shameful as a human being. In particular, shameful as you can roll your eyes all you want, but I'm gonna tell you what, when you can sit there and say that kind of thing, you as a man of color growing up in this country, I don't even know how you get there. Don't know how you get there. But I don't think it fits the crime of ethnic intimidation, and won't bind him over on that charge. The defendant is bound over on counts 1 through 6. You know what? You better check your client. Take him back. Bind him over. We'll call the next case up after you check him. Got to finish his arraignment once he's here on the information, but I can't do it at this moment.
Anyway, I can take his property back there with him.
Pardon? I don't think they're gonna allow him back. I'll leave that to the sheriff's department to do, but if they say no, sir, I can't order them to let that happen. All right. Want me to go on before I say something? Okay, yeah, I'll go off. Am I on? No. 1 through 6, counsel, you acknowledge receipt of the information client stands mute to those charges.
Yes, yeah.
Been in every way, form, or reading, standing mute. Court will enter a not guilty plea. Pretrial in that matter will be set for
July 17th at 1:30 before Judge Slay.
July 17, 2025, 1:30, Judge Slay. Bond on that matter will continue. My understanding is that he's waiving on the other matter.
Yes, yeah.
Mr. Gibson, you're waiving your right to a preliminary examination on the other case?
Correct.
And you understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Correct.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution?
Correct.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on count 1 with 2 and 3 following. Counsel, you acknowledge receipt of the information, waive its reading.
Yes, yeah.
Client stands mute.
Yes, yeah.
Defendant every way form of reading, standing mute. Court will enter a not guilty plea to all 3 counts. Pretrial in that matter will be set for
May 29th at 1:30 before Judge Slay.
May 29, 2025, 1:30, Judge Slay. Bond in that case will continue. Thank you.
Thank you, Your Honor. May I approach?
Yes. Got a side road. What's my other waiver so I can get that?
Very good.
All right. Bird, you take care. Bird, I didn't know you ever go find that case law for me. That's okay. I am a patient judge.
I appreciate it too. I had so much to go through because we had another motion.
Yes, I got you. I got you.
So you're patient, Judge?
Wow.
When did that? Alan, some change?
What do you mean you don't know? Seriously, Alan? Court does call the case of People versus Jantz.
Andrew Childers, attorney on behalf of people.
And Alex Warren Green on behalf of Jantz. Mr. Jantz, can you state your name for the court?
James Jantz.
All right. He's waiving his right.
That's correct, Your Honor. He's executing the form right now. In exchange for his waiver, the people have agreed to reduce the OWI third to an OWI second in circuit court, and have extended a sentencing agreement to no prison.
That's correct.
Mr. Jantz, you're waiving your right to a preliminary examination.
Yeah.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes.
All right. People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendant is bound over to circuit court on counts 1, 2, and 3 with 4 and 5 following.
Your Honor, we acknowledge receipt of the information, waive its reading, and stand mute.
Defendant never waived formal reading, standing mute. Excuse me. Court will enter a not guilty plea as to all 5 counts. Pretrial in this matter will be set
June 30th before Judge Simpson.
June 3rd, 2025, 1:30 before Judge Simpson.
3 weeks.
Bond will continue. Thank you. I don't know. I don't have a loose information for whatever reason.
I will have one.
There wasn't one in that one. I don't know what's happening because it's like the fifth file today where we didn't have them. All right,
Your Honor.
thank you.
That's fine.
Brent, who's on the other side of the person? Childers?
Here.
Okay. Let's call the case of the people versus Chalice McClung.
Andrew Childers, appearing on behalf of the people.
Is Mariana Long Brown, Deputy Public Defender of Green Wigan on behalf of client Mr. Chalice McClung.
All right.
Silas McLaughlin.
All right, thank you. All right, date and time set for preliminary examination. Ready to proceed, you may call your first witness.
There they are. I'll start with, we'll have Deputy Phillips testify first.
Please come forward and be sworn.
Please raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth. State your first and last name for the record.
Phillips, A-L-E-S, Phillips, P-H-I-L-L-I-P-S.
All right, main court.
Sir, how are you currently employed?
I am currently employed with the Washington County Sheriff's Office,
And how long have you worked there?
approximately 5 years.
Were you working in that capacity back on April the 15th of this year, 2025?
I was,
Were you alone or with a partner at the time?
I had a partner,
Who was that?
Deputy Bovee.
Directing your attention to, I believe it was kind of mid-morning on that date, April 15th. Were you dispatched in relation to a possible stolen vehicle?
I was,
Okay, tell me about that.
gave me a call, for a reported unit at the hotel located at 1275 South Huron. Myself and my partner initially called and spoke to the complainant who preliminary statement and then advised videos, cameras at the hotel.
Okay, and this, what kind of hotel is this on here?
This is the Marriott.
Okay. Did you and your partner physically respond to that location, or did you just communicate via phone?
We did respond out.
Okay. Did you or your partner make contact with the owner of that vehicle?
We did.
Okay, tell me about that.
She advised that she left her car there.
Two things, Your Honor. One, I'm not offering this for the truth of the matter asserted, but only to explain, in part, to explain what the deputies did. But further, and I'll get to this, permission to use property hearsay is admissible under 1101B8 at preliminary examination, and I do intend to elicit that testimony.
All right, very good. Then I'll overrule the objection with the understanding that it's not offered for the truth of the matter, except to the extent it goes to the issue of permission.
Correct. Thank you. Go ahead, Deputy Phillips.
She advised that she left her car in the parking lot overnight, and when she returned home, the vehicle was not there.
Okay. Did she let you know if anyone had permission to take that vehicle at that time?
I'm gonna know the relevance of this. I don't, but it's my understanding you're not doing the UDA, but just the,
Oh, I didn't know that.
oh. Okay.
What?
I was planning on making sure I can prove all my elements.
Oh, no.
Oh, yeah, come on. I guess. Record should reflect we had a bench conference in this case, and while the testimony of Deputy Phillips has started, my understanding is that there was additional evidence that came that is now there that as a result of a search of a phone that is now in the possession or will be in the possession of people that need to be turned over to the defense.
That's correct, and I apologize. I am last minute covering this. The assigned APA became ill and had to excuse herself. And I trust Mr. Brown that he had this conversation with Ms. Douglas earlier in the morning. So I have no problem with that. And I think that based on that new discovery and the fact that we would ultimately likely have to just recall the same witnesses, that moving this whole exam to a new date to allow an opportunity to receive and review that discovery maybe makes the most sense.
So what I will do is I'll move to my next available date, which is June 3rd, 2025, 9 a.m. That's before me. All right.
Thank you.
Yeah. All right. Thank you, Deputy. His bond will continue.
Thank you, Your Honor.
What was that? Just like, good morning. Wow.
Solemn for the,
What?
for the court. I was being, respectful and solemn for the.
So
Justice.
when did that change that? You've never been that way.
Woke up this morning.
I woke up this morning and said I'm gonna be solemn. Okay, all right, very good. They're in custody
Yes.
on Zoom. Court calls the case of the people versus Timothy Haslam.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Haslam. Mr. Haslam, please state your name for the record.
Timothy Haslam.
Mr. Haslam is obviously in Macomb County. I have been trying to meet with him. They use an online system that is just not functioning correctly with my computer. I've had IT working on it. So I haven't met with Mr. Haslam. I know this is a time-served recommendation. However, there is a discussion about HIDA. And I would like.
Oh, in this case.
Right.
Oh.
And I would like to explain that to him. He is being held in Macomb County on I think a $50,000 bond. An exam is scheduled for, I want to say June 6th, but I'm not sure if that's correct, in the next couple of weeks. So I asked for an adjournment of the sentencing. I apologize to Mr. Haslam. I'm working on trying to get out there. Or I might have to go there, but their online system is giving me some issues.
All right. Mr. Haslam?
Yes.
You got another case here. Another misdemeanor complaint that alleges that on or about November 25th, 2024, location in Pittsfield Township on Carpenter Road, that you did operate a motor vehicle while your license was suspended, denied, and or revoked. Do you understand the nature of that charge, sir?
Yes.
Okay. That's a misdemeanor punishable by up to 90 days in jail and a $500 fine plus court cost, 93 days in jail, $500 fine plus court cost. You understand that, sir?
Yes.
Okay. First question I have for you is, do you wish to be represented by an attorney?
Yes.
Okay. This is a public defender case.
Yeah,
Do you need the case number on that?
No, that's okay.
All right.
We waive formal reading and stand mute to the charges.
All right. Defendant having waived formal reading, standing mute, court will enter a not guilty plea in this matter. Casey.
Yes, sir.
All right. I will set his bond at a 1,010% bond, so he gets credit. That was his warrant amount. Now, what's my next sentencing day?
May 28th at 12 p.m.
Do you think, Ms. Perry, you'll get whatever needs to be solved by May 28th?
I think so. If I can't get the online system, I think I can request an in-person, and go out to Macomb.
All right. And I don't want to bring him back twice on this pretrial, so let's do this. I'll set your pretrial, Mr. Haslam, on the one that I just arraigned you on, that case. I'll
Yes.
set that for a pretrial. Well, problem's gonna be, I won't have Siller here on the 28th.
It's a trial docket in morning by
Yeah. The sentencing would be in the afternoon.
Yeah.
Give me my next, let's do it this way, this other one is, give me my next pretrial date, and I'll just set the sentencing at a special time.
Okay, so pre-trial would be June 4th.
All right. I'll set the pretrial in your other matter for June 4th, 2025 at 9. Okay? And then I'll set your sentencing on this case also for that June 4th, 2025 at 9. That'd be a special time for sentencing. But that way you don't have to come back twice. All right? All right, thank you. Court does call the case of People versus Jenny Liu.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Ms. Liu. Ms. Liu, please state your name for the record.
Oh, she's unmuted, I think, now.
Jenny Liu.
Okay, thank you.
Your today's date and time set for sentencing. We have reviewed the pre-sentence report, don't have any material changes, additions, or deletions. We do ask that you adopt probation's recommendation. Ms. Liu has been incarcerated at the Sierra Valley Prison for many years now. So I think that a credit for time served sentence is appropriate.
All right. Is there anything you want to tell me before I impose sentence?
No, sir.
All right. On the count 1 assault and battery, $125 statutory fees, 93 days in jail, credit 93 served. On count 2, the assault and battery, $50 statutory fees, 93 days in jail, credit 93 served. All right. Thank you, Ms. Liu. Good luck to you.
Okay, thank you.
Court calls case People versus Logan Cyrus.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Mr. Cyrus. Mr. Cyrus, please state your name for the record.
Logan Cyrus.
Your Honor, we have reviewed the pre-sentence report and don't have any changes. We also reviewed the recommendation and asked that this court adopt it. He did do the maximum time on this charge.
All right. He's still in.
He is, when I asked if he knew when he was going to be released, he doesn't know at this point.
Okay.
I don't know when he's going to be able to pay the restitution.
Got it. Is there anything you want to tell me before I impose sentence?
No, Your Honor.
All right. Sentence to the court, $125 statutory fees, $540.14 restitution to Meyer payable to the court. That will be due 90 days after his release. I'll order 93 days of jail, credit 93 served. Thank you.
Thanks.
Court calls the case People versus Elijah Kyler.
Assistant Public Defender Natalie Pate on behalf of Mr. Elijah Kyler, who appears via Zoom. Sir, can you please state your name for the court?
Elijah Kyler.
Thank you, Your Honor. We are here for an amended sentencing. We have had the opportunity to review the PSIR. Of course, still no corrections to that. As to the amended recommendation for the restitution, we would ask the court to adopt it. My client does understand that. And we are asking if the court would make that amount of restitution payable 6 months after his release. His max out date is September of this year.
Got it. Okay. Sir, anything you want to say before I impose sentence?
No, Your Honor.
All right. Sentence of the court, $125 statutory fees, $300 restitution to Ann Arbor Police Department payable through the court. That will be due 90 days after release. And I'll order 180 days in jail, credit and 180 days served. Okay? Thank you, sir.
Thank you, Your Honor.
Kyler. Have a good day.
Thank you, Mr. Kyler.
All right, thank you.
Court does call the case People versus Yolanda Woods. That's all my hand custody.
Yes.
Hello.
All right.
That's good. Good morning, Your Honor. Bruce Davis, P 76203, appearing with Yolanda Woods, who's present via Zoom.
So Woods, could you identify yourself, please?
Yes, Yolanda Woods.
All right. Go ahead. This date and time set for sentencing, counsel.
Yes, it is, Your Honor. I had a chance to review the pre-sentence report. No corrections, deletions, or additions. And the recommendation is in line with what the prosecutor and I discussed. I think the deferral program is good for her. She doesn't have any prior criminal history, no thefts or anything like that. She's 54. She's working. She's working for Eastern Michigan in a clerical position. Ask the court to adopt the recommendation as is.
Ma'am, anything you want to say before I impose sentence?
No.
All right. Sentence of the court, place you on 4 months prosecutor deferred sentence. You're to pay $480 fines and costs, $125 probation oversight fees. When can you get that paid, ma'am?
I can pay, half today and half on the 13th of next month.
Okay, so $300 today.
Yes.
All right. And then the balance, you said you could pay it by the 13th, so I'll make it the balance by June 16th,
Okay, thank you.
2025. There should be no use of alcohol, recreational marijuana, or any illegal drug. You'll be subject to random testing as requested by probation. You are to complete a theft class. You're to do that within the next 60 days. You're to complete 25 hours of community service as directed by probation. No going to any Walmart store in the state of Michigan. I will set a review hearing September 10th, 2025 at 9 a.m. I'll order 90 days in jail that is suspended. All right.
Okay, thank you.
Thank you, Judge. Have a good day.
Thank you. All right. Take care.
Yeah.
Calls case people versus Jonathan Webb.
Morning, Judge John Shea, appearing with and on behalf of Mr. Weber for sentencing.
Go ahead.
Judge, Mr. Weber's before you on his first offense. He's 63 years old. The BAC was not low, but not hugely high either. It was 0.156. It was a very minor accident. And by that, I mean it was a very slow speed rear end, and it's a matter of him being drunk and not adequately giving himself enough room to stop at a red light. Very little damage, both cars drivable, that kind of thing. He was completely honest with the police. When they asked him if he had been drinking, he said yes. When they asked how much, he told them. When they said when, he told them. So there was no screwing around. He's been responsible since this case. He's sober. He's enrolled in an IOP, completed next week. He's had negative tests through community corrections. He's had negative tests in the IOP program itself. They ETG him every week. He's prepared to pay his fines and costs today. He's reported this to the bar. He's doing everything that he's supposed to do. And he looks great and he feels great. So in a sense, I'll let him tell you this himself, but in a sense, this has been unfortunate that it happens in this way, but he's happy to be sober. I asked the court follow the recommendation. I think it's fair.
Mr. Weber, anything you want to say before I impose sentence?
Yes, Your Honor. I am very sorry that this happened. It has been something I've been very careful about in the past, and I blew it. The only positive thing is being in the IOP, those people are really good, and I don't think I'm ever going to drink again. I think 40 years of drinking is enough, and then I have every intention of never drinking again. And thank you for your patience.
Sometimes it's all I have, right? All right. All right. And Mr. Weber, as I indicated, I do know of you, and sometimes bad things happen sometimes for a good reason, right?
That's exactly what I said to my sister.
Pardon?
Right after the accident, after I spent the night in jail, I called my sister. I said, I was in an accident last night. It might be the best thing that ever happened.
Okay. And the other thing I was going to point out is that also being aware of you, there's a lot of good things that you've done throughout your life and career. And certainly this, the important thing to note is that doesn't erase any of that, right?
Thank you.
All right. The court does acknowledge that this is not a serious misdemeanor as defined by statute. However, it does believe that there are reasonable grounds to depart from the presumption of a non-probationary sentence. Specifically, the alcohol assessment, screening assessment identifies the benefit of an IOP program, as well as random testing. Therefore, I will follow probation's recommendation of a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance with recommended treatment. Therefore, the sentence of the court that I would place you on 12-month probationary term. You're to pay $855 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs, $360 probation oversight fees. That is going to be paid today. Is that correct? There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete your IOP treatment program at U of M with status reports to probation. You're to attend one AA meeting per week with monthly verification to probation. You're to provide proof of the victim's impact panel attendance to probation. I'll continue to sober link for an additional 30 days in lieu of 4 days in jail. I'll order 93 days in jail. Credit one, the balance is suspended. All right. Thank you.
Thanks, Judge.
Thank you.
See you soon.
Court does call the case of the people versus Sequandala Middleton. I messed that up again.
Covered on behalf of Ms. Middleton. Good morning, Judge. Ms. Middleton, please state your name.
Sequandala Middleton.
I just want to put another, I want to break the syllables apart in a different way. I apologize again, man. All right, go ahead.
So thank you, Judge. So we are here for sentencing. We have reviewed the report. I've spoke about it with Ms. Middleton. We have no additions, corrections, deletions, no changes to be made to it. I just would add, so when Ms. Middleton was speaking to Agent Pilara, the number she got for fines and costs was $848. The report says 1010. She can make that happen, but we are asking for a little relief. She is paying off fines and costs in other cases in other courts. She is ready to put this behind her. She can make a $300 payment tomorrow, and after that asks for a $50 payment plan. Other than that, Judge, I've got nothing to add. Ms. Middleton is ready to set this behind her and move forward with her life. She's taken quite a few steps in the last few months to turn around her past. Nothing further.
So Middleton, anything you want to tell the court before I impose sentence?
No.
All right, you said you could make the $300 payment. Said tomorrow?
Yes.
Okay, but you can make it by Friday for certain, okay.
Yes.
And then you want to. Okay. On the count 6, larceny less than 200, $455 fines and costs, $700 restitution to Meyer payable through the court. You'd pay $300 of that by May 16, 2025, then $50 per month thereafter until that's paid in full. I'll order 93 days in jail, credit for 10 days served. The balance is suspended. On the count 7, larceny 200 to 1,000, $555 fines and costs, 365 days in jail, credit 10, balance is suspended. That $50, those fines and costs will be paid with the $50 per month payment. All right.
Thank you, Judge.
Thank you. Court does call the case, People versus Jordan Hartmeyer.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Hartmeyer. Senator, I have not had contact with Mr. Hartmeyer. I did attempt to make contact with him. I don't see him in the courtroom. I'm not sure if he's present on Zoom. I don't have an explanation for his failure to appear. I would request an adjournment of the sentencing hearing.
I'm Teresa Clare on behalf of probation. Your Honor, Mr. Hartmeyer, this is his second sentencing hearing. He's failed to complete his pre-sentence interview appointment with the probation department. This is now the second time, given that he's not compliant with that and also not present. Probation has been further.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $25,000. I'll give a 10% privilege on that. That warrant will issue immediately. Court calls case, People versus Nicole Nelson.
Good afternoon, good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Nelson. Mr. Nelson, please state your name for the record.
Nicole Nelson.
And I did speak with Mr. Nelson regarding his missed court date and his missed PSI appointment. He is willing and able to complete everything he needs to do before his next sentencing date. I do ask that you adopt probation's recommendation. He is, as the court knows this, but just as a reminder, he just did get out of inpatient at Bear River, did transitional housing, and now is working with an organization up north in Gaylord to, he's living in his own place and is sober. So he's doing really well. We just need to, get him to complete his PSI, which I think I did send him some reminders, so I think that will help. But again, we're just asking that the court adopt the recommendation.
And Teresa Clare on behalf of probation. Your Honor, it was brought to my attention yesterday that Mr. Nelson also has 2 pending felony cases that came through. I'm not sure if the court has those.
I don't have those with me now.
Let me see if where they are.
He's got 2.
They indicated two new felony cases. They were just entered.
They were just entered.
Yeah.
He's not been arraigned on those, or?
I do have case numbers if you want those. I'm not sure if the court wants to address those.
Well, the problem is, well, it's not really a problem for me, but what will happen is Mr. Nelson will have to come back to get arraigned and then have to come for what kind of cases are they?
I don't know. This is the first I'm hearing of it.
It was just advised of them, Your Honor. One is a larceny in a building. Other is an uttering and publishing, counterfeit bills, criminals.
Okay. I don't have those in front of me right now, so, and they just got entered, so.
Well, I can reach out to the magistrate's office and see if maybe we can, since he is in Gaylord, see if they can do a quote unquote walk-in Zoom arraignment and
didn't get them set and then make it for me. Okay, all right, real good. All right. So what I will do in these cases, Mr. Nelson, is I'm gonna re-refer you to probation for a pre-sentence investigation and report on both cases. Okay, sir?
Yes, sir. Thank you, Your Honor.
Do you have the $75 re-referral fee, or where are you?
Yeah, I don't have it at this time, at this moment, but I am working, so it shouldn't be anything to pay that.
Okay.
Coming up soon.
So what I'm gonna do is, you need to pay the re-referral fee. I'll make that due and payable. I'll give you a couple weeks to get that in, okay?
Okay.
Just pay it by May 30th. We'll do it that way. Pay it before the end of the month.
All right.
And then I'll set a PSI appointment. Is that gonna be, that obviously be a Zoom?
Yes, Your Honor, I will conduct that, via Zoom or telephone with.
Okay. I'll set it for May 15th, 2025 at 1 PM, so tomorrow. I'll adjourn your sentencing to May 28th, 2025 at 12 PM. That's on both cases. There's only one re-referral fee. Okay?
Yes, Your Honor.
All right. Thank you, sir.
Thank you.
Court calls case People versus Kevin, is it Stichler?
Assistant Public Defender Natalie Pate with and on behalf of Mr. Stichler, who appears via Zoom. Sir, can you please unmute and state your name for the court?
Is Kevin Stichler.
Thank you, Your Honor. Today is the day and time set for sentencing. We have had the opportunity to review the PSIR as well as the recommendation. As to report, we have no material changes or corrections, and we would be respectfully requesting that the court adopt probation's recommendation.
All right. Sir, anything you want to say before I impose sentence?
No, I appreciate getting this taken care of. It's cleaning up my damage that I did, and I'm just respectful to the court and appreciative of everything that has been done. Thank you, Natalie, too.
All right. Sense of the court, $480 fines and costs. When can you get that paid, sir?
Your Honor, I just got my license back and I'm pursuing a better job. Right, I had come out of rehab and have been working at the House of Meats. They just haven't been giving me enough hours. So if I could get a payment plan started with you guys, I owe Lenaway for the same.
How much, what type of payment plan do you need?
If I can do $25 to $50, somewhere in that range a month.
What day do you want to make it payable? I'll do it for you.
I can start this week.
All right, so what I'll do is I'll just indicate $50 per month starting on the May 16th. Well, I'll make it May 19th.
I appreciate that.
All right, and then 90 days in jail that is suspended. All right, thank you. Good luck to you, sir.
Thank you, Your Honor.
Thank you, Your Honor. Thank you, sir.
Court calls case People versus Juwan Wilson.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Wilson. Please state your name for the record, sir.
Juwan Wilson.
Your Honor, we did review the pre-sentence report. We don't have any material changes, additions, or deletions. We did also review the recommendation. We believe that it to be fair, and we ask that you adopt it.
Sir, anything you want to say before I impose sentence? No, sir. Sentence of the court, 4 months prosecutor deferred sentence. You're to pay $480 fines and costs, $120 probation oversight fees. When can you get that paid, sir?
I say before the 4 months is up.
Pardon?
Before the 4 months is up.
Okay, but how are you going to pay it?
Do you have like an amount monthly you think you can pay?
Yeah, $50 a month. I could pay 100 today.
Okay, that's a good start. 100 today. And then how much are you going to pay each month? You're gonna have to actually get it done in 3 months if we're gonna do the 4 month.
Yeah, before the 4 months. I'm not sure how much that is.
I can't do the math off the top of my head, but it's
He'll have 500 due
after the 100.
after the 100.
250 on.
Is something you can do?
Yeah.
Okay.
All right, then $250 per month until that's paid. There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete a theft class. You're to do that within the next 60 days. You're to complete 25 hours of community service as directed by probation. You're not to go to any Walmart store in the state of Michigan. I'll set a review hearing that's to be held on September 10th, 2025 at 9 a.m. All under 90 days in jail, credit-free balance is suspended. Thank you. Court does call the case, People versus Frederick Warden. Oh.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Warden. Warden, please unmute and state your name for the record.
Frederick James Worden, II.
Your Honor, today's date time set for sentencing. Mr. Warden still needs to complete his Von Schwartz assessment. I do ask that you adopt probation's recommendation. He does have.
Why didn't he do it?
I would defer to Mr. Warden. He did tell me this morning that he has the packet that he needs to fill out prior to doing the assessment. When do you think you're going to have that finished, Mr. Warden?
I didn't know how to I don't have a good excuse. I didn't know how to do the money order thing that I'm supposed to send with it, but I have my daughter helping me with it and I can have it done by today. I do have it. I don't know how long it takes through the mail, all that stuff, but I do have it completed and I just have to send it in the money order. So
We referred the defendant to Von Schwartz for an alcohol screening and assessment. He's to pay a $75 re-referral fee. He's to pay that today to the court. I'll adjourn his sentencing to June 11, 2025, 9 a.m. That sentencing will be in person. All right. Thank you. Court calls the case, People versus Jessica Duff.
Your Honor, Dan Garrett on behalf of Jessica Duff stepping forward.
Jessica Duff.
Thank you. Your Honor, we've reviewed the pre-sentence report. It is accurate. I'm asking Your Honor to follow the recommendation. Of note, financially, my client paid the restitution entirely today, has brought cash to make sure the victim's made whole on that, as well as her fines and costs. I want to point out how proud I am. Ms. Duff has proactively completed her Dawn Farm program, and she's been on the scram now, I think, almost 6 months without one violation. Tribute to her sobriety and her commitment to doing what the court asked her to do.
Yeah, just to clarify on behalf of probation, Your Honor, the victim, A.B. Hudson, is present. She'd like to make a statement.
All right. On your side.
Good morning.
State your name, please.
My name is Amy Hudson, A-M-E-E, last name's Hudson, H-U-D-S-O-N.
All right, go ahead.
So on August 31st, you changed my life forever. You made the decision to get behind the wheel of a car drunk. You drove into the back of my car. I was sitting at a stoplight. Not only did you drive drunk, but you were speeding. I will never forget the sound that haunts me to this day. By throwing me around in the car like I weighed nothing after the pressure of your vehicle blew out the back tire sitting in the driver's seat, which broke, by the way, along with the seatbelt. The airbags burning into me and the pain. I honestly don't remember much about getting out of the car, except for the look on the passerby face. The driver's door was broken. It took both of us to get me out. He stood there with tears running down his face, telling me not to swallow due to the blood pouring from my mouth and face. Or my nose and mouth, excuse me. The pain from my left side and hip was worse than pain I'd ever described, that I could not even realize I was bleeding, burned on my elbow. My left hand was completely damaged. I ended up going to the same hospital, to the same ER as you. You did not know it, but I was in line in front of you. As I cried in pain, I listened to you laughing and joking with the officers. Not once did you ask about the other driver or what you did or what was going on. There was no remorse. For nearly 7 weeks, I was on crutches. This did not include the 7 days beforehand that I was completely bedridden. I cannot drive past that street without shaking. If someone comes up behind me too fast at a stoplight, it's hard for me to even breathe at times. You did this to me. You made the choice to drive drunk. The permanent effects from this vehicle accident that I have to live with the rest of my life, just to state a few, I have permanent scars from the burns from the airbags. I will never get to feel what it feels like to put a ring on my buddy's finger again. It is damaged to be unfixed. I walk with a limp. I have permanent damage done to the side of my face, to the right side of my face. I have permanent damage done to the left side of my whole body that will never be able to be repaired. After grueling months of physical therapy, which I'm still going through, multiple surgeries, I will never get any of that time back. The only income that came out of this was that I learned one thing about the justice system, and that is that they're not always your friend. The victims are the ones that pay, and the criminals are the ones that are made to look like the heroes. I have fought every single day for my voice to be heard. I have fought every day for the insurance companies, for justice to be served as today, and for you to be sentenced for this. I am asking for the court to give you the highest recommendation can be, including having it be to where anytime you get into a vehicle, you have to blow. I'm also asking for the restitution, which does not even cover half of what I've lost or what I've had to pay for. It's only for what I could find the receipts for of the rental vehicles and for the towing, which is $2,700, I believe $40.21. Thank you.
Well, first of all, I have $2,720.80.
I did not have the amount in front of me.
Oh,
Is the reason why I was saying that. I did not have that. And that does not include, that's only the receipts I could find of the rental. It was I had a loaner vehicle. So that's what I was driving. So while the insurance companies were fighting, I had to rent a vehicle until he could get his money back. And then he proceeded to work on my vehicle. So I just had what that was.
Are you telling me that there's additional restitution?
Yes, there is, but I'm not charging for that because I could not provide the receipts. I only had until May 7th. And unfortunately, one of the places that I rented the vehicles from closed their doors at the end of last year. So I was not able to get the original, the receipts for that one.
All right.
Thank you.
Your Honor, if I may, I'd like to make a direct apology to Ms. Hudson.
May
May I turn and face her?
Okay.
I'm so sorry. I'm so sorry. I take full responsibility. And I'm so sorry for the damage that I caused to you, and to the hurt that I caused to you. If I could take it back, if I could undo it, I would. I would completely undo it. I will never do anything like this again. I'm sorry.
Thank you. I appreciate that. Thank you.
Is there anything you want to tell the court before I impose?
Same, Your Honor. Sorry, and I'm deeply regretful. I've learned from this I think about this every single day. I do have complete remorse. I do have complete regret. And I intend to never repeat anything like this experience again.
This is not a serious misdemeanor as defined by statute, however, believes there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of outpatient treatment, AA meeting attendance, and monitored abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. Therefore, the sentence of the court, I will place you on 18 months probation. You're to pay $855 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs, $540 probation oversight fees, $2,720.82 restitution that is payable to Amy Hudson, but that is payable through the court. What can you pay today?
We're prepared to pay that in full today.
Pardon?
We are prepared to pay in full today, Your Honor.
Everything today?
Yes,
All right. And you do have then the restitution in cash, correct?
yes, sir. We
Okay, very good. All right, all of that is payable today. There is to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete the non-farm outpatient program, including all aftercare recommendations with status reports to probation.
Yes, Your Honor.
You are to attend one AA meeting per week with monthly verification to probation. You're to provide proof of the victim's impact panel attendance to probation that has, to my understanding, been completed.
Sure.
I will continue to scram tether for an additional 30 days in lieu of 4 days in jail. All over 93 days in jail. Credit 1, the balance is suspended.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor. Just outside.
Court does call the case, People versus Naji Kahala.
Good morning, Your Honor. Dan Guerin on behalf of Najee Kahala.
Good morning, Your Honor. Najee Kahala.
Thank you.
Your Honor, Mr. Kahala and I have reviewed the pre-sentence report. It is accurate. We are asking Your Honor to follow the recommendation. Grateful to see it was recommended for the deferred sentence. He can pay all his fines and costs today as well.
Sir, anything you want to tell the court before I impose that?
No, Your Honor. Just, I'm happy and glad that we're able to take care of this.
Sentence of the court, you are placed on 12 months prosecutor deferred sentence. You're to pay $555 fines and court costs, $360 probation oversight fees that will be paid today.
Yes, Your Honor.
There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as directed by probation. You're to complete an anger management program as directed by probation. There's to be no contact with Nassim Kasham or Caleb Kasham, directly or indirectly. There's to be no assaultive, threatening, or intimidating behavior on your part. You are not to possess any weapons, firearms, ammunition, or anything fashioned to be a weapon. I'll set a review hearing that's to be held May 13, 2026 at 9 a.m. I'll order 93 days in jail. Credit 2. The balance is suspended. Thank you.
Thank you, Your Honor.
Hold on. Court calls the case of People versus Ahmed Kahala.
Morning, Your Honor. Dan Guerin on behalf of Meg Kamal. Can you state your name?
Ahmed Kahala.
Your Honor. Your Honor, I'm going to fill in for your attorney record, Joe Simon. That's with your consent. Is that correct?
Yes, sir.
Okay.
All right. You have no objection to that?
No.
All right. Very good.
I'll keep it brief, Your Honor. I'm asking Your Honor to follow the recommendation that looks to mimic his brother and co-defendants.
Sir, anything you want to say to the court before I impose that?
No, I just want to say I'm very grateful for the deferred sentence and thank you guys so much.
sent to the court, 12 months prosecutor deferred sentence. You're to pay $555 fines and costs, $360 probation oversight fees. When can you pay that?
Today.
Thank you. Pay that today out at the counter.
Sir.
There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as directed by probation. You are to complete an anger management program as directed by probation. There's to be no contact with the Sim Kasham or Kidlip Kasham, directly or indirectly. No assaultive, threatening, or intimidating behavior. You're not to possess any weapons, firearms, ammunition, or anything fashioned to be a weapon. I'll set a review hearing that will be held on May 13th, 2026, 9 a.m. I'll order 93 days in jail. That is suspended.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you, sir. They did not. Court does call the case People versus Derek Hall. Go ahead, Cal.
Assistant Public Defender Natalie Pate, for Mr. Hall, who, Your Honor, I believe still is in Macomb County Jail. They were logged on this morning with another client. And I met with him.
They did not confirm the
Mr.
writ
Hall?
for this case.
Oh, okay. I would respectfully request an adjournment. We would be prepared to proceed at sentencing at an adjourned date. I did get to meet with him online, so at least that's square.
Then what I will do is, who was the other? That was Mr.
That was Mr. Hall.
We did.
And I did speak to the officers there. They had a shot red and they didn't physically have it.
Turn this to the 28th, is that my understanding?
Yes, it is.
May 28th, 2025 at 12 noon.
Thank you, Your Honor.
That's it for that one. All right. Very good. Court's gonna stand in recess. All right. Court does call the case People versus Amy Avey.
Good morning, Assistant Public Defender Lauren, on behalf of Miss Avey. Say your name, please.
Amy Marie Avey.
You know, Miss Avey and I did not have a chance to speak prior to today. She's here for a show cause. I'd ask if you could provide to the court if and when you can pay some money on these cases.
I am on a fixed income. I get disability, $967 a month.
How much?
$967 a month. I've been put on disability for my breathing. I mean, I can do 50 a month, maybe, you know, that's all I have. That would be honestly, I forgot all about these charges because I did the jail time. So I didn't think.
Maybe adjourn this out, let you fill out the ability to pay. Why don't we do that and let's see what we can do about this.
Sure.
All right. So I'll adjourn this to June 11th, 2025, 9 a.m. Okay.
Thank you.
Thank you.
Never fill out the paperwork and we'll take a look.
If you're your phone number, so. Okay.
Court does call the case of People versus Donald Foreman. Extend.
Yes.
Your name, sir?
Donald Foreman.
All right. You're here on a show cause for fines and costs. $610. You're obviously in custody right now. Do you have an out date at this point, or what are you in for?
DV.
DV. Who's it before, do you know?
Conky.
Okay, okay, so when are you next scheduled to go to court?
Supposed to be Friday.
Pardon?
Supposed to be Friday.
This Friday?
Yeah.
And I know there's a lot of questions, but is that for a trial or a pretrial or
Trial.
for a trial?
Bench trial.
I'm sorry?
Bench trial.
Ben's trial on this Friday? All right. And that's the only thing that you have pending right now that's holding you? Let's do this then. I'm gonna adjourn this matter to June 11th, 2025, 9 a.m. Let's figure out what happens with that, because right now you can't pay anything. Okay, all right, we'll do it that way. Thank you, sir. Are you represented on that other matter, sir? Are you represented by the public defender?
Yeah.
Okay.
Time served.
Pardon?
Time served.
Time served on this matter? You mean? Well, you've got fines and costs. You've already been sentenced on it, but this is for the fines and costs. So maybe what I'm gonna do is, Ms. Perrine, I'm gonna have the PD represent him on this case so that you can, because what he has up there is gonna flip into that anyway.
Yeah, we'll track whatever happens there, and depending on how things proceed, get in touch with the court.
All right, real good. All right, thank you.
Remind me of the next date, I'm sorry.
June 11th.
Okay, thank you.
They can grab it. Court does call the case People versus James. Is it Reidenthal?
Public defender Natalie Page versus Breidenthal, who may be trying to answer.
Reidenthal?
So you're today's the day and time for a show cause. My office was in contact with him and was able to leave voicemail to a number we had for him to get a further explanation for his failure to appear. I would request an adjournment of the show cause record.
Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $25,000. I'll give a 10% privilege on that. That warrant will issue immediately. Court calls the case People versus Brian Gerard. 4 cases.
Morning, Assistant Public Defender Lauren Perrine on behalf of Mr. Gerard. Mr. Gerard, please for the record.
Brian Gerard.
You know, we're here for a show cause, I think, total, Mr. Gerard. So these cases are just about the money, Mr. Gerard. I think he owes about $3,000. Do you know if and when they're going to be released from custody?
Not yet.
So,
He doesn't know when he's going to be released.
so I'd ask for an adjournment of the show cause hearing.
What does he have pending?
Possession.
I believe they're still at the PCC stage, right? They're still before your honor. His honor.
They're bound over.
Oh, okay.
When's your next date?
The 12th
Of
June.
June. Okay, give me a July date.
July.
All right. What I'll do is I'll adjourn these to July 9th, see where these are at, 2025, 9 a.m.
Thank you.
All right, thank you. Court does call the case People versus Cesarius Edwards.
Assistant Public Defender Natalie Page with on behalf of Mr. Edwards, who should be present via Zoom.
Cesarius Edwards?
Yes.
Okay, I need a camera.
All right. Trying to get it. Right.
You got it. Okay. He owes what, $975?
Yeah, I was able to discuss this with Mr. Edwards. He states to me that he can begin making $25 payments in 2 weeks. He recently started receiving unemployment benefits. He had gone through a long road with a lot of health issues. He now has these unemployment benefits and can start making $25 monthly payments. He's asking if the court would allow him to start those in 2 weeks.
Okay, defendant to pay $25 per month. That will begin on, why don't we just make it May 30th? All right,
Thank you, Your Honor.
make sure to make those payments.
All right.
Thank you.
Thank you, Mr.
Court does call the case of the people versus Donovan Gibson.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Gibson, who I believe is on Zoom, Your Honor.
Don't even check.
Gibson?
Your Honor, I did speak to him. I'm not sure why he's not here. He was actually here in court yesterday.
Yes, he was.
For another case. He did pay a make a $10 payment. I believe the end of April. He did say he was planning on making another $10.20 payment this week. He recently got back to work, in his training to be a manager at Papa John's. So he thinks he's gonna have some more income coming in.
How much is he? You don't know why he's not here.
No, I did speak to him and provided him with the Zoom information. He's usually pretty attentive. Your Honor, for the record, I'd ask for an adjournment.
Gibson? No response, bench warrant, 15,000. Give a 10% privilege on that. That warrant will issue immediately. Court does call the case People versus Stephen Bernal.
Good morning, Your Honor. Edward Drukas on behalf of Stephen Bernal, who should be on Zoom. Mr. Bernal, could you unmute and state your name?
Stephen Bernal.
Thank you, Your Honor. We have reviewed the recommendation and the pre-sentence report. No additions or corrections to the actual report. We're asking that the court follow the recommendation.
Mr. Bernal, anything you want to say before the court imposes sentence? No, sir. $125 statutory fee, 93 days in jail, credit 93 served. You're all set.
Thank you, Your
All
Honor.
right, thank you.
Thank you, guys.
Thank you. Court calls case People versus Willie Henley.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Henley. Your Honor,
Hello, what's your name?
Willie Henley?
Okay, there he is.
great. Your Honor, we were not able to speak prior to today's hearing. We did provide him the information. I'd ask that he provide the court with some information on his financial situation. I believe he owes $600.
I have $600 owed. How are you gonna get that paid, sir?
I've been trying to make payments, but the court over the phone don't allow me to make payment. They want the whole thing at once. I'm a DoorDasher and I DoorDash on the bike, so it's hard for me to come up with exactly 600 at one time. So I've been trying to make payments, but over the phone. And I don't live down Ypsilanti
I don't
anymore.
think you can make a payment over, you may not be able to make a payment over the phone.
I mean, yeah, I've been trying to do it over online on the thing, but they wanted the whole thing at once. On doc.
Well,
I'm doing it on
Mr.
doc.
Henley, how about this? Call the public defender's office, update your contact information, and I'll get with you and see if I can assist you on making the payments.
Okay, what's the number to the public defender?
222 69.
You can Google it.
Google it. Okay.
Got it?
Yeah, I can
You got
Google
a
it.
pen?
No, I don't have a pen. I'm outside, so I have to run to a building and try to find a pen.
You got somebody that can write this down?
No, I'm outside. I'm outside dancing. So I don't. I'm going over to a restaurant right now to the nearest one. Grab me a pen. Sorry about that, Judge.
All right, you ready?
Yes, sir.
222
222
6970.
6970.
Yes, sir.
We want, that's 616 734.
734. All right, 734-222-6970. Call them, make sure they have a good phone number for you and an email address if you have one, okay?
All right, thank you, Judge.
All right, I'm going to adjourn your matter to June 11, 2025, 9 a.m. Take care, sir.
Thank you.
Court calls case, People versus Carlos Hicks.
Assistant Public Defender Natalie Pate for Mr. Hicks, who may be present in Zoom. You're there, can you please let me state your name for the board?
Carlos Hicks. You got two cases or just one?
So one's an
It's a new felony. Yeah, I got it.
Your Honor, I do not have an explanation for his failure to appear. I will say our office did leave you voicemail his last known number. I will ask for the adjournment for the record, and I did handle Mr. Hicks prior. He always has been very communicative, always would show up to court. I would ask for the record. I was not aware of the case, but new felony case.
Bench court will issue for defendant's failure to appear. Bond will be set in the amount of $7,500. Give a 10% privilege on that. That warrant will issue immediately.
Thank you.
Case People versus Ibrahim.
There's no
Is on, he's got a new felony or a new case anyway. That's already in warrant status. He's not here. How much do you have? Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $3,500. Give a 10% privilege on that. That warrant will issue. Court calls case People versus Paula Johnson.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Ms. Johnson. Your Honor, do you mind if Ms. Johnson sits while we
Not a problem.
call her hearing?
How are you today, Your Honor?
I'm doing okay, Ms. Johnson. How are you?
I'm here. Thank God for that.
Can you state your name, Ms. Johnson?
Yes, Paula Johnson.
Your Honor, we are here for a show cause. I think Ms. Johnson owes about $218. She did,
Just didn't pay so she can come back and see me.
That's
I know why she didn't do it.
See, he knows.
I know.
Because he just don't ask me. He try to get all of it.
What?
That's it.
You said what?
Nothing.
No.
No, I said, because he's so handsome, he think all the women be trying to get in to see him. That's what I said.
I did not say all.
No, I said that.
Oh, okay.
No.
Okay.
You said
I did not say that. Yeah, they come here to see Alan. They don't come here to see me. I'm just.
I don't get you in trouble. You know your wife will hit you.
What?
You know, I know your wife will hit you, so you can, yeah.
Okay, Miss Johnson.
See, that's how you know I'm telling the truth. You just smiling.
knowingly.
Nothing else.
Okay.
I'm just gonna leave that.
Right. There you go.
All right.
I didn't know I still owed you money though, first of all.
You didn't know?
I was the God I didn't. I would
I was shocked there was only one case left.
you know that was so, how do you do?
I just said it. I was just surprised only one case came in.
Touche. We do go way back, don't we?
Yeah, it's been a while.
Yeah, that's a blessing, right? I'm in school, doing really good. Yeah, I am.
You're in school?
Yes.
What are you doing this time?
Criminal justice, he say this time.
Man.
Yeah, I know. I knew it.
You're in the criminal justice?
Yes, sir, I am. Doing quite well, by the way.
What?
I said, I'm doing quite well, by the way.
Yeah. Given how you operated, you're probably an expert.
Little bit. On certain levels.
Yeah, I'm just saying.
I know.
All right. So how are you gonna get this paid?
I don't know. I was hoping you was just gonna let me not have to pay it because since I'm in such a dire strait right now. I mean, I paid the majority of it. I thought maybe you could say, well, she said so well.
But I speak for my mother.
There go my pay.
I just have a few.
You wanna talk, this is your mother?
That's my baby, yes,
I'm
sir.
so sorry. No, I'm kidding. Come on.
By the way.
Myself and my mom, we are all obsessed with her. Just recently.
What's your name, first of all?
My name is Jolita Addison.
Okay.
So just recently, my mother has had a lot going on. She had a bout of double pneumonia, and she spent about 4 days in the hospital for that. She got out and was out for about 3 days, whereas they had a car accident, her and my dad. They had a very bad car accident, which totaled their car. She had bruised her kidneys and was in the hospital for another 4 days at that point. Then at that point,
No fault of mine, hold on.
it was no fault of her own. Yeah, someone lost control of their vehicle on the highway.
And ran into.
And she got hit twice.
Yeah.
So she had spent about 4 days in the hospital. Then upon getting out from that, she was still very sick. And we had to take her back to the hospital for another 4 days. Because she just wasn't doing very good with the pneumonia. She was still struggling with that. She's still having to recover from that car accident. She's got to now try to figure out how to get another vehicle. I just asked that, kind of similar to what she's asking. She just doesn't really have the funds at the moment to try to come up with that. Even trying to do a payment would be a lot for her. She is in school, like she stated. She's doing her absolute best. She's been pulling in almost all A's and B's, and I'm so proud of her. She's been doing really good. As you see, like you said, this is the only case. She's been doing really good, and I'm very proud of her. That's all I have to say.
That's all?
That's all.
Okay, no, yeah, I was gonna let you keep going.
She believes I'm good.
Well, no, because you know that there were not a lot of people coming up speaking good things about you before.
Well,
So you must have changed something.
well, yeah. Yes, I did.
180, so she's doing really, really well.
Really?
There.
Really? So there?
Yeah, I was like, I couldn't help it. You bring out the worst in me. What do you?
What? Whoa! Whoa! Whoa!
I don't know. Miss Teresa, what is going on here? What's
how did I bring out the worst in you?
I'm just kidding. Listen. Okay, what are we gonna do here?
I bring out the worst in you.
No, we don't.
I think they're doing a great job. I don't even need to be here.
Yeah.
I will add though, Ms. Johnson is on a fixed income. She gets a Social Security disability. Is that right?
Yes, it is.
And she did do 92 days on this case.
Oh, I know. I know.
Yeah.
And it was not because I wanted to get, she just.
Kept on till I just had to do it, huh?
Huh?
I just had to be here with you, huh?
You just would not do anything I asked you to do.
That's true.
You decided I'd say do something this way. You decided you were going to do something else.
You said right.
And then finally it just came down and
and I had no qualms with that, and you know it.
Well, at the time you did.
Well, no, I didn't actually. I did what I needed to do and came on up out of there. It wasn't your fault, so I
know it wasn't my fault.
So why should I have any animosity or ill feelings against you? You're just doing your job.
Thank you.
You're welcome.
It was very nice of her to say. She is not like this. I don't know what's happened.
What is wrong with you? What do you
This
mean?
is not the person I remember.
You know what?
Miss Polera,
Miss
Polera, is this the person you remember?
You know, Your Honor, I do have to say, I don't know what time, that Paula came around to me, probably the second or third. She did really well.
Thank you, Mr.
She did get her act together, per se, and was compliant with me on a later case than that, and she did do probation. She checked in with me. She was in school then, and she was doing really well when she ended there. I do have to say that.
So everybody else stick up.
Oh, no. You know what? You just
like
do not believe.
It's like a Paula festival.
You know you're so wrong today.
What?
What did I do, T? What did I do? I've been doing really well here.
I would tell you she was not doing what she was supposed to do, but she did. She did really well towards.
And you know she'd tell. She would tell you. Yes, she would.
Oh, I know she would.
There you go. See?
Because we had a lot of conversations like that, didn't we?
Yeah, we did. Oh, many occasions.
But then came around.
I don't have no qualms with it. You know, you're wrong. You have to own up to it so that way you can move forward, correct? At least that's the way I see it.
You got all A's and B's?
I've got a C. I ain't gonna lie to you, okay? I'm working on it.
What do you have a C in?
What do I have a C in? I have a C in, what is it? Right now, all I have is, I have, my math class. It's been a while, so I'm working my way back up to the B, you know, but it's different, you know. I haven't had math in a long time, so I'm just saying, I'm working on it though. I don't have a defeatist attitude. I am going to get my degree this time. Bam, bar none.
This person that I see now, I have no doubt in my mind that she will.
Yes, sir. I guarantee you. Lord willing, I'll come back and show it to you. I was looking forward to that one.
I think none of that I have to hold to. When is she gonna pay me my money?
You still,
You know, it's been nice chatting with you, but
I mean, I just don't have it. I'm honest with you. I don't. But,
so he's still here with you?
yeah, I actually
Bet you're
married
being
him.
quiet this time.
Yeah, I
He
married
was
him.
jumping
so
up and down last
maybe
time I
that's what
threw
got
you
him quiet, huh?
Huh?
I married him, so maybe that's what got him quiet.
Oh, y'all got married?
Yes, we did. What you look like that?
I just,
You didn't think?
I thought he was gonna run it. Whoa.
Now, you know, that's bad.
I'm just
So
saying.
bad.
I'm just saying. One day,
Oh, you didn't think
he
I
was
was
looking,
gonna run. You
looking
thought
like,
he
he
was
was
gonna
like looking, winking at me like, take her so I can run.
run.
That's what I was getting from him. I'm just saying.
See, that's not the memo I got.
Well,
See,
I'm just saying,
I get it. I understand.
he and I were communicating.
Clearly.
And
Yeah.
so that's how I saw it. I guess I was wrong.
I can see that, you know.
All right.
That's God thing. It's okay.
It is a pleasure seeing you. It is
Always
a
a
pleasure
pleasure
to
seeing
see that you are actually doing well and
Thank you.
doing the right thing.
Yes, sir. I'm doing my best.
So here's what I'm gonna do.
Yes, sir.
You already have paid the state fees, so I'm just gonna waive the entire balance.
Oh, God
I'm
bless
gonna
you.
just get rid of everything. I'm doing that mainly because of, if you have a daughter that will come up and say those great things about you, then I have to, and I believe what your daughter's saying.
Oh,
And so,
not gonna lie, trust me.
well, but that, in a lot of ways,
She'll say good, she'll say bad. That's what
it's a lot of ways, that's what life's about. You raise kids, and when they can say good things about you, you've done your job.
It is.
So here's what I'm gonna do, on your promise, because
Yes, sir.
I would,
Oh, you're not the boy.
so I'm gonna waive that entire balance
Okay.
on your promise that when you have that degree, you come back here and you show me that
You
degree,
think I'm not what I am? Oh, my God. I can't-
right? If you don't,
Okay. Well, okay.
if you don't come back and show me the degree and I find out that you got the degree, Alan and I are getting in the truck, we gonna find it,
Oh, my God.
okay?
Not you and Alan.
Yeah, both of us,
Oh,
both of us.
okay.
All right, fair enough?
Well, Alan, for sure.
I don't know what that's about. All right.
Okay.
You take care of yourself.
God bless you. Thank you so much, Justin.
Bella, you take care of yourself.
It's good to see you, Jeremy. You do good.
Yes, ma'am. Thank you so much, guys.
We'll see you. All right. Take care of yourself.
No sovereign citizens, right, Judge?
Yeah, it is. Yes, sir. Court calls the case, people versus Aaron Ticini.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Ticini. She is in inpatient, is he here? Oh,
He's here.
He's an inpatient at Dawn Farm. He said he was gonna attempt to pay it. Just make him, okay. Go ahead.
I'm not an inpatient.
Oh, okay.
I was an inpatient for 3 months, which is why my payment stopped. I talked to Alexis yesterday. He sent me the paperwork and said after I had court today to send it back to her and I can start back on my payment plan, so.
All right.
Well, congratulations, Mr. Pacini.
All right.
Thank
great.
you.
So I don't need another date. I'll just send this over to collections. All right, so I'll just refer this over to collections. I'm not gonna give you another date. You get
Okay,
back on
thank
your
you.
payment plan and stay
Yep.
sober, huh?
All right, I appreciate it. Have a nice day.
All right, you too.
All right.
Court calls case People versus Shakira Pillar.
For Ms. Fuller, who may be present via Zoom.
Pillar? They're both on. No.
Your Honor, I was unsuccessful in reaching Ms. Pillar. I do understand that she still does have a balance. For the record, I would request an adjournment of the show cause.
Going to have to balance, okay.
The show, just over 17.
Bench warrant will issue for defendant's failure to appear upon 15,000. I'll give a 10% privilege on that. That warrant will issue immediately. Today's People versus Dexter Pillar.
Assistant Public Defender Natalie Payton on behalf of Mr. Pillar, who should be on Zoom, but he may have dialed in, Your Honor. I believe he is currently at a doctor's appointment.
Pillar? It's the number you have, 81 and then 817.
Yes, Your Honor.
That's him. Yeah, he's unmuted, but. Mr. Pillar? You said he's at.
Can you hear me?
doctor's.
Can you hear me?
Yes, we can hear you
Hello?
now. Yes, sir.
Oh, okay. I'm sorry about that, sir. I'm sorry, sir.
It's okay. All right. He's got a warrant, 1482, that he needs to take care of.
Thank you, Your Honor. I will follow up with him and discuss getting that warrant resolved with him out of court.
All right.
As to the balance, my understanding that is $785 balance. We're asking for an adjournment of the show cause at this time. I was only able to talk to Mr. Pillar very briefly. He states to me he was in a bad accident somewhere recently, which is one of the reasons that the doctor today he has to get treatment and shots. So I would ask for an adjournment of the show cause so I can have a longer discussion with him about getting on track with this.
July 9th, 2025, 9 a.m.
Thank you.
All right, thank you, Mr. Pillar.
Thank you, sir.
Court does call the case, People versus Lamar Pitts. Michigan court rules other cases decided thereunder to the extent of conflict does exist. Given the waivers, the court will consent to hear the matter. Court does call the case of the People versus Jenny Liu.
Ashley Lobby for the people.
Michael Getty, Assistant Public Defender on behalf of Ms. Liu, Judge, who I believe is present here via Zoom.
Yes, she is. Ms. Liu, can you state your name, please?
Yes, sir. Jenny Liu.
Thank you.
Your Honor, I believe we have a resolution in this matter. I have had a chance to speak with Ms. Liu. I believe upon a plea to attempted resisting and obstructing in case 23F10628, that the felony in that matter will be dismissed and the matter 24F10014FY will be dismissed in its entirety.
Correct. The plea sheet that I have indicates she'd be pleading no contest to an added count two of attempted resisting and obstructing a police officer in 1 year offense.
That is
on her successful plea. Count one in that case would be dismissed, as well as the case ending in 014.
Yes, Your Honor, and I have had a chance to meet with her, and I did go over her rights. She understands those. She is a U.S. citizen. There are no PDA issues. Is that correct, Ms. Liu?
I don't need to know that.
Oh, I'm sorry. Judge.
All right.
That is a correct recitation of the agreement.
Okay, very good. Ma'am, if you could please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
All right, state your name again, please.
Jenny Liu.
All right, you can put your hand down. Ms. Lewis, it's court's understanding that in the case ending in 0628, that you're going to be pleading to the charge of attempted resisting and obstructing a police officer. That is a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs. Do you understand that?
Yes.
All right, do you understand what a no contest plea is?
Yes.
All right, two things about it I have to make sure that you understand. The first thing you need to understand is it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
All right. Mr. Getty, the basis for the no contest plea?
I'm sorry, Judge. Potential civil liability.
Ms. Liu, to the charge of attempted resisting and obstructing a police officer, how do you plead?
Guilty. Did you want to plead no contest, Ms. Liu, like we discussed?
I thought that's what it was.
Well, no contest is.
So am I
if
saying
you're
no
not
contest?
If that's how you want to plead, yes.
Okay, yes, sir. Can I say no contest?
All right, let's do. You want to do over? All right. So to that charge, how do you plead?
No contest.
There you go. Now you understand that by pleading no contest, you will not have a trial of any kind.
Yes, sir.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for your trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
You are not. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
Court has been provided and has reviewed Michigan Department of State Police report for their case number 1957-23. Any objections to the court having reviewed that report?
No, Your Honor.
None from defense, Judge.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this case. Counsel, have I complied with the court rule and would it be proper to accept this defendant's plea?
People are satisfied.
Defense is satisfied, Judge.
Court will accept the defendant's plea to count 2 in the case ending in 628, and count 1 in that case is dismissed, as well as the case ending in 014. That case is dismissed. This is a victim's rights case, so.
It is, Your Honor.
Pre-sentence investigation and report is ordered at 14A probation. Sentencing in this matter will be
June 11th at 9 a.m.
June 11th, 2025, 9 a.m. before me. Bond will continue in this matter. Okay.
Thank you, Your Honor.
Thank you, Ms. Liu.
Okay, so on June 11th, what's gonna happen? I'm coming back.
Yes, you'll come back and I'll impose sentence. I can't do it today because the victim has to be contacted in case. And so otherwise I would send it to you today. But yeah, you'll come back on the 11th.
All right, Your Honor, thank you.
All right, thank you.
I'll talk to you before then, Ms. Lou.
Okay.
Court calls the case of the people versus Jacob Dorston.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Dorston, who is making his way to the podium, Your Honor.
Your name, sir?
Jacob Dorston.
All right, what are we doing on this case?
Your Honor, Mr. Dorston would like to set this matter for preliminary examination. We have had discussions with the people, but he'd like to set this matter. Discovery is complete to the best of our knowledge.
So he's not requesting the adjournment on the,
Oh, no, Your Honor, that's my fault.
well, no, that was from last time. I'm sorry. All right. So all discovery is complete.
Yes, Judge.
People have their witnesses available the 27th. Preliminary examination in person, May 27th, 2025, 9 a.m. That's before Judge Freshour.
Thank you, Judge.
Bond will continue. I need that. 27th, before Judge Freshour. Bond continues.
Thank you, Your Honor.
Thank you. Court calls case of the people versus Kennedy Braddock.
David I. Goldstein appearing on behalf of the defendant.
All right, thank you.
That wasn't me.
I know.
This time.
All right.
Your Honor, we've executed a waiver form. We're going to be waiving exam seeking resolution in circuit court.
Is that correct, ma'am?
Yes.
You understand the preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and if you committed them.
Yeah.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yeah.
People also waive the right. Preliminary examination having been waived, defendant is bound over to circuit court on both counts.
Your Honor, we acknowledge receipt of information in this matter. My client waives further reading, stands mute, asks that a not guilty plea be entered.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
At 1:30 p.m. with Judge Conlon.
July 9, 2025, 1:30, Judge Conlon.
Thank you, Your Honor.
Thank you. Bond will continue. Court does call the case of the people versus Anthony Flanagan.
Joseph and Colin, the people. David I. Goldstein appearing on behalf of the defendant.
Your name, sir? Anthony Flanagan. Thank you. What are we doing?
Your Honor, as the court is well aware, there was a competency evaluation done in this matter. We are now going to be asking for an evaluation on criminal responsibility, but we'll do that in circuit court. So we're going to waive exam.
Okay. All right. Is that correct, sir, that you're waiving your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes.
All right. You understand that you'll not have that hearing, you'll proceed to circuit court for further resolution?
Yes.
People also waive their right?
We do, Your Honor.
7, 6.
Your Honor, we acknowledge.
Preliminary examination having been waived, defendant is bound over to circuit court on counts 1 through 5 with 6 following. Go ahead, Mr. Marshall.
Your Honor, we acknowledge receipt of the information in this matter. We waive its further reading. My client stands mute, asks that a not guilty plea be entered.
Defendant having waived formal reading, standing mute to all 6 counts, court will enter a not guilty plea. Pretrial will be set for
June 3rd at 1:30 p.m. with Judge Conlon.
June 3rd, 2025, 1:30, Judge Conlon.
You're all set.
Bond continued. Thank you. Court does call the case, people versus Corey Craig.
Come in. Okay, I was out in the hallway.
And
David I. Goldstein appearing on behalf of the defendant.
Your name, sir?
Corey Craig.
All right. What are we doing?
Your Honor, I was prepared to ask the court for an exam date, but I was informed this morning when I got here that there may be some media that has not been provided as of yet.
And that's correct, Your Honor. I did put in a request for media discovery yesterday as well for the 911 call. I have not received that.
All right. And what time would you be available on 29th?
Oh, I'm looking at the 27th for some reason. Yes, Your Honor.
All right. Probable cause conference will be adjourned May 29th, 2025, 9 a.m. Bond will continue.
Thank you.
Court does call the case of the people versus Haley Gregg.
Good morning, Your Honor. Great to see you. Christina Costantino appearing with and on behalf of Haley Gregg.
You're over there. Your name?
Haley Gregg. Judge, this is a date and time set for a PCC, and we have reached a resolution in this matter. I do have a plea agreement if I could present that to the court.
Okay, so how am I going to accomplish this?
Do you mean because it's a no contest plea? Or
And I don't have a report.
I do have a clean copy of the report, if I could also present that to the
So I'm
court.
supposed to read that now.
I know, Judge, I apologize.
Okay, the plea agreement indicates that she's going to be pleading no contest to the charge. The maximum penalties on here either.
That would be my fault. Judge, if I could, the maximum possible penalty is 1 year.
Maximum fine.
That one's a good question, Judge. It's $4,000.
That it goes. 1,000 on the attempt. Yep, we're rolling along in this.
Sorry, Judge, I had to come along and
Home. And
mess
I will
everything
blame
up.
both of them all day for this.
So
Not you.
sorry.
You're good. This is not your fault at all.
No, it's not.
I am looking at the attorneys that don't seem to be ready.
Very sorry, Judge, very sorry.
What's the maximum? Well, hang on, folks. The maximum penalty on this is going to be, give me the max on unlawful use and just cut it in half.
My understanding, the max on unlawful use is 1,500.
It's
However,
1,500.
it says if the case is a first offense, the court may reduce the punishment for imprisonment or the fine of not more than $500. So the maximum would be 1,500. The court could, of course.
On the principal charge, it would be
Yes.
1,500, which means on this attempt, it's 750.
That would be my understanding. My math is not great, but it seems right.
Is she signed an advice rights form?
Judge, I'm sorry.
So let's see. We called one case of Constantino's, and I could have done like 8 cases.
I know, Judge, I'm so sorry.
No, it's okay.
It is unfair.
I
It's
have,
hard to get the
I have no
signature when there's custody.
problem waiting. I don't think the rest of these people have that same feeling.
I understand. I apologize to all of my colleagues. Agent, I missed as well.
It's on there.
Okay. All right. Are we finally ready?
I think so, Judge.
Yeah, let's see. May I have her sworn?
Raise your right hand. Do you solemnly swear in the firm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Haley Gregg.
All right. Ma'am, it is this court's understanding that you are going to be pleading no contest to the charge of attempted unlawful use of a motor vehicle. That is a misdemeanor punishable by up to 1 year incarceration and a $750 fine plus court costs. You understand that?
Yes, I do.
All right. Do you understand what a no contest plea is?
Yes, I do.
All right. 2 things about it. I have to make sure that you understand it. First of all, means that you're not further desirous or wanting to contest this charge. Hear me?
Yeah, I can hear everybody else.
Okay. You understand that it means that you're not willing or wanting to contest this charge?
Yes, I do.
All right. Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that? You understand also that while I'm taking your plea, I would not be your sentencing judge. You would be sentenced before Judge Perry in the 15th District Court.
Yes, I do.
All right. Now understand, and the basis for the no contest plea.
Potential civil liability.
All right. Understanding all of that, do you still wish to plead no contest?
Yes, I do.
And to that charge, how do you plead?
No contest.
Now you understand that by pleading no contest, you will not have a trial of any kind.
Yes, I am.
All right. You signed an advice of rights form, is that correct? A question regarding any of those rights? You'll see a copy on the podium. Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up, pleading no contest, you'll be giving up those rights as well as all the rights on that form.
Yeah.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you?
No.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily?
Yeah.
Of your own free will? And because you believe that you are indeed guilty? Or I won't ask you that. Never mind. Court has been provided Ann Arbor Police Department report for their case number 25-17-355. Any objection to the court reviewing that report to form the factual basis?
No, Your Honor.
Based upon the review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt. To the defense counsel, have I complied with the court?
You have, Judge.
Yes, sir.
Court will accept the defendant's plea of no contest. 2 count 2, count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court. Probation sentencing in this matter will be
June 6th at 10 a.m. with Judge Perry.
June 6, 2025, 10 a.m. before Judge Perry.
Thank you, Your Honor.
Thank you.
Would the court allow me to address Ms. Gregg's bond?
Sure, let's spend all day on this. Go ahead.
Sorry, Judge. Your Honor, her bond is currently $5,000 with a 10% provision. She's unable to post that bond. That bond was set in mind with this charge being a felony. She has now pled to a 1-year misdemeanor. She spent the last 50 days incarcerated. Should she be released, she does have stable housing. That would be in Ypsilanti with a friend. She does also have employment lined up as well, should she be released.
we would ask if the court would consider a personal bond. She's also been in touch with community mental health, and she will be working with them upon release.
Response.
Mental health, we would not have objection to the lowering of the bond.
Okay, I will for a bond to a $5,000 personal recognizance bond. Defendant, and with the condition to maintain contact and communication with community mental health. Okay,
Thank you very much, Judge.
you're good.
Oh, yeah.
All right. Follow through on everything.
I will.
You hear me?
Yes, I will.
All right, thank you.
Thank you, Judge.
Court does call the case of the people versus Antoine Pitts. Speak French again. Antoine Pitts? Really? So where's is there a prosecutor on this too? What?
Is this your case? You know, the two of us are looking at each other like, who, what? David I. Goldstein, appearing on behalf of the defendant. I didn't have this on my calendar for some reason, Judge. Apparently neither did she.
All right.
Your Honor, I received a email from Mr. Pitts last night. Apparently he's having a medical problem. He did send me a medical letter indicating he's been ordered for bed rest and oxygen. I'm trying to find it so I can show it to the prosecutor in the court.
Well, when did that happen? Because I issued a bench warrant for him without bond because he has not done anything at community corrections.
That was within the last couple of days, Your Honor.
So this bench warrant was ordered before that. It's back in the earlier part of May. He's not been in contact with them.
Okay, I will, I did see some kind of a bond violation report, Your Honor. And that's why I assumed it wasn't on today because the warrant had been issued, so.
I'll leave the bench warrant outstanding, and then, he's having a medical issue, you can send it in a recall, and I'll look.
Well, I'll get in touch with him. We'll figure out what's going on.
All right.
Thank you.
Thank you. Court does call the case, people versus DeBassier Hennings.
This will go much smoother. Christina Constantino on behalf of
I do
Mr.
not believe that's true.
Mr. Headings, can you please state your name for the record?
DeBassier Henning.
Thank you.
Judge, this is a date and time set for our PCC. We have just recently, as of yesterday, received some additional discovery that has led me to believe that there is some additional outstanding discovery. So given that, we would be asking for an adjournment of the PCC.
We do have a great sheet.
I do.
Oh. We're sharp here.
See, I told you to be smoother.
Yeah.
Mr. Headings said actually on the 3 p.m. block with Ms. Markwell. I saw her actually in the courtroom 2 minutes ago. So I just wanted to make the court aware that his social media will be here this later today.
All right. June 5th work for you? Well, I can do the 29th. Will that be better?
If we could do the 29th, that would be great.
Probable cause conference, May 29th, 2025, 9 a.m. Bond continue.
Thank you very much, Judge. Have a good rest of your, out of your hair.
You're done?
I'm out of your hair.
Really? You're done. Took up 4 hours. Now you're done. All right. Have a great day. Time I don't get back. Court calls the case. People versus Reno Save.
David I. Goldstein, appearing on behalf of the defendant. Your Honor, the defendant is not present. He can be on Zoom if necessary, but we had already been notified this matter was going to be dismissed prior to today. I believe that Ms. McDuffie has an order for the court.
Well, is that correct? It's going to be dismissed?
That's right.
No objection?
No, Your Honor.
Case is dismissed. Is he in Zoom? Mr. Alve, sir, state your name.
Yeah, good morning, Judge. Reno Suave.
All right, your case has been dismissed. I'm assuming you don't have any objection to that.
No, sir.
All right. Have a great day, sir. Thank you.
Thank you, Judge. Appreciate it.
Court calls the case, people versus Cedric Johnson.
Morning, Your Honor. Edward Lucas on behalf of Cedric Johnson.
All right. Your name, sir?
Cedric Johnson.
All right.
At this time, we'd like to set this for a preliminary examination
All right, he does have the bond violation.
for the new case.
Was there another case coming?
There's another case that he's got
Pardon?
he has a misdemeanor charge that came through from, that was the bond violation in this case.
This one, this is the one where he is a double contact.
That's correct, Your Honor. There's a, history account of DD in 1482.
But that's not considered a violation of this one?
No, it is, Your Honor. There's a rate on that case on 512.
We just did an arraignment, last week to get this date. Or was it on the arraignment?
It was on.
The arraignment was on Monday this week. And he got this PCC date to go in front of you.
Right, but there's a bond violation, is what I'm indicating.
If the court has it. I mean, I'm in receipt of understanding that there's a new case that I would anticipate being that bond violation. Because he wasn't.
Well, I don't know that. He was arraigned on a
He also failed.
bond violation.
He failed to show up at the exam.
That case is the bond violation.
Okay. Well, what am I gonna do with the bond violation at this point? I mean,
It's difficult to address if he's got a pending case.
well, at this point, his bond is revoked in any event, so it's gonna be revoked. You want this set for preliminary examination? Why is this one listed? What's this my case? No.
It was previously
set before.
Yes, it was an exam that was set. And
That's what I thought.
He failed
It was
to-
set before me.
yeah, he did turn himself in last Sunday. He had the mix up of the court.
So all discovery is complete.
Yes, Your Honor.
People have their witnesses available. My next date is June 3rd. Preliminary examination will be set June 3rd, 2025, 9 a.m. That's before me. Court calls the case of the people versus Areli Zara Vilches.
Ashley Lonnie for the people.
Good morning, Judge Lawrence H. Margolis, and on behalf of Mr. Raza Vilches, Ashley Areli, please state your name.
Good morning, Judge. Areli Braza Vilches.
Okay, what are we doing?
Judge, it's the first meeting. I believe we're waiting on some discovery. I'm asked to adjourn it, and I would defer to the prosecutor as to the time she would like.
There is outstanding discovery, specifically the autopsy, as well as the lab results. So that's going to take a little bit of time. I can't say with any definitive
Understood.
facts how long, but it's gonna take at least a few weeks, I would think.
Probable cause conference will be adjourned June 12th,
Could people be heard on bond?
2025, 9 a.m. Yes, that's the bond.
Could the court inform us how many times the defendant is testing per day? She's on a silver link. I couldn't quite tell if she got a silver link or a scram.
So she had.
I have her on a location tracking. I think I have her on a scram.
Excellent. Thank you, Your Honor. Nothing further.
Bond will continue with its conditions. Thank you.
Thank you, Judge.
Court calls case people versus Danielle Landeman.
Carolyn Foster Tucker on behalf of Danielle Lampman. Danielle Lampman.
Thank you. Yes. All right. Record should reflect we had a bench conference. What are we doing on this case?
Your Honor, we're requesting a preliminary exam,
And all discovery is complete.
to my knowledge.
People have their witnesses available the 27th. Preliminary examination in person, May 27th, 2025. 9 a.m. That's before Judge Washington. I will also execute an order that defendant, to the extent we can, her mail privileges or ability to send mail will be restricted. I'm just not sure how that's going to look, but we're going to shut down her potential communication with the alleged victim, in this case, the best way we can. All right. Thank you. I'm going to need an order that says that kind of. Court calls the case, people versus Michael Hill.
Good morning, Your Honor. James Fifelski on behalf of Michael Hill, who unfortunately is not here. I just went out to the hallway to check to see if he was present and did not see him. I've called him a couple of times and wasn't able to leave a voicemail message. So just for the sake of the record, I would ask for one brief adjournment.
He already has a bench warrant out.
Okay.
So his failure to appear, I'm just gonna leave the bench warrant out.
What, is there a bond set on that or just a?
He has no bond.
No bond. Okay. Thank you, Your Honor.
Court does call the case, People versus Angelica Towers.
And is it on behalf of the people, Your Honor?
For Angelica Towers.
Angelica?
Thank you. All right, what are we doing?
Your Honor, there's some negotiation and I'm asking for an adjournment today. I'm asking for a short adjournment. And I understand that the bond violation.
Pardon?
Maybe a bond violation as well.
Yes, violation of her, no contact order.
That's correct. I have the understanding, I was contacted by the complaining witness in this case. I was told that he had spoke to the victim advocate, two of them, and he would like to address the court today.
For what reason?
To allow contact.
That is correct. He is here to request contact.
In light of the bond violation? I'm not gonna do it that way. I mean, I have an alleged bond violation. I have somebody coming through wanting contact. Okay, I don't. What I will do, probable cause conference, I will adjourn to May 29th, 2025, 9 a.m. I will also set it for a bond violation hearing at that time. And then I'll hear from the parties. So actually that's, yeah, on that day. For probable cause and the bond violation here. Bond at this time will continue. Thank you. Court does call the case, People versus Julia Sosinski.
National Line for the people.
Your Honor. James Fifelsky on behalf of Ms. Szynski. State your name for the record, please.
Julia Sosinski.
All right, I have before me a plea form that indicates that the defendant would be pleading guilty to the charge of use of heroin, a 1-year misdemeanor. Upon a successful plea to that charge, the felony would be dismissed. There's also the agreement between the parties of no 7411, delay, or deferred.
That's correct, Your Honor.
That's correct, Your Honor.
Ever sworn.
Raise your right hand. You solemnly swear to affirm the testimony you're about to give the whole truth and nothing but the truth, so help you God.
Yes, I do.
Take your name.
Julia Sosinski.
Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of use of heroin. That is a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. You understand that?
Yes, Your Honor.
You also understand that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Freshour in the 1483 District Court. You understand that?
Yes, Your Honor.
All right, understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form today, is that correct?
Yes, Your Honor.
Any questions regarding any of those rights?
No, Your Honor.
Please look at paragraph 5 on that form. Those are your rights which are part of the trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you in any?
No.
You're doing this voluntarily,
Yes, Your Honor.
of your own free will,
Yes, Your Honor.
and because you believe that you are indeed guilty of this offense?
Yes, sir.
On the date of April 3rd, 2019, location of US 23 near North Territorial Road, Northfield Township, Washington County, State of Michigan. Did you have heroin in your possession?
Yes, Your Honor.
Did you use it?
Yes, Your Honor.
And did you know what you were using was heroin?
Yes, Your Honor.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Before that time.
Defense is satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. The pre-sentence investigation and report is ordered at 1483 probation. Sentencing in this matter will be
June 16th at 9 a.m. for Judge Freshour.
June 16th, 2025, 9 a.m. before Judge Freshour. Bond with its conditions will continue. Thank you.
Thank you very much, Your Honor.
Court calls case People versus Larzell, Washington.
Good morning, Edward Hughes on behalf of Washington.
How you doing, Your Honor?
I'm doing great. What's your name?
Larzell in Washington.
Thank you.
Thank you, sir.
Your Honor, we had referred this over to the recovery court. I spoke with them and they indicated that they've in receipt of all the information to do an intake. However, they have not done that interview. That interview could be completed within a week. Like if we could have a 1 week adjournment.
Probable cause conference, May 22nd, 2025, 9 a.m. Bond continue. Court calls case People versus Marquis Fab.
Oh, excuse me, sir. Yeah. Can I please have a word? With all due respect.
I think Mr. Washington would like to address Bond.
Excuse me, go ahead. How you doing, Your Honor? My name is Larzell near Washington. First and foremost, forgive me about my outbreak last time I was here.
Can I have that file?
Thank you, sir. What happened was, I wasn't aware, as my attorney indicated, what day was my, probable cause hearing was. Okay, I went back to the magistrate. They said, no, well, we're gonna let Judge Simpson handle it. Then last time I came here, it was a 2-week hold because they didn't do their job. I feel I shouldn't have to
They
be.
didn't, who didn't do their job?
What you say? You gave him a plea.
The recovery court?
Well, I didn't ask for no recovery court, but whatever assessment you gave him, it was 2 weeks. And the honorable judge said, okay, well, I'm not gonna change his bond. Now, you still didn't indicate I was looking for a bond. And I wasn't even aware of a drug court. So with all due respect, I do appreciate you, but I did, unfortunately, miss my court date.
Right.
I was,
And then how'd you come into custody?
oh, I came into custody? What, trying to, being a good Samaritan. Some woman was being stalked and they figured out what my name was, and I totally forgot. I really didn't know what court date it was. And I was disciplined for the first, and in discipline, well, not necessarily discipline, you allow it to, override until they took care of their own situation, but it's not my fault.
So who is they?
Would you explain to him?
Well, I think I got to collect more of that story.
Okay, you gave him a piece of paper about assessment along with a plea. Okay, I get here today, the assessment I took care of. Right?
You just want them to speed up the process.
No,
I
it's
think
not them. It's not his fault. He's a judge.
Thank you. Thank you. Thank you. Thank you. Thank you. That's right. Nothing is my fault.
No, it's not.
That's right. I know.
Amen. So I'm saying, I'm just trying to, sir, live my life. I normally work carnival shows. I have really been disciplined for not being aware of to show up. I'm not dumb enough not to show up again.
Excuse me one moment. Whose phone is that? It's somebody down there's phone. Is hers? Tana's phone? Really? Go ahead, sir.
And I'm not ignorant enough not to show up in front of Judge Simpson courtroom again.
I think he is saying that he would show up to court next time. He's asking for a PR bond.
Yes, I am, sir.
If the court would not provide a PR bond at this time, if the court would allow an interview to take place, if that interview takes place, then the court provide a PR bond.
I never said that. I asked, could you please provide a PR bond? And I will.
I addressed this the last time you were here.
What was it about?
I think they're going to keep you in.
All right, man. You fired. God bless you. And thank you, Your Honor.
Why is he fired?
Because it's not speaking up for me. I really don't even know what's going on.
Oh, it would, okay, so does he understand before you make that final decision about firing him?
Well,
it wouldn't have mattered whether you spoke or he spoke. I'm denying your motion. I've already heard it.
Well, I don't know. Why are you denying the motion? And what's so funny?
Because you appeared here, didn't show up, didn't turn yourself in, got picked up, got brought here.
Yes.
That's how we got you back.
And
so I'm not releasing you
right,
now.
The magistrate.
Okay, so
did not release me, and then
that's right.
You didn't release me because
that's right.
You wait for assessment. Am I correct?
And I haven't had the assessment yet.
Exactly. So is it my fault? You haven't had assessment. It's your fault.
It's my fault. I thought nothing was my fault.
So whose fault is it?
I don't know.
But it's not mine. You do agree?
No, I don't agree.
The assessment.
I don't know whose fault it is. It hasn't happened. I'm done.
Pretty much. God bless you.
Thank you.
Thank you.
Well, keep talking. Why are you up here at my why are you at my podium? Why are you at my podium? Next time, Tana, turn your phone up louder when that's going on. Did I call your case?
Yes, you did. You called Mrs. Beth, Marquis Beth.
Oh, that was so long ago. You're right. You are right, Miss Cannon. And I usually criticize you for not getting up here on time. And I have to give you credit that you're like early.
Got it, Judge.
Court calls the case, People State of Michigan versus Babb.
And then on behalf of the people, Your Honor.
Stephanie Cannon, on behalf of Mr. Babb, should be appearing by Zoom. Oh, thank God.
Mr. Babb?
Please be there.
So what had happened?
Marquise Bab, you need to unmute and turn on your camera. Every week, Cannon. Every week.
I was doing my part today. Your Honor, we're just setting it for a preliminary exam.
What?
We're simply setting it for the preliminary exam.
I gotta have him, I don't know who, I gotta have him here. Oh, you're just gonna call him?
Yep.
Never mind. I'm gonna say something. This is practicing law by Janaza. That's what you're doing right now. This is,
Great, he got it.
yes, acting really, this is so you. You're like, what? Oh, uh-oh. Mr. Bab?
Yes, sir, Judge.
All right, you got your camera on?
You need the camera as well?
Yes, Mr. Babb.
That is his camera on.
Yes, it's already.
Is that Mr. Bab?
That's Mr. Babb, Your Honor, yes. The good news is he'll be here in person the next time. Your Honor.
I won't be here to witness it. It's going to somebody else. All right. Your all discovery is complete, Ms. King.
Yes, Your Honor. Discovery is
People
complete.
have their witnesses available the 27th. Preliminary examination in person, May 27th, 2025, 9 a.m. That's before Judge Fresh Hour.
Thank you so much, Your Honor.
Thank you. Bond will continue. Courthouse case of the people versus Marvin Sullivan.
Andrew Childers, appearing on behalf of you.
James Fifelsky appearing on behalf of Mr. Sullivan, who is approaching. State your name for the judge, please.
Marvin Sullivan.
Thank you. Your Honor, this is the first PCC. I'm asking for an adjournment for discovery and investigation, so I can review discovery with my client, and if I could possibly address bond, I would appreciate it.
Probable cause conference, May 29th, 2025, 9 a.m. I need a screen sheet. Okay.
Your Honor, I know you hate it when I do this, but I actually have a trial in Wayne County that day. Could we do the 3 weeks out?
June 5th.
Thank you very much, Your Honor.
2025, 9 a.m. Esteban.
Your Honor, it's my understanding a $10,000 bond has been set in this case. My client has a lot of family in and around Romulus. He would reside with his mother in Romulus if he were bonded out. Has been gainfully employed doing demolition work out in Detroit, has 3 kids, custody of, I think, 2 that are in Michigan. And to my knowledge, I haven't had a chance to verify this, but it does not have any prior convictions involving firearms or assaultive activity. And I believe that while he has another pending case, that case has a PR bond. So I would ask the court to consider a low cash bond.
What's his other pending case?
No.
I'm not sure.
I got to talk to driving without ops on the person.
Maybe a misdemeanor case?
So he's got another weapon charge.
Apparently so. I don't know anything about it, but it has a PR bond, so.
But that case preceded this one. And then he picks up this one.
I don't know.
Actually, the other case that he has is the other issue is that the defendant does have an extradition warrant from Mississippi. And we haven't, and I did verify, I spoke with Ms. Burton Harris yesterday about this in our office. We're awaiting the actual governor's warrant from Mississippi, but we can verify that there is a warrant, warrant for an out of Mississippi.
But we don't have the governor's warrant yet.
Correct. And so it just, so there is a CCW, Mr. Sullivan has a pending CCW charge now, 8/27/22. And then the facts of this case, I believe, false. So that the older CCW, which is still pending, predated this offense. Mr. Sullivan does have a prior CCW conviction under HIDA, 2012. And obviously this case involving possession of firearms, shooting it in the vicinity of a Washington sheriff's deputy training canine in the back of the parking lot. It's not charged with, he wasn't charged with shooting at that deputy, but the reason this came to law enforcement's attention was the deputy was training and heard gunshots and saw a car drive off. And our allegation is that Mr. Sullivan was shooting, basically casting out his new gun that he shouldn't possess in the vicinity of the deputy. I'd ask the bond, frankly, $10,000 bond.
But it's low. Anything else?
Nothing further, Your Honor.
Didn't think so. Bond denied, most of the bond reduction is denied. Bond will continue. Thank you.
Thank you, Your Honor.
Court does call the case of the people versus Cassandra Gray.
I'm busy probably handling her case, so. Your Honor, Assistant Public Defender Jay Bellinger on behalf of Ms. Bohr. Ms. Bohr, can you please state your name for the record?
Cassandra Rainbow.
Court has before the plea form. Is that what we're doing?
Yes, Your Honor, I have an advice right before me.
All right. Plea form indicates that the defendant would be pleading to an added count 3 of operating while intoxicated second offense, the 1-year offense. Upon a successful plea to that charge, counts 1 and 2 would be dismissed. That's the court's full understanding of the agreement.
That's our understanding as well, Your Honor.
That the people's understanding? May I have the defendant sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Cassandra Bohr.
All right, ma'am, it is the court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated second offense. Is that correct?
Yes, Your Honor.
All right, that is a misdemeanor, punishable by up to 1 year incarceration, a $500 to $1,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
You understand that the court could also order community service, any rehabilitative services support deemed necessary. Could order your vehicle immobilized. Could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, Your Honor.
All right. You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. You
Yes, Your
understand?
Honor.
All right. Now, understanding all of that, you still wish to plead guilty.
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Anybody promise you anything other than what's been stated here today to get you to plea?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
May 27th, 2022, at the location of US 12 and East Horse Road in Ypsilanti Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes, Your Honor.
What'd you have and how much?
I had drank beer during the day, ate, and then I went to a bar and I had liquor, a couple drinks at the bar. I hadn't drove it all that day other than returning home that night when I got pulled over.
And Your Honor,
Were you stopped by the police or was there an accident?
I actually hit a ditch with my boyfriend's car and yeah,
So there was
police were
an
called to the
accident.
scene. I couldn't get out.
Didn't
of
do
it.
that on purpose, did you?
No, Your Honor.
So there was an accident? Not with
Yes, Your Honor.
beer. All right. Did the police arrive?
Yes.
All right. Were you ultimately arrested?
No, Your Honor. I was taken to the hospital for a blood withdrawal. And then I talked to my
But you were taken there in a police car in,
Well, yes, Your Honor.
right?
Yes,
So you were arrested.
yes,
You weren't free to leave at that point, correct?
correct.
All right. There was a blood draw.
Yes.
All right. What were the results of that blood draw?
Your Honor, we would stipulate to .277.
277? Ma'am, do you have any reason to dispute those blood test results?
No, Your Honor.
Had you previously been convicted of operating while impaired on or about April 18, 2013 in the 18th District Court and or operating while impaired on or about June 30th, 2014 in the 34th District Court out of Romulus?
Yes, Your Honor.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report and screening assessment is ordered at 14B District Court. Sentencing in this matter will be
July 3rd, and with Judge Washington.
July 3rd, 2025, 10 a.m. before Judge Washington. Bond with its conditions will continue. Thank you.
You're all set, okay?
Court calls the case of the people versus Kenia Jackson.
Ashley Lonnie for the people.
Here on behalf of Mr. Jackson, I don't know if Mr. Jackson is joining us.
Who do you have?
He's pulling on Jackson right now.
Okay,
He's pulling Jackson right now.
okay, thank you.
Good morning, Your Honor.
Your appearance.
Yes, Your Honor. Ashley Lonnie for the people.
Hugo J. Macaron, appearing on behalf of Mr. Jackson.
Morning, ma'am.
Nia Jackson.
All right, what are we doing?
Your Honor, I've had a brief conversation with the prosecutor. I would ask that you allow both of us to approach the bench or something that I need to inform the court of.
Approach.
Thank you, Your Honor. We would mutually request, myself and the prosecutor, that we.
I need a green sheet prepared. I'll adjourn probable cause to May 22nd,
Yes.
2025, 9 a.m. Bond continued.
I can put that we requested, it doesn't matter.
Court calls the case, People versus Michael Brooks.
Public Defender Jay Bellinger on behalf of Mr. Brooks.
Michael Brooks. Need to unmute and state your name, please.
Can you hear me now?
I can hear you now. State your name.
My name is Mr. Michael Brooks.
Thank you.
Your Honor, we are just requesting a step for examination at this time. All discovery is complete to the best of my knowledge.
People have their witnesses available the 27th. Preliminary examination in person, May 27th, 2025, 9 a.m. That's before Judge. That's before Judge Washington.
Thank you, Your Honor.
Bond will continue. Court calls the case, People versus Kyle Burmeister.
And then on behalf of
Assistant Public Defender Jay Bellinger on behalf of Mr. Burmeister in case ending in 5078, Your Honor.
James Gladfelski appearing on behalf of Mr. Burmeister on the case ending 5028.
Burmeister, can you please state your name for the record? Your Honor, we're just requesting a 3-week adjournment for purposes of him going inpatient. He's just awaiting a bed right now.
That is correct, Your Honor.
Probable cause conference, June 3rd, June 5th, excuse me. 2025, 9 a.m. Bond will continue.
All right. Sit up here, not doing anything. Okay. Thank you, Your Honor.
Court does call the case of the People versus Winona Harvey.
Harvey.
Morning, Your Honor. Hannah Mack, requesting permission to practice under Michigan Court Rule 8.120 under Public Defender Brian Bowling.
Permission to practice is granted. Good morning.
Thank you, Your Honor.
All right. Ms. Harvey, can you state your name?
No, I can't. I know, you got, my last name is Michelle. Who are you? Where are you?
I met with you in jail yesterday.
Look, if it's gonna skip, okay, yeah, okay.
All right. You're Miss Harvey?
Yeah.
Okay. You're seeking an adjournment?
I am, Your Honor.
No, not you. I'm not Miss Harvey. People don't miss Harvey. I'm Harvey. I'm Harvey like that. People don't miss me, but I'm Harvey.
Okay, maybe she doesn't want to be addressed as a Mrs.
Understood.
I don't miss. People don't miss me or nothing. I'm Harvey.
Sorry about
My apologies.
Okay.
Probable cause conference will be adjourned June 5th, 2025. 9 a.m. Bond continue.
We'll be in touch, Harvey, okay?
When?
I'll come to
Excuse me, what's going on?
We just adjourned your case. Winona, remember we spoke yesterday and you said.
Until when?
Which date did you get?
June 5th.
June 5th, want to see me?
No, I'm gonna see you before then.
Look, I'm not going back. I can't go back to conference when that hurt my back a lot. That room you took me and hurt my back a lot.
Okay. I'm gonna let you talk to your attorney some other place, okay?
Okay,
Thank you. Shut her, please. Court calls the case, People versus John Fulton.
Deputy Chief Public Defender, and on behalf of Mr. Fulton, he's in the lockup, should be on his way out. Your Honor, today is the date and time set for the probable cause conference. I believe that we've adjourned this matter because we're waiting for a mitigation report. That mitigation report is almost complete, so we'd ask for one more adjournment without the final piece of information we need.
Probable cause conference, May 29th, 2025, 9 a.m. Bond continue.
Thank you very much, Your Honor.
Thank you.
Gotcha. Court calls case, People versus Damon Branford.
Brian Bowling on behalf of Mr. Bransford.
Your name, sir?
Damon Bransford.
Thank you.
I have a green sheet, Judge.
Requesting an adjournment.
I am, Judge.
Will be adjourned to May 29th, 2025, 9 a.m. Bond continue.
Your Honor, may I address one issue of bond? Would the court allow an order for him to be released to treatment if it becomes available?
If I get that order, I will sign off.
I will submit it. Thank you, Judge.
Thank you. Court calls the case, People versus Alan Franklin.
And then we have, Your Honor.
Good,
There it is.
morning, Honorable. Please call the court, David Burgess, on behalf of Alan Franklin.
Your name, sir?
Alan Franklin Jr.
Thank you. All right, what are we doing?
Your Honor, I was gonna ask for an adjournment. I was just received this case Tuesday. I do not have discovery yet. I know I can't fill out a green sheet from Zoom, but I apologize, but just 2 weeks, Judge.
Turn this out to May 29th, 2025, 9 a.m. or if your invite indicates, bond will continue. All right,
Thank you, Your Honor.
I'm sorry, I still wear this tether or the
Pardon?
GPS. I still wear the GPS.
You still have to have the GPS on.
Okay, that's all I need to know. Thank you.
Okay, thank you. Court calls the case of the People versus Rick Artuso. Artuso?
And good morning, Your Honor. Assistant Public Defender Timothy Carrier, on behalf of Mr. Artuso, who is approaching. Mr. Artuso, state your name for the record, please.
Rick Artuso.
Thank you.
Your Honor, I do have a green sheet. We're asking for an adjournment. We're currently in negotiations with the people. I would like to also address bond, please.
Matter will be adjourned May 29th, 2025. 9 a.m. Yes.
Your Honor, in regards to bond, we're asking, Mr. Artuso, well, Mr. Burgess is on one of his matters. I apologize.
Okay, good morning, Your Honor. Please, Honorable Court, David Burgess, on behalf of Rick Artuso, that's the other matter.
All right.
So, Your Honor, in my matter, Mr. Artuso has $1,000 10% bond that was set. He does have a cash or surety bond in Mr. Burgess's matter. Mr. Artuso, it seems as if he went into bench warrant status on Mr. Burgess's matter because he failed to appear to court. He did indicate that he came to court on that date, but he was under the impression his court date was set for 2:00. When he did come, he stated he was here until the building closed and he left. Unfortunately, at that time, our office was not on his case, so he didn't call us. I'm unaware of his communications or if he was able to communicate with Mr. Burgess. So there was no opportunity to have a bench warrant recall.
So how do you come back into custody?
You said you were just in the car that was pulled over.
Yes, I got pulled over. But
So he was arrested on the bench warrant, Your Honor. There are no new charges.
So why didn't he come back to court?
I did ask him that as well.
Okay, and what was the answer?
He did not have an explanation, Your Honor.
Okay.
It was
Go ahead, I'm listening.
He did not have an explanation as to why he did not come back to the court, why he did not, contact the court to let them know that he tried to come. I did explain to him in the future if he's got any issues with his court dates, that the clerk's office is right there at the front, that all he needs to do is speak with them and they'll advise him properly. The issue that we're having is in our case, the resolution that we're seeking to reach would require that he pay some restitution up front. Unfortunately, with him being in custody, Judge, he will not be able to do that. He is hopeful that the court would consider giving him a PR bond. I understand if a GPS tether is necessary to ensure his return to court. He has very minimal criminal history, to my understanding as well, but I'd like to see if he could get out so he could raise some money and pay off his restitution so we could get a resolution.
Sponsoring people.
I would leave it up to your discussion.
If he doesn't appear, doesn't come back, it's got to be picked up. It's going to sit until we can get it resolved. Motion for bond reduction tonight. Bond will continue.
Understood, Your Honor. What do you need to say?
I was gonna ask you, Your Honor, worst comes to worst, I know I could, it's Thursday, I'm scheduled to be married on Sunday, I could come in Monday and I could pay restitution, whatever it takes to pay. Scheduled to be what? Married this Sunday.
That is true, Your Honor. He did inform us of that. I don't know if his fiance and his mother are here, but prior to his being picked up, I think he was scheduled to be getting married this Sunday.
I'm not going to use that as a basis to. I mean, the problem is that you should have come back down to the court. If you waited here all day, you should have come to the court at some point, but we had to pick you up, bring you in. I'm not doing that again. Thank you.
Thank you, Your Honor.
Why? I guess. Still can't say. Yeah, stop. All right, never mind. Court is on case of me versus James Clark.
Good morning, Your Honor. Audra Savary requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Janaz Aikiri Akinruli, representing client Kyle Clark, who is present in person today.
Is that release the one that's supervising you?
That's correct, Your Honor.
How's that going?
It's going very well.
Is it?
Yes.
You don't know a whole lot, so you don't know, right? Never mind. Permission to practice it.
Thank you, Your Honor. Mr. Clark, please state your first and last name for the record.
Shane Clerk. Thank you, sir. All right, what are we doing?
Your Honor, we respectfully request that this matter be set for a preliminary examination.
All right, all discovery is complete.
To my knowledge, Your Honor.
People have their witnesses available the 27th. Preliminary examination in person, May 27th, 2025, 9 a.m. That will be before Judge Fresh Hour. And we'll continue. Thank you, Mr. Clark.
Thank you, Your Honor.
The intern that disappeared, could you just get your last name over to my staff? Appreciate it. Court does call the case of the people of the state of Michigan versus Jeffrey Murphy. Ray.
Morning, Your Honor. May I please have a Burgess on behalf of Mr. Murphy.
Marie Tanha, AKA the phone.
Again, Your Honor, I apologize. Someone dare call my work cell.
What? Somebody called your work cell? I think it was somebody over there. They just, all right. Okay, what are we doing? Your name, sir?
Jeff Murphy.
Thank you. What are we doing?
Your Honor, discovery is complete in this matter, requesting exam be held.
People have their witnesses available the 27th?
I may have a moment.
Yes.
Your Honor, I do want to bring up something else that's concerning this case, and at this point, I'm hoping that the court can warn defendant. I'm sure Mr. Burgess will speak to him as well. Part of this case is defendant posting naked pictures of the victim. Not that they should be anywhere, but certainly places that have put her at risk. They have since taken down, it's my understanding. So if the court wouldn't mind issuing a warning to the defendant about ensuring that does not happen again. And I believe Mr. Burgess is well aware of what I would do if this happens again, so he can have a conversation with his client about.
All right, so these came up after the charges in this case?
Let me double check. Your Honor, we don't know the exact date. I have to look into that.
Okay, but they have since been taken down.
Yes, it's been taken down, which is why I'm asking for a warning as opposed to.
All right. You understand that, sir?
Yeah. Yes.
All right. And Mr. Burgess, you're gonna have a more detailed conversation with him about that?
Yeah, yes, I will, Your Honor. I'm well aware of what Ms. Tanner will do if that's the case. If he does it again, if it happens again, if it did happen in the first place, Your Honor. So.
All right, very good. Okay. And with the people
That's a good thing, Your Honor.
that will work,
Thank you, Your Honor.
preliminary examination in person, May 27th, 2025, 9 a.m. That is before Judge Washington. Round will continue. Thank you. Let's call the case of the people versus Frank Clark.
Okay, I'm sorry, Your Honor. I apologize. We can call that previous case. Apparently I wasn't clear,
Okay,
if you don't mind.
you weren't clear? Okay, I guess, can we get this back?
I appreciate your defendant if it's appropriate.
Well, hold on a second, because I lost Mr. Burgess.
I can call you on it.
Okay, so when he appeared, we'll get him back out at some point.
I'm in the
Can I have-
court. I'm in the court. I'm in the court.
Morning, Your Honor. Mike Gaddy, Assistant Public Defender for Mr. Clark, who's in the court.
Yeah. Thank you, Mr. Clark.
That's for people.
Your Honor, I'd ask the court for a brief adjournment in this matter. We're still talking with the prosecutor in hopes of a resolution.
Probable cause conference will be adjourned May 29th, 2025, 9 a.m. Bond continue.
Thank you. I'll give you a call, Mr. Clark.
Thank you, Ms.
All right.
Take care. Court calls case people versus Scott Jenks.
Yeah, then on behalf of Your Honor, Stephanie Can on behalf of Mr. Jinx.
Jinx it.
I did it. That's not him.
What's up with Cannon's clients?
It's Thursday, Your Honor, so the good news is I do have a plea in this matter, which I can hand to the court and the plea form.
Who do they have?
They were bringing back the other gentleman.
This Jenks?
Stephanie Cannon on behalf of Mr. Jinx.
Scott P. Jenks.
I have before me a plea form that indicates that the defendant will be pleading to count 3 to domestic violence with sentencing under 4A. That's the stated count 3. And the defendant will seek alcohol treatment. He will also be pleading to an added count 4 of attempted resisting and obstructing a police officer to a 1-year offense. Upon a successful plea to those two charges, counts 1 and 2 would be dismissed. That's the court's full understanding.
That's right, Your Honor.
Your Honor, that is my complete full understanding of the agreement.
May I have him sworn?
Raise your right hand. Do you solemnly swear in the affirmative testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name.
Scott B. James.
All right, sir, it is this court's understanding that you are going to be pleading guilty to 2 charges. Is that your understanding?
Yes.
Speak up for the court.
Yes, sir.
The first charge is that of domestic violence. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Yes.
The second charge is that of attempted resisting and obstructing a police officer. That's a misdemeanor, punishable by up to 1 year incarceration or $1,000 fine plus court costs. You understand that?
Yes, sir.
All right. You understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A4 District Court. You understand that?
Yes, sir.
All right. Understanding all of that, do you still wish to plead guilty
Yes, sir.
to the charge of domestic violence? How do you plead?
Yes, sir.
To the charge of attempted resisting and obstructing an officer? How do you plead?
Yes, sir.
How do you
You guys
plead?
say guilty.
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Can you hear him?
I have hard hearing. A
You're okay. We can get some equipment, so let's do that.
little bit lower.
Okay. All right. Is that better, sir?
Yes, sir.
Okay. So up until that point, you heard everything else that I said.
Yes, sir.
Is that correct? All right. So you understand that by pleading, well, I think I was at the plea, so let's just make sure we have that. To the charge of domestic violence, how do you plead?
Guilty.
To the charge of attempted resisting and obstructing, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
No, sir.
Look at paragraph 5 on that form. You'll see a copy on the podium. I'll let you get your glasses. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
of your own free will?
Yes, sir.
And because you believe that you're guilty of these offenses?
Yes, sir.
April 20th, 2025, at the location of 418 North Point Drive, Northfield Township, Washington County, State of Michigan. What did you do involving a Betty Jane Jinx that makes you think that you're guilty?
We got in an argument based off of a family member on her side that was making racial.
Your Honor, may I have water?
Excuse me.
Yeah.
Go ahead.
You got in an argument with your wife
Yes, sir.
and you guys were married, living together?
Yes.
This was at the family home?
Yes.
And during that argument, did you push her onto the couch?
Yes. Yes, ma'am.
Ultimately, the police were called?
Yes, ma'am.
And when the police were called, they attempted to arrest you and you pulled your hands back such that they had a hard time arresting you?
Yes, sir. Yes, ma'am.
Your Honor, do you believe that's sufficient basis for the plea?
All right. You didn't have her permission to push her down on the couch when you did that, did you?
No, sir. She was pushing me. I was just trying to get her off of me. I didn't shove her real hard.
Oh, that kind of slingshotted around.
Yes. Yeah. So, but again, you were having an argument.
Yes, ma'am.
And you did push her.
Yes, ma'am.
You didn't have permission to push her, true?
Yes. Yes, sir.
Yeah, okay, but, sir, you do realize that, I'm not saying it would be successful, but you may be able to assert self-defense in this matter? I don't want to hear your comment on that. You understand that is a possibility?
Yes, sir.
All right. Do you want an opportunity to discuss that with your attorney? Because as it stands right now, I cannot accept your plea.
Okay. Yes. Yes, sir.
Want some time to do that? All right.
Yes, sir.
So let's take him back and I'll bring it back out later.
Thank you, Your Honor. Give that to Mr. Allen.
And just remind us he needs the equipment when he comes back out.
Thank you, Your Honor.
Court calls the case, People versus Deshaun Clifton.
Stephanie Cannon on behalf of Mr. Clifton.
Your name, sir?
Deshaun Clifton.
Thank you. You're requesting an adjournment?
Yes, sir.
Probable cause conference, May 29, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
And I'll call you like.
Court calls the case, People versus Richard Johnson, the second.
Hannah Mackey on behalf of Mr. Johnson, who was to my right. Please state your name for the record.
How you doing today? Richard Johnson.
Thank you.
Your Honor, at this time, I believe we'd like to set this matter for preliminary examination and all discovery is complete as far as we are aware.
People have their witnesses available the 27th.
We can try our best, but I wanted to make sure the court was aware. Mr. Johnson has 2 other cases that are already set for exam next week. That's a short turnaround, so again, we'll try our best to get our witnesses there. I didn't know if the court wanted to put them all together.
Now, is there a reason they need to be all together?
There's no reason, Your Honor.
So he has 2 set next week.
Yes, Your Honor.
Preliminary examination in person will be. So will the people have their witnesses available the 27th on this case?
We'll try our best.
May 27th, 2025, 9 a.m. That is before Judge Fresh Hour.
Thank you.
Bonding this matter will continue. Thank you. Calls case People versus Antoine Coleman.
Good morning, Your Honor. Student Attorney Andra Sabri on behalf of Mr. Coleman, who is present in person today. Say your name for the record, sir.
Antoine Coleman.
Your Honor, we are requesting an adjournment.
Why you tell, you know what to do? Why, just quit interfering until it's necessary. Just leave her alone.
Thank you. I don't know if you know something. How much time did you want, counsel? Don't look at her.
Your Honor, we are waiting for him to complete his assessment for drug treatment court, so however much time the court sees fit.
See, you did that all on your own. You didn't need, she wouldn't have told you that. She would have started picking numbers.
Which court is he waiting on an assessment?
14B, Your Honor.
All right, let's do it this way. Thank you, counsel, for informing me of that. That makes it easy for me. Unlike your supervising attorney. June 5th, 2025, 9 a.m. Bond continue.
Thank you.
Thank you, Your Honor.
You're welcome, sir. Well, we wait a minute, because I don't. Oh, understand, sir. Okay, so let me get this guy, and then we'll get him back out. Hold on a second. I got this one? Or no? Okay, all right. You just tell me, I'll deal with it. Court calls the case People versus Danielle Klimola.
Andrew Childers, on behalf of the people. Your Honor.
And Assistant Public Defender, really on behalf of Danielle Klimola, who's approaching. Danielle, state your name for the record, please.
Danielle Klimola.
Thank you.
Your Honor, I am handing the court a plea form as well as the advice.
Well, we don't get these before. But never mind. Court has before the plea form that indicates that the defendant will be pleading guilty to the charge of use of cocaine. That's a misdemeanor, 1 year misdemeanor of use of cocaine. Upon her successful plea to that charge, count 1 would be dismissed. There is the further indication that the defendant is to enter the 15th District Court sobriety court.
Your Honor, I don't know if this, so my understanding is the defendant is under sentence on a year in jail. There may be an ask.
That is
for modifying that sentence.
Today?
Whenever the court, I don't know how the court would like for us to address it, we
I
can
wouldn't,
come,
but go ahead.
we can submit a motion to that effect.
You have to present a motion.
Absolutely.
And I guess I'll put on the record right now, you have no objection to that and would be fine with the defendant's entry into sobriety court program, which she's been screened.
All right. Okay, this is the court's full understanding of the agreement. Is that correct?
That is our understanding as well. Yes, Your Honor.
May I have her sworn?
Raise your right hand. You solemnly swear to the testimony you must give to be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name.
Danielle Klimola.
All right. It is this court's understanding that you are going to be pleading guilty to the charge of use of cocaine. That is a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. Do you understand that?
I do.
Understanding, and I also should advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court. You understand that?
Yes, I do.
Still wish to plead guilty?
I do.
And to that charge, how do you plead?
I plead guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind?
Yes.
You signed an advice of rights form, is that correct?
Yes, I did.
Any question regarding those rights?
No.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights in the form.
Yes. Yes,
You understand you're giving up your right to appeal of right?
I do.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
Doing this voluntarily?
Yes,
of your own free will,
yes,
and because you believe that you're indeed guilty?
yes.
March 18, 2025, the location on South State Street, City of Ann Arbor, Washtenaw County, State of Michigan. Did you have cocaine in your possession?
I did, yes,
Had you used it?
yes,
Did you know what you were using was cocaine?
I did.
Counsel, have I complied with the court?
Defense is satisfied as well, Judge.
Court will accept the defendant's plea of guilty to count two. Count one is dismissed.
Thank you, Your Honor.
Pre-sentence investigation and report is ordered at 15th District Court. Probation sentencing will be
June 3rd at 10 a.m. with Judge Allen.
June 3rd, 2025, 10 a.m. Judge Ravel.
This was also an email from Ms. Johns from the 15th District Court about possibly setting this on Friday. I don't know what this was, those sentencing dates for 15th on Fridays. I'm sure they could also modify it. Judge Valvo could also set it on a different day. I know the court only gets so many days.
Yeah, I don't have that.
I only have June 3rd.
So we'll just set it that.
Yeah, okay, I'll just set it June.
And you're on the desk at 9 a.m.
Oh, it's at 9 a.m. before Judge Ravel. All right. Okay. Thank you.
Thank you so much, Your Honor.
Court does call the case People versus Elijah Kraft.
And then on behalf of the people, Your Honor.
She's back.
Good morning, Your Honor.
They gave
Student,
you a bunch of cases, didn't they?
yes,
Did they?
not a bunch, a fair amount.
Not a bunch? Who gave them to you? Did she give them to you?
I cannot confirm or deny, but I was assigned. Okay.
Did Akin really give you all these cases? Did she say when she gave them to you, I don't want to do anything today?
No.
Oh, she didn't say that? Okay, I was just checking. All right, go ahead, counsel.
Student attorney Andra Sabri on behalf of Mr. Elijah Kraft, who is present in person with me today, Your Honor. If you could please state your name for the record.
Elijah Kraft. Thank you, sir.
Your Honor, we respectfully request that these matters be set for a preliminary examination.
Right. And on both of these matters, all your discovery is complete?
To my knowledge.
And would the people have their witnesses available the 27th?
We'll do our best, Your Honor.
Preliminary examination, May 27th, 2025, 9 a.m. That is before Judge Washington.
Thank you, Your Honor.
Thank you. God will continue. Thank you, sir. Court calls the cases of the People versus Dale Miller, 3 cases.
And Maggie on behalf of Mr. Miller, who is approaching. Please state your name for the record.
Dale Miller.
Your Honor, we recently have received a competency report and we stipulate to findings of Mr. Miller being incompetent but restorable.
They determined that he's incompetent to stand trial at this time, but likely to obtain competency through treatment. Is that correct?
Yes, Your Honor.
All right. All right, I have reviewed that report. I will sign off on those orders. I'll set a competency review hearing. I need 90.
90 days would be August 14th.
August 14, 2025, 9 a.m. Defendant's bond will continue.
Right. Thank you, Your Honor.
Thank you. Court does call the case of the People versus Marquez Dalton.
Anna Mackey on behalf of Mr. Dalton, who is, I believe he's riding a bus right now at the court, Your Honor. The last we've heard, he was in downtown Ann Arbor 20 minutes ago. It's a slow bus.
You know, he came from Detroit. Let him know he came from Detroit.
The bus has been driving from Detroit, Your Honor. Maybe it ran out of gas.
What?
He's coming. The bus is coming.
How do I know he's on a bus?
I spoke to him, Your Honor.
Huh?
I spoke to him and he said he was on the bus.
So what do you want me to do? Bench warn him?
No, Your
If
Honor.
we can go get him?
If you could please pass this matter for a few.
A few. Okay, so hold on. I went through this almost exact same thing with Cannon. And yes, I know, they had pictures all along of him on his bus ride. It was
So
like
it's a
trees.
common
It was
thing.
video. It was just trees going by a window on a bus. I don't know if he was on a bus. But at least they had gave me pictures. Not you, nothing.
I'll provide photos, Your Honor, in a minute. It's clearly a common problem with buses. If Stephanie had the same issue with her.
Okay, Mackie, when's the last time you got on a bus?
For school, Your Honor. We ride a bus from the parking lot to class. It's like a mile walk.
When's the last time you got on a bus for travel around the city? Or
New York. Subway, that's even better. Subway.
A subway is different than a bus.
Okay, I've never been on a bus, Your Honor.
I didn't think so. Okay, thank you. I'll pass it.
Thank you, Your Honor.
Never been on a bus. I know. I don't know why you're trying to fight it. Just say, I've never been on a bus. She doesn't even know if it's a slow bus. Court does call the case. People versus Rahman Mohammed.
My client is not on the bus. Yet.
Are you calling him, Mackie?
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Rahman Mohammed. Mr. Mohammed, please state your name.
Rahman Mohammed.
Thank you. Your Honor, today's date and time set for probable cause conference. We are respectfully requesting that this matter be set for preliminary examination. Also, we'd like to address bond at the.
All right, all discovery is complete.
As far as we know,
People have their witnesses available the 27th.
I didn't want to let council know Mr. Muhammad has a new warrant in, as of just a few days ago. I was received for a heightened jail appearance, so I have that with you.
Preliminary examination, May 27th, 2025.
Thank you.
And that's before Judge Fresh Hour.
Thank you, Your Honor. As to bond.
Yes.
Your Honor, my client is respectfully requesting that the court allow him a personal recognizance bond. He does have a place to stay. He would stay with his father, Kushir Muhammad. That would be in Manor Street in Detroit, Michigan. He's asking if the court feels that it's necessary, he would agree to wear a tether to ensure that he returns to court.
Response.
Your Honor, I think the underlying case, or the case that was set for exam is a bit older, if I'm not mistaken. I'm not sure how much I'm in custody. I'm concerned that while he's in custody, potentially accumulating assaults and offenses, but I'll leave that in discretion of the court. I would request that if he is released, that he is testing, given the nature of this.
And my client will agree to test.
How did he come into custody? A traffic stop?
Your Honor, my client tells me that it was a traffic stop.
Oh, Your Honor, maybe approach, please, very quickly.
Approach. Record should reflect, we've had a bench conference in this case. And in considering everything, I'm going to deny the request for change in bond. Bond will continue.
Thank you, Your Honor.
Thank you. I'm trying to get people on this one. The court calls case People versus Aaron Daniels.
And then on behalf of the people, Your Honor.
Anna Mackey, on behalf of Mr. Daniels, who is to my right, please state your name for the record. And at this time, we'd like to request that this matter for preliminary examination and all discoveries complete as far as we are aware.
People have their witnesses available the 27th. Preliminary examination in person will be set for May 27th, 2025, 9 a.m. That is before Judge Washington. Bond will continue.
Thank you, Your Honor.
Court calls case of the People versus Danielle Pressey.
Michael Gaddy, Assistant Public Defender, on behalf of Ms. Pressey, who's approaching Judge. Get your name?
Danielle Pressey?
Requesting an adjournment.
Yes, Your Honor, there's a lot of discovery to go through.
May 29, 2025, 9 a.m. Bond continue.
If I could be heard on bond, Judge?
You may.
Thank you. Judge, I did have a chance to talk with Ms. Pressey. She is here before the court with a bond of, I think it's set at 150,000 cash. This is a situation where she has absolutely no criminal history the last 13 years or so. She does have an old OWI matter from 2012. That's all I could find on her CCH. She resides in the Metro Detroit area in Oxford or Lapeer. She owns a business, a brick and mortar business, a nail salon. She's not a flight risk in any way. She cares for her disabled mother. She is, like I said, gainfully employed. She owns a business, a nail salon that she is the proprietor of. She is we'd ask the court to consider some kind of a reduction in bond, hopefully a personal bond, like if she would avail herself of any both a scram and a GPS tether if the court thought that was beneficial to ensure both her presence and that she's not anywhere that she should not be. She has, as I said, work, family responsibilities, and have to care for disabled mother.
Response.
The facts of this case involve the defendant traveling around 60 miles an hour. It's on Marks Road, which I believe is 45, but and it's probably 45 would be my guess. 60 miles an hour with now candidly the BAC was 0.038, but there was also 200 nanograms per milliliter of amphetamine, as well as THC, 2.7 nanograms of THC in her system. The victim is tragically the defendant's son, I believe 7 at the time, was improperly belted in the rear seat and killed in the accident. The vehicle crashed into a tree. Based on those facts and circumstances, I don't believe that the bond is improperly set. I believe that the facts of this case are awfully tragic, but I am concerned about the defendant's potential conduct while out this matter pending given the serious.
Your Honor, if I might, this is a very serious situation, very tragic. There was, the allegations of the purported Adderall, I believe, was a prescribed drug. As Mr. Childers stated, it was a 0.038 of what was the reported drug or alcohol. This was, like I said, this was a situation where I don't think she comported herself. This accident happened several months ago. She's comported back in December, I believe. She's comported herself properly since then. She'll continue to do so. As I said, she's not a flight risk in any way. And she does have responsibilities while we, there's a lot of information to look at here, and I believe this is a matter that is going to be litigated pretty heavily. So I'd ask the court to reduce the bond.
Motion for bond reduction is denied. The court does consider the defendant a risk to public safety, and so her bond will continue. Thank you.
Thank you. Your Honor, if we did put together a written motion, would the people waive notice on that?
I'll wait notice as long as you don't give it to me at the end of the day on Wednesday.
No, I don't do that. Okay.
As long as I have a fair amount of time to respond.
Court consider hearing it early as well, Judge?
It will, when we receive the motion, this Wagner will be more than happy to give you a date to hear.
Thank you, Judge.
Court does call case of the people versus Jordan Davis.
I'm sorry, Judge. I didn't catch the adjourned date. My fault.
29.
Thank you. All right.
Jordan Davis.
And then on behalf of Ken Mackey, on behalf of Mr. Davis, who's approaching, please state your name for the record.
Jordan Davis.
Okay. Your Honor, at this time,
No, I'll wait.
we'd like to set this matter for a preliminary examination.
All discovery is complete.
As far as we're aware.
People have their witnesses available to 27.
Yes, Your Honor.
Preliminary examination in person, May 27th, 2025, 9 a.m. That's before Judge Freshour.
Thank you, Your Honor.
Thank you.
Bond will continue. Thank you. Court recalls case, People versus Jeffrey Murphy.
And that's just the prosecution, you Madam People.
Good morning, Your Honor. Again, may it please the Honorable Court, David Burgess on behalf of Jeffrey Murphy.
All right. Thank you for coming back, Mr. Burgess.
Yeah, of course, Your Honor.
Thank you, Your Honor, for recalling the case, and thank you, Mr. Burgess, for jumping back on. Mainly, I want to make sure the defendant's not confused about how this process is going to work and what his bond conditions are. The victim was present here today in the gallery, and defendant decided it was a good idea to mean mug her as he walked by her. Here.
Sir.
Now, I know that this defendant has a history of abusing women sexually and physically, and apparently somewhere along the way, he has learned and decided that intimidating a victim of his crime is a good idea. Like I said, I think he's confused, so if we can clear some of that confusion, I would appreciate it.
All right. So you understand that? That you're not, and when the court is saying no contact, no intimidating or threatening behavior, that applies both here in this courtroom and all of your behavior. You understand that, sir?
Yes.
And so if the alleged victim is present in the courtroom, I don't want you staring at them any kind of way.
I got you. I apologize.
All right? All right. Thank you. Thank you, Mr.
Yes, of course, Your Honor.
Across the case, People versus Harold Dennis.
Assistant Public Defender Jay Bellinger on behalf of Mr. Dennis. Mr. Dennis, can you please state your name for the record?
Harold L. Dennis. All right, I have before me a plea form that indicates that the defendant would be pleading guilty to an added count two of larceny less than $200 to 93 the offense. Upon his successful plea to that charge, count one would be dismissed. There is no objection to sentencing under 77(1.1).
That is our understanding of the plea, Your Honor.
Have him sworn.
Raise your right hand. Do you solemnly swear in front of the testimony you're about to give be the truth, the whole truth, and nothing but the truth? You got it.
I do.
State your name.
Harold L. Dennis. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of larceny less than $200. That is a misdemeanor punishable by up to 93 days jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property, which is the subject matter of the theft. If that's greater than $500, that would become the maximum fine. You understand all of that?
Yes.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Okay.
You understand that?
Yes.
You wish to plead guilty?
Yes.
To that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form today, is that correct?
Yes.
Any question regarding any of those rights?
No.
Look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights of that form.
Okay.
You understand that?
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes.
because you believe that you are indeed guilty of this offense?
Yes.
On date of August 19, 2023, at the location of 1150 Nash Avenue, Ypsilanti Township, Washington County, State of Michigan, what'd you do regarding property belonging to Willie Rawls and Willie Rawls Jr. that makes you think that you're guilty?
Well, actually, I didn't do anything that,
Did you have an agreement with him?
yes,
And did you take his car as part of that agreement?
yes,
And as part of that agreement, you were to return that car within a specific amount of time?
yes,
And how long did you keep the car?
too long,
And how long is too long?
a couple of years.
Okay.
2 years?
Yes.
Is that what you said?
Yes.
I'm just,
And was the value of that property under $200?
well, it doesn't matter.
I understand for the purpose of the plea, Your Honor.
So how long were you supposed to have the vehicle?
Well, it wasn't a determined time, but, supposedly till I finished,
Tell you what?
till I finished the job.
What job?
You were doing work
I
on the
was
car.
doing work on the car.
Oh, you were doing work on the car.
Um,
And so then after you did the work on the car, you were supposed to return the car.
well, I was not finished with the work on the car.
2 years later?
Well, yes, 2 years later. And
Did the owner of that vehicle have an expectation that you would turn that within a sufficient amount of time?
yes,
And did he contact the police as a result of you not returning the vehicle?
yes,
If I could briefly, were there multiple requests for the vehicle to be returned
Thank you.
that were not responded to?
yes,
So that we're really clear. The work that you were supposed to do would not take 2 years to complete,
No.
would it?
no,
In fact, it should have been completed well before that 2-year period,
yes,
correct?
yes.
You just didn't do the work.
No, actually, I did do the work.
You did some work,
Well, I didn't have it finished,
and the
but,
vehicle was returned after the adjournment of the PCC.
and it was returned fully finished and in excellent shape, which I was trying to do in the beginning.
Well, here's what I do. Yeah, there certainly would be a higher charge I could accept a plea to, given the facts of this case. So with that understanding, counsel, have I complied with the court rule? Have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B District Court sentencing
July 3rd at 10 a.m. for Judge Washington.
July 3rd, 2025, 9 a.m., 10 a.m. 10 a.m. before Judge Washington.
Okay.
Bond will continue.
You need to contact 14B probation as soon as possible. And that's your sentencing date. Okay, and fine. And that's your location.
Where am I saying?
You don't need to sign off on this one. That's just for you to keep for your record so that you know when to go to that court, okay? You can give me a call later. Oh, all right, take care of you.
Just thinking. Court calls case People versus Barrage Scott. Bellinger, don't come up here with anything else like that.
We're ready in this matter, Your Honor. Lauren Brown, Deputy Chief Public Defender, being written on behalf of Scott. Barrage, state your name.
Barrage Scott. How you doing?
How you doing, sir?
I'm okay.
You're doing very well, Your Honor. Today is the date and time set for a competency review hearing. I do not believe that the report has been completed at this time. Does the court have?
I do not have a report.
So, Your Honor, we'd ask for an adjournment to see if that report can be completed.
Let's do this. Has he been interviewed at all? Yeah. Has he come talk to you, Mr. Scott?
From the forensic center, I'm confused.
Yeah.
Yeah, I went to the forensic center.
Okay.
Did a evaluation or something.
Yeah.
They took me from the jail.
Jail to
And then,
okay. So when did that happen?
like maybe a week or two.
Oh, just about a week.
Yes,
ago.
sir.
Okay. All right. So let's do this. Let's put you out. Still got to get a report. So I'll put you out. Let's set this hearing date. I'm indicating no report yet, but we'll set it for June 26th, 2025.
So they don't get to do anything.
Okay, that's fine. I understand.
How you think?
Yeah, but I'll set. Which ones? They're both going to be.
Yeah.
No, she already had it. She passed. Something.
Okay, so we don't.
I'll just adjourn your probable cause to that same date of 26th. I can't go ahead on that case anyway. Whether there's, I technically don't have a comp referral on the other matter, Mr. Brown. I don't have a comp referral on the larceny of building case.
Oh,
I do on the armed robbery case, but I can't do anything on that case with that other one pending anyway. But
Right,
just so
right.
you
So,
know.
okay, we can do an order to match that one. Your Honor, what is my client's bond on this case?
On which case? On the larceny case, his bond is set at 1,000 cash or 10%. On the armed robbery case, his bond. Yeah, what do you have his bond on there? I think it's denied.
And we would ask that the court do set a bond in this case. He does have very strong family support, as he has always had. They are pressing. We're asking that some bond be set for him.
Well, I think his bond got revoked on a, he was on bond on another case when this happened. So I'm not sure if he'd be entitled to have a bond in any respect because I released him and 8 days later, this case happened.
Okay.
So I'm going to decline to change his bond at this time. Let's get the report back and see where he is. The bond on these matters will continue.
Oh, yeah. Absolutely.
All right. Thank you, Mr. Scott. No. Court calls case People versus John Fleming.
Good morning, Your Honor. Student Attorney Audra Sabri on behalf of Mr. John Fleming, who is present with me in court today. Record, sir.
John Fleming. Where are the rest of his family?
Oh, hoping I'm going to work after this.
Your Honor, we
You'll
are,
talk to him about that afterwards.
will do, Your Honor.
Thank you.
You got workload today, don't you?
Your Honor, we are requesting an adjournment.
Your Honor, we need a protective order in this case. There's a forensic interview with the child victim that I watched.
Okay.
I have received the protective order, Your Honor. I was just going over it. I'll submit it to the court.
Court. All right. So probable cause conference, I'll adjourn to May 29, 2025, 9 a.m. On continue.
Thank you, Your Honor.
Thanks, sir. Thank you. Calls case People versus Rashad Shafi.
Morning, Your Honor. We're the Assistant Public Defender with and on behalf of Mr. Shafi. And I do apologize, Your Honor, but maybe approach on this one.
What would a day be without Yagi approaching? Come on. All right. You're requesting that these matters be set for exam.
That's correct, Your Honor.
Discovery is complete then on both cases.
To our knowledge, Your Honor, yes.
People have their witnesses available the 27th. Preliminary examination in person, May 27th, 2025, 9 a.m. That is before Judge. Court calls the case People versus Jamie Good.
That's a lot of the people. Good morning. Judge Simpson. I'm Dadush on behalf of Miss Good.
I was wondering if they were gonna let you have any case?
I had more.
Huh?
Kidding. I stipulated to adjourn a bunch of them.
See, even like Akinruli could have given you some of hers, because she's not done anything. Go ahead.
Can you say for the record, please?
Jamie Good.
Thank you.
Your Honor, this is the first PCC on this matter. We are going to be asking for an adjournment to continue plea negotiations.
Do I have a green form?
Yes.
Probable cause conference will be May 29th, 2025. And continued. Thank you.
Thank you.
Thank you.
Let's call the case People versus D'Angelo Simmons.
Good morning, Honor.
I read in that, Ron Brown, Deputy Chief Public Defender, appearing on behalf of Mr. D'Angelo Simmons, who approaches from the lockup. Under today's date and time set for a competency review hearing, does the court have an updated report?
My most updated report is from April 8th. Dated April 8th, received by us April 14th.
And have, okay.
Double checking this evidence. That's the last one I have.
That's the last report. I don't know why this wasn't sent earlier. Or moved out once we got that report.
But I have my client state his name for the record.
Yes.
D'Angelo Simmons.
All right. Well, they would do a review from April 8th. That'll be about July something. So, I'll just indicate at this point, I don't have a report. I'll set it out basically at 90 days from the date of this report. So hopefully we'll have something. What's my closest date to July 8th?
July 17th.
All right. No, that's fine. That's a Thursday.
Yes.
I'll set that out to July 17th, 2025, 9 a.m. If we do get a report, this one should have been moved up itself, but if we do get a report, we'll move the date up. All right.
Thank you, Adam.
Thank you. Court does call the case People versus Douglas Hill.
They gotta cover your butt. You don't want to see it.
Okay.
Thank you, Your Honor. I did provide the court with a clean sheet. We're simply asking for a brief adjournment in this case.
If I were to test your client, will you test clean today? And I don't like being lied to.
Probably not.
Okay.
What would be in your system?
I've been tested dirty for cocaine and THC, I believe.
3 successive occasions. Mr. Allen. I have a bond violation report here.
But I haven't even been out a week to get my system clean. I just caught this charge and the bond was just set, so I haven't had time to actually get my system clean.
I have a whole week of testing with cocaine in your system.
We also have a failure to appear for CCOP, is that correct?
For CCOP, what's that?
It's
That's true.
correction stuff.
No, oh, yes, they rescheduled my appointment for Monday at 9:30 with the Brown guy for the outpatient program.
Yeah.
Yes, 'cause I thought I showed up at 2, it was at 1:30, and then I also dropped yesterday.
Why is cocaine still in your system?
It will not be today.
Well, you just told me it was gonna come back.
Because I haven't dropped clean yet, that's why I assumed that. I don't know how long it takes to leave.
You're
my system.
still using.
No, I'm not.
No, because you want, okay, I'm gonna tell you what. You're telling me you're not. I'm gonna take you back. I'll call over, get levels, and then we'll see exactly what's happening.
So I got.
You want me to do that?
So I can drop today?
No.
I'm sorry, I
You
didn't.
would go back there with my bailiff. I will call over and get levels. If you're telling me that your system is just cleaning out.
My system should be clean.
No, that's not what I'm saying. You're telling me you're not using,
Correct.
right?
Yes.
Okay. Then this must be some super duper cocaine.
I have.
So we'll figure it out. And so what I'm gonna do is, Mr. Allen, you can take him back. We will call over to community corrections, get your levels, and then we'll figure out what's happening. They probably don't have anybody right there then. They do? Okay. Court does call the case, People versus Romeo Serba. Oh, 2 in a row.
Kevin Radish on behalf of Mr. Serba, who is asserting.
Your name, sir?
Romeo Serba.
Thank you.
Your Honor, we are going to be asking for an adjournment for mitigation, and we would like to address bond, please.
Probable cause conference will be adjourned May 29th, 2025, 9 a.m. I need a green sheet and then next.
As to bond, Your Honor, I wanted to address, I wanted to ask for him to be released on tether. Your Honor, Mr. Serbo is 20 years old. He has 2 children that he takes sole custody of. He has to take care of them right now. They're in the care of his father and his foster grandfather and foster grandmother, who aren't able to actually keep taking care of his children. He has been in school. He has a 4.0 GPA. He just got his transcript back. He had a job interview. He's doing really well. The reason he was missing them is just because he had so many things going on. They were early in the morning. He has these 2 kids. I can assure you that if you put him on a tether, Your Honor, that you will be seeing obviously no missed tests, but no positives or anything like that. He is not drinking. He doesn't drink. He reacts very poorly to it. So we are going to be asking for that.
Yeah, but he wasn't testing on a SoberLink device. I mean, he just wasn't testing like he should.
Yeah, there's 2 that he missed. He was in custody for those. Those are the first 2 missed ones on the report from March. And then he had 4 missed ones, but he submitted a compliant test like within 15
No,
minutes.
I'm talking about, I got that, but his April 24th report from community corrections.
I'm not in receipt of that. The last one I have is as of April 23rd. I may have missed it, but
April.
The report that I have, the last test on there that was missed was the 23rd of April. Let me look.
Right, but there should be a bond violation report from that's dated April 24th, 2025.
Oh, this is the one. Oh, no, sorry. Yeah, April 24th. This is the same one that I'm looking at.
Okay.
Okay.
Go ahead.
Yes. As 2 of those were missed when he was in custody elsewhere. 4 of those he missed, but he retested like within 20 minutes, 15 minutes, 7 minutes after the 9 a.m. block. I believe there's only 2 that he missed that he never retested for, and those were the newly added time window. I believe he had either forgotten about those, and I understand that that's not an excuse. He just has a lot going on with school, with work, with his 2 kids, and that's why I believe having him on a tether would resolve this issue. He should have been put on tether from the beginning, honestly. But if Your Honor releases him on that tether, and he's not missing any of his drug tests. So.
Any response?
The only thing I'm concerned about was in September of 2023, the defendant was placed on probation in the Oakland County Circuit Court on 2 counts of RIO and an A&B or HIDA. And obviously this offense occurred in June of 2024. So it would have been while he's on court supervision, Oakland County Circuit Court on a similar charge that also falls with the defendant's ability to cover.
Your Honor, he is undergoing mitigation for mental health concerns, that we're gonna provide to prosecution. I've talked to his attorney in his Oakland County cases. He is on probation for those. He's testing in so many different places for so many different things. That's why also he is having trouble keeping track of these tests. And I mean, again, I believe a tether would help with all, huh? What do you want to say?
I just want to, that I did ask. When I realized it was gonna be a problem. So I won't have any problems with it.
Yeah. He's saying that he requested, well, he wanted, a tether in the first place, and
When you're saying a tether, you're talking a scram tether?
Yes, sir. And if I was to get that, I wouldn't have any problems. You wouldn't hear it from me. I don't drink alcohol. There's no alcohol in my household. It's just 2 children and I go to school every day.
2 children and some pot, right?
Well, I smoke outside the house and it's never around them.
Okay. Do you have a card?
Yeah, I do. And
Did you give us your card?
I offered to give that to community corrections, but they refused to take it every time I offered it to them.
and his father submitted it. They'd already submitted it to community corrections. I don't know why community corrections lost track of it, but I talked to his father yesterday, and his father said that he sent community corrections a copy of it again yesterday, but that every time he goes to test, he has a medical marijuana card on him and it's active. And I can send that to the court right now.
I will modify his bond, although he may not be entitled to a $25,000 personal recognizance bond, but he needs to be on a scram tether prior to release.
Thank you, Your Honor.
And I've set this over to the 29th.
Thank you, Your Honor.
Thank you.
Thank you.
Case People versus Sherry Hughes.
Thank you, Richard, Deputy for the people.
Morning, Your Honor, Mike Candy, Assistant Public Defender on behalf of Ms. Hughes, who's not here. Judge, I did submit a green form. I did receive a call from Ms. Hughes' mom yesterday stating that she was at St. Joe's psych ER. I got a call around 8:30 saying that they're waiting to be discharged. And I don't think she's in a position to actually be still going to court today. I'd ask the court to excuse her presence and adjourn this matter.
Well, I'll need some documentation, but Mr. Getty, but I'll adjourn this over to the 22nd, 1 week out.
Thank you, Judge. I will.
2025, 9 a.m.
Thank you. I will provide the discharge paperwork when I get it. Thank you.
Court calls the case of the People versus, you said lot. It's LaDonta Skinner. I don't know why they have it this way.
Thank you, Richard, Deputy for the people.
We're ready in this matter, Your Honor. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Skinner, who approaches the podium. Skinner, please state your name for the record.
LaDonta Skinner.
Thank you. Your Honor, today is the date and time set for the probable cause conference. Respectfully requesting this matter be set for preliminary examination.
Both matters.
Yes, please.
Discovery is complete. But
Yes, to the best of our knowledge, discovery is complete.
people have their witnesses available the 27th. Preliminary examination, May 27th, 2025, 9 a.m. That will be before judge. Continue.
Okay, Your Honor, what does the court show as the bonds in these matters?
Have 1,000 cash surety on the case ending in 5724. And on the other matter, same thing. 10%.
Both are 10%, Your Honor.
Hmm?
Both are 10% allowed.
It is cash surety 10%.
Okay, all right. Thank you very much, Your Honor.
There you go. Somewhere. Courthouse case People versus Joel Stevens.
Jennifer Douglas for the people.
With that, on behalf of Mr. Joel Stevens, who is approaching.
Joel Stevens.
All right.
Your Honor, we are going to be setting this for preliminary examination, please.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available the 27th. Preliminary examination, May 27th, 2025, 9 a.m. That's before Judge
Washington.
Washington. Bond will continue.
Thank you, Your Honor.
Court does call the case People versus Davian Thomas.
We're ready in that matter, Your Honor.
Andrew Children, appearing on behalf of the people.
Vaughn Brown, Deputy Chief Public Defender. They're appearing with and on behalf of Mr. Davion Thomas. Mr. Thomas, could you state your name for the record?
Davion Thomas.
We're doing the plea.
Yes, please.
The plea form indicates the defendant will be pleading guilty to an added count 3 of larceny by false pretenses, 200 to 1,000 to 1 year offense. Upon his successful plea to that charge, counts 1 and 2 would be dismissed, and it is okay for him to seek hideout in the case. That's the agreement of the parties as the court understands it.
That is our understanding, Your Honor.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
State your name.
Davion Thomas, Your Honor.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of larceny by false pretenses, $200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased at 3 times the value of the property. It's at 3 times the value of the property, which is the subject matter of the theft. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, Your Honor.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge. You would be sentenced before Judge Barr in the 14A2 court. Do you understand that?
Yes, Your Honor.
All right. Now, understanding all of that, do you still wish to plead guilty?
Yes,
Yes. And to that charge, how do you plead?
guilty, Your Honor.
You understand that by pleading, guilty, you does not have a trial?
Yes, Your Honor.
Would you sign an advice rights form?
Yes, Your Honor.
All right. Approach. Yes. Sign an advice rights form. Do you have any question regarding those rights?
No, Your Honor.
You'll see a copy on the podium. Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Anybody threaten you or coerce
No, Your Honor.
you? You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you're going to be guilty of these offenses? On between the dates of January 22nd, 2024 and January 31st, 2024, at the location of Eastern Eateries on the EMU campus, Eastern Michigan, Washington County, state of Michigan, what do you do that makes you think that you?
Yes, what did you do? No, we're talking.
I used cars without permission, Your Honor. So,
What kinds of cars?
I had used someone card without their permission.
To
So,
get food?
to order a DoorDash, which was $40, and I was wrong, Your Honor.
All right, so you did that. And in using these cards, the value of the property that you received, was that in excess of $200?
No, Your Honor. It was,
Your Honor, I'd be asking the court to take a plea.
To a higher charge for that. All right, the court can do that. And you didn't have anybody's permission to be using these cards?
correct, Your Honor.
All right. All right. Counsel, have I complied with the protocol?
Defense is satisfied, Your
Honor.
Court will accept the defendant's plea guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be
May 28th, Judge Barr at 10 a.m.
May 28, 2025. What time? Time?
10 a.m.
10 a.m. before Judge Clark.
Your Honor, may I address the issue of bond?
Go ahead. Everybody else.
Your Honor, my client has, originally he was not incarcerated. The court put him on, I believe he missed the court date. I think he had taken a trip, a family trip. He had taken a family trip. He was able to do that, but he wasn't able to make it into the next court date. I believe that's how the case went. So, as a result, the court, put him in. We're asking that now that he's pled to the misdemeanor, this is a property offense. My client is scheduled to start classes on May 19th. We ask that his bond be reinstated. He'd be allowed to be released, from incarceration at this time.
So is he gonna be at EMU?
Macomb Community College.
Okay, so how do I know that he's gonna get back here?
Oh, he'll make it back. He'll make it back. He has not enjoyed his time in the Washington County Jail.
Okay, so how did he come into custody?
I turned myself in, Your Honor.
You turned yourself in where? Here?
Yeah.
So he knows how to make it back here, Your Honor.
Any response from the people?
No, I would agree. I believe the defendant appeared in front of you back on May 1st and he was free there.
Got it. That's what okay. So you know the importance of showing up now?
Yes, Your Honor.
You ever been in jail before?
No, Your Honor.
So this has been Mr. Brown is right. This has been an experience for you.
Yes, Your Honor.
Meaning you take it serious, right?
Absolutely, Your Honor.
I'll reduce the defendant's bond. I'll set it at $25,000 personal recognizance bond. And they get him back. Court does call the case of the people versus Brendan Williams.
And here we go to the people.
We're ready to start, Your Honor.
Or Brown.
Deputy Chief Public Defender Ping, with on behalf of Mr. Williams.
Your name, sir?
Brendan Williams.
What are we doing?
Your Honor, we are respectfully requesting we're going to set this matter for preliminary examination.
Discovery complaint?
Yes, and, there's a complication. There's a new case that's arisen. We'd like to be able to resolve these matters, but we have to know what's happening on the new case because that's going to be part of this. So it is complete for this case. We may even resolve this case short of preliminary examination, but we will need to have that other case.
The other case, does it affect this case?
Your Honor, if I can say a comment, I thought we were adjourning for that purpose, but Mr. Williams has a high EAC case set for arraignment. It is out of this court. And the arraignment date that was set for his summons is June 18th. So our request was going to be that the court, I understand it's not for today, but if that file could be pulled so that he could have been arraigned on his next adjourned PCC date, but we don't have one. We're setting it for exam. I had discussed with Mr. Brown that we might be able to figure out something between those two. So if we're setting it for exam, we don't need to worry about the other case. We wouldn't have time to do that.
People have their witnesses available the 27th.
What's right?
Preliminary examination in person, May 27th, 2025. 9 a.m. before Judge. Fresh hour. Bond will continue. Thank you.
And may we address the issue of my client is currently the bond set right now.
I have it at 10,000 cash surety.
And we're asking that the court consider in this case a personal recognizance bond with a tether. He does have strong family support. His aunt and his family have been in the court all day today and waiting for this matter. I've spoken with his aunt. She would be willing to allow him to stay with her during the pendency of this matter.
The case, the new high BAC, what was the offense date of that?
Your Honor, the IBAC offense date is, I have it right here, that was April 3rd of 2025.
Okay, here's my problem. I've got that charge coming up, and I'm not presuming his guilt on that. But I certainly got a high level of alcohol involved in that case. That case is coming up. I've got an indication that there's alcohol involved in this case, plus then assaultive behavior is at least alleged in this case. At this time, and maybe certainly after Judge Freshour hears it, her mind will change on this, but at this time, I'm not gonna reduce the defendant's bond. I'm gonna deny the request for modification of bond and bring out Hill. Oh, we have either one. Who do you have? Hill, do you have Jenks? Yeah. Okay, I'll bring him out, that's fine. Court recalls the case, People versus Scott Jenks.
And then on behalf of the people, Your Honor.
And Stephanie Can on behalf of Mr. Jinks, who is appearing to my right. Mr. Jinks, please state your name for the record.
Scott B. Jenks. Giving me his equipment.
Oh, did you get it? Okay. Your Honor, I've spoken to my client regarding the possibility of a self-defense argument and his desire potentially go to trial. My client has indicated he does not want to go to trial. He is not exerting a self-defense and he would like to proceed with the plea.
All right. So you're waiving your right to assert a self-defense claim. Is that correct, sir?
Yes, sir.
All right. And so at some point during the altercation with your wife, you, without her permission, put your hands on her and pushed her down. Is that correct?
Yes, sir.
All right. Counsel, with that testimony, has the court complied with the court ruling? Would it be proper to accept this defendant's pleas?
Yes, sir.
You have, Your Honor.
Court will accept the defendant's pleas of guilty to counts 3 and 4. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 1484 probation. Sentencing in this matter will be
June 5th at 10 a.m. with Judge Freshour.
June 5th, 2025, 10 a.m. before Judge Freshour.
Your Honor, may I address bond?
Okay.
Thank you. Your Honor, with this plea agreement and the felonies now being gone, I would ask my client be released on a PR bond. A part of this was treatment. He could be screened for any sort of treatment necessary. He has strong family support. His daughter is here. His daughter is here. The family home has been vacated. It's my understanding from her that the complaining witness in this case is now living with the daughter and no longer at the family home, so he can go home.
His daughter?
Yes,
Okay. So, okay, gotcha.
yes. That the complaining witness is no longer living at the family home, so he would have somewhere to go. This is his very first time doing, well, anything. My client will appear for court. He has no desire, nor will he be seeking any contact with the complaining witness in this case, Your Honor. We're asking for a PR bond.
And Your Honor, we have not had direct confirmation from the victim that she has vacated that address. We don't have a new address that she has. However, I would leave it in the court's discretion as to release. If he was to be released, Your Honor, I would ask that he be placed on a GPS tether as well as some type of testing, or alcohol testing or a scram tether.
Do I have an indication of alcohol use in these cases?
Yes, Your Honor.
There is, okay. Well, I won't put him on a GPS because we can track him from the scram tether, quite frankly, but what I'll do is I'll modify his bond I'll give him $25,000 personal cognizance bond, so I'll release him. But he has to be placed on a scram tether prior to his release.
Thank you, Your Honor.
Thank you.
Yes, sure.
Good. All right, thank you, sir. Well, you can bring us Mr. Hill whenever you're ready. This guy. You're getting him. Who's on? Case was this? Where'd Cannon go? Okay. About to call her client back up. Court does recall the case, People versus Hill.
Yes, Your Honor, we did receive the results in this matter and I have discussed them with my client. And what the likely outcome will be based on that result.
Pardon?
And what the likely outcome will be based on that result.
Well, just so the record's clear, he had indicated to me that he hadn't taken it, hadn't been using, but his levels started out in May of cocaine, started out on May 7th at 424, then went down by May 9th to 353, but then by the 14th shot up to 889. So anything else you want to say? He's been using.
Your Honor, my client is just asking for a 1-week adjournment in this case. We're gonna have him screened for drug court to see if that's a suitable, a good fit
Probable
for him.
cause conference will be adjourned May 29th, in 2 weeks.
2 weeks. Thank you, Your Honor.
Absolutely. 2025, 9 a.m. His bond is revoked. Court calls the case, People versus Martez Dalton.
Rachel McDuffie for the people.
And Maggie, on behalf of Mr. Dalton, who is appearing to my right, Your Honor.
Your name?
Martez Dalton, sir.
I told you he was on the bus. I told you you'd get here, Miss Mackey. They didn't have any faith in you. I had all the faith in the world you were gonna get here.
John, I want to thank you for passing on the matter, allowing me time to get here, sir, and the time matter.
You know what? I had to pass it because she was just screaming at me.
Sir, I don't make no
Miss
excuses.
McDuffie wanted a bench warrant. I had faith in you, and so we gave you time.
Thank you, Jan. Thank you, Jan. I appreciate that. I was coming. I was finna miss
No,
Brooklyn, thank you.
I appreciate you going through the effort to get here, sir. Really.
John.
All right, and you're requesting an adjournment.
Yeah, Your Honor.
Grant the adjournment. What are we trying to do in this? Oh, okay, I got it. All right, so probable cause conference, May 29th, 2025, 9 a.m. Bond continued. All right.
Thank you, Your
Thank you, sir.
Honor.
Yes, sir. Thank you, Jan, once again.
Thank you. Oh, that ended on a happy note for Miss Mackey, didn't it? Shocking. What? I didn't see that. You put a photo of a bus? Let me see. Oh, you drew. I asked for a picture, not like this. Thank you, Miss Mackey. Technically, it is a picture. All right, we'll stand in recess. We'll come back and set our next block shortly. Court stands in recess.
All right. All right. 14A District Court for County of Washington, State of Michigan is now back in session. The Honorable Judge Simpson Court.
You may be seated. All right, court does call the case of the People versus Clyde Moore Jr.
Here, Your Honor.
He's in Zoom. Go ahead, Madam AG.
Good evening, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Is this your case? Why should that be a shot? Gee,
Judge, I apologize. Which case did the court call?
I mean, what did I call?
Yeah.
Clyde Moore.
That is my case. Assistant Public Defender Tanazi Carey Akinruli on behalf of Mr. Clyde Moore Jr. Mr. Moore, state your name for the record, please.
Clyde Moore Jr.
All right, what are we doing?
Your Honor, we are actually going to ask for an adjournment. Mr. Moore did make some payments. I was hoping that we'd be able to get a resolution with the people, but we've still been in communication as to what the offer is going to be.
All right,
But I think he has made payments to satisfy the recommended reduction.
all right. They probably haven't appeared as of yet, or may have, who knows?
Your
All right.
Honor, Your
Yes.
Honor, I just tried to reach out to the PD's office this morning, but I didn't get in contact with anyone timely. My system shows, unless he has more than one case, that the arrears are now at 0. And typically
All right,
when-
0?
Yes, and typically, even though I think the case is still charging, but typically when they are at 0, we do offer a misdemeanor disorderly. But I don't know if his attorney was aware of that, if she wants to discuss that with her client, or how she would like to proceed today.
Got it. So it's at 0.
It's at 0.
You just have to get everything worked out.
That's correct, Your Honor.
Okay, so why don't I do this? I'll adjourn the probable cause to May 29th, 2025, 9 a.m. And with that, out the payment doesn't, it won't click up, but
Thank you so much, Your Honor.
all right, thank you. All right, thank you, Mr. Moore.
Thank you.
The attorney didn't even ask, so they just.
Nothing.
Court does call the case, People versus Daniel White.
Good afternoon, Your Honor, Assistant Attorney General Clarissa Williams on behalf of the people.
Assistant Public Defender Jay Bellinger on behalf of Mr. White, who appears via Zoom.
Mr. White, can you state your name, please?
Yes, Daniel White.
All right, where are we on this?
Your Honor, I am asking for 2 weeks. I did speak with Ms. Williams earlier in the week, and if you got back to me, I unfortunately didn't get to it yet. So I just asked for a couple weeks so that we can, so I can discuss with my client where he's at.
All right. May 29th, 2025, 9 a.m. without objection. Bond continued. Thank you.
Thank you.
Court does call the case of the People versus Joseph Wynn.
Good afternoon, Your Honor, Assistant Attorney General Clarissa Williams on behalf of the people.
This is Yagi's case.
Yes, it
Well,
is.
don't everybody move at once.
I apologize, Your Honor. Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Wynn.
Mr. Wynn, can you state your name?
Joseph Wynn.
Motorola. All right, where are we on this?
Your Honor, I am asking for one more adjournment. I know we have adjourned several times. Mr. Wynn indicated that he is receiving a paycheck in a couple weeks, and he's going to, and we are hoping that with that payment, we will be able to continue towards resolution in this case.
So if I put it out to the 29th, that will happen.
So he says his paycheck, Mr. Wynn, did I remember correctly? You said your paycheck's coming on the 30th?
In a couple weeks, 2 weeks on Friday.
On Friday, so the 30th. That's what I wrote down.
Okay. All right. So let me adjourn this out to June 5th,
Thank you, Your Honor.
2025, 9 a.m. Or as your invite indicates, bond will continue. Thank you.
Thank you.
And then this, I'll call it, but they haven't signed in.
Correct.
Court does call the case of the People versus Brian Brown.
Good afternoon, Your Honor, Assistant Attorney General Clarissa Williams on behalf of the people.
And this is Perkins. Is he in jail, Mr. Perkins? Todd Perkins? Can you send Todd Perkins? He's gonna lose his ability to appear via Zoom if he doesn't answer. This is Attorney General's last case, I don't. All right, counsel, just let me pass it and see if, we're gonna see if we can get him on there. The facility that's housing the defendant hasn't signed in, but I don't know what Mr. Perkins has in mind.
Okay, Your Honor. Oh,
Let me pass it and then we'll get you out of here as fast as we can, as soon as we get him up.
thank you.
Thank you. Court does call the case, People versus Alexis Murphy.
And it's on behalf of the people, Your Honor.
Let me know when Perkins.
Edward Rodriguez on behalf of Alexis Murphy.
Alexis Murphy.
Thank you. What are we doing?
Your Honor, I received the discovery today and was able to review that with her. I think the only thing outstanding is a 911 call that was requested yesterday. I'd like to set this for an exam. The 911 call should come relatively.
People have their witnesses available the 27th. Preliminary examination in person, May 27th, 2025, 9 a.m. That is before Judge Washington.
Thank you, Your Honor.
Bond will continue. Thank you. Court calls the case of the People versus Maurice Cahey.
On behalf
Senator J. Bellinger on behalf of Mr. Kay, who approaches.
All right. What are we doing?
Your Honor, we are here for a plea today. I will let Ms. Zenda place that on the record.
Your Honor, the defendant's going to be pleading guilty to count 2, the sentencing under 4A, count 1 will be dismissed.
For a sentencing.
Correct, Your Honor.
May I have him sworn?
Right hand. Do you solemnly swear to affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God? Yes. State your name, Maurice Cahey.
All right. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of domestic violence. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Sir.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Sir.
You understand that?
Yes, sir.
Understanding all of that, you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand if we're pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct? Any question regarding those rights? Look at paragraph 5. Those are your rights which are part of a trial. You understand if by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Okay.
You understand that?
Yes, sir.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily of your own free will? And because you believe that you are indeed guilty of this offense? April 14th, 2025, at the location of 2700 International Drive, Ypsilanti Township, Washtenaw County, State of Michigan. What'd you do involving Charita Agee that makes you think that you're guilty?
Put my hands on her against her will.
You did what?
Put my hands on her against her will.
Okay. I get that, but what did you do? Did you push her? Did you?
She tried to attack me and I put my hands, I removed her off.
Okay, well, you run into the same problem.
I understand, Your Honor. If the court,
No, I can't accept the plea. What do you want me to do?
if the court wouldn't mind passing the matter for a few moments.
Why not? We passed everything else.
I appreciate it, Your Honor.
I'll pass it. Mr. Perkins is here. Let me try to get that. Court recalls the case, People versus Brian Brown.
Good afternoon, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Good afternoon, Your Honor, and good afternoon to your staff. May it please this honorable court. My name is Todd Russell Perkins, P55623, appearing on behalf of Mr. Brown. I'm not sure if he's
The facility that is housing him has not signed him in.
I guess I could waive his presence. If I could address the issue, Your Honor. I did speak with his new federal attorney. I'm not able to represent him federally because of a conflict. And I did speak with his federal attorney who has been working to try to find a solution to bond for him. And that was Allison Krieger is one of the newer federal attorneys that's working for him. So at this point, I know he was litigious in this matter in your court, in Washtenaw County Circuit Court, as it relates to the accrual of these charges. So that is an issue that is contestable. So at this point, Your Honor, we're at a PCC. I would ask for another PCC if I could, one final one, to see what, if anything, Ms. Krieger is going to be able to do, and how, because that's what I'd be asking, Your Honor. He's in custody.
All right.
He's in the federal system.
All right, I will, without objection, I'll adjourn it. I don't think we're gonna be able to move on this right at this point as we stand here now, so. How much time are they looking, Mr. Perkins?
If I could come back, is it going to be on a Thursday, Your Honor?
Always is, yep, pretty
Okay,
much.
just one moment. I'm trying to find it. June 5th would be a good date.
Probable cause conference in this matter without objection will be adjourned June 5th, 2025, 9 a.m. Or as your invite indicates, bond will continue. All right, thank you.
Thank you so much.
Yeah.
Thank you, Madam MG. Take care.
Have a good day.
Court does call the case. People versus Anushka. Got that right, King.
Assistant Public Defender, Janessa Perry, I'm Catherine King, who's the pro tem judge.
Hello.
State your name for the record.
What's your name?
Anushka King.
All right.
Judge, we're still in negotiation, so we're asking for an adjournment for us to.
Hearing it this time. Probable cause conference, May 29th, 2025, 9 a.m. Bond continued.
Thank you so much, Your Honor.
I think for the record, I know we had brought this up earlier. Ms. King did in fact get arraigned on that IBAC out of 35th District Court on May 7th, and our first pretrial is June 17th.
All right. Thank you.
Okay.
Court calls the case of the people versus Alexander Cronin.
That's good.
Good afternoon, Your Honor. Again, I'm
And good afternoon, Lori Yagi, Assistant Public Defender, with and on behalf of Mr. Cronin. Mr. Cronin, could you state your name for the court?
Good afternoon, Your Honor. This is Alexander Cronin. How are you?
And Your Honor, I just filled out a green sheet. I'm going to be asking for an adjournment for further discovery. I was just emailing with Ms. about the specific discovery that we are requesting.
Probable cause conference, June 5th, 2025, 9 a.m. Bond continued.
Thank you. Thank you.
Thank you.
Court calls, thank you. Court calls the case, people versus Eric Coons.
I've addressed it, Your Honor. I've explained.
Just what? The
The,
fact that he only has half his pants on?
that is correct, Your Honor.
Okay.
All right. Your Honor, we are going to ask this case be set for a preliminary exam.
For a preliminary examination?
Yes, Your Honor.
I just want to confirm with counsel, reached out with a requested offer. I inquired whether she had looked into, any sort of treatment program with Mr. Combs to facilitate that. And my last update as of April was that she was going to look into it with him. I want to confirm on the record that he is either rejecting that possibility and not interested in that course, or where.
Your Honor, to say he's not interested would be incorrect. He just, we're going to move it forward. He is considering the possibility of a specialty court. We've discussed specialty courts and the rigors associated with them. My client is not saying no, but in this moment, he is not saying yes. So I'm not saying it's not going to happen, just not today.
Okay. So the discovery is complete.
To my knowledge.
People have their witnesses available to 27th. Preliminary examination, May 27th, 2025. 9 a.m. in person before Judge. Fresh hour. Bond will continue. Thank you. Court does call the case of the people versus Maxwell Lawson.
People.
Yaki, Assistant Public Defender, with and on behalf of Mr. Lawson, who's approaching. Mr. Lawson, could you state your name for the court?
Maxwell Lawson.
Thank you.
Forgive my clarity, Your Honor. I was on my way to work this morning when I remembered I had court.
Okay, at least it's got whole pants on. Go ahead.
Your Honor, the people and I have previously discussed a potential offer. At this time, we're asking that it be set for preliminary examination. I have been trying to find a recovery court to no avail in Wayne County that is accepting transfers, and I've spoken. I won't go into detail. At this time, we're asking that this case be set for preliminary examination.
Discovery is complete.
To our knowledge, yes.
Witnesses would be available the 27th.
I'll try, Your Honor.
Preliminary examination, May 27th, 2025. 9 a.m. That's before Judge Washington. Bond continued.
Thank you.
Thank you, Your Honor.
Thank you. Court does call the case of the people versus Latrice Lee.
Michael Gaddy, defender for Ms. Lee, who's approaching, Judge.
Yeah, if I could approach, I do have an advice of rights and sentencing judge waiver.
Okay.
State your name, Mr.
Latrice Lee.
I don't care. Yeah,
Oh, I'm sorry, Judge. I have it.
I don't have a care.
Yes. My apologies, Judge.
All right, I have a plea form that indicates that the defendant will be pleading to the stated count 2 of operating with a high BAC, as well as count 3, attempted resisting and obstructing. The operating with a high BAC is a misdemeanor punishable by up to 180 days in jail, and the other offense up to 1 year in jail. Upon our successful plea to those charges, count 1 would be dismissed. That's the court's full understanding of it.
That's correct, Your Honor.
That is a correct recitation, Judge.
All right, before I take the plea, though, we have a violation.
Oh, I didn't know. May I approach?
May I approach this way, Your Honor?
Yes,
Violation.
there we go off. No, you know what? No, never mind. No, it's in the wrong file.
Oh, that's a meeting.
It's in the wrong file. It's okay. It was somebody else's violation.
Okay, I know, I'm,
But you look shy?
huh?
Never mind. All right, may I have her sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
State your name.
Latrice Lee.
And is she pleading guilty? or-
She's pleading no contest, Judge. I did provide the police report yesterday.
Yes, I have the police reports, I just don't. Ellen? Am I
It
in
must be
danger?
working.
No, am I in danger? Are you sure? You just telling me?
Oh, wow.
So you're gonna plead no contest. Any of those.
What?
So,
But that doesn't mean it went away.
Felon.
Maybe somebody be checking that?
don't look at me. He pointing to me.
You tell me, I'm, my faith and trust is in you. If you're telling me I'm okay, I'm okay. Ma'am, it's just court's understanding you're gonna plead to no contest to 2 misdemeanor charges. Is that correct?
Yeah,
The first one being the charge of operating with a high BAC. That is a misdemeanor, which is punishable by up to 180 days incarceration, up to a $700 fine plus court costs, The court could order community service and any rehabilitative programs the court deems necessary. Court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes.
The other charge is the offense of attempted resisting and obstructing. That's a misdemeanor, punishable by up to 1 year incarceration and a $1,000 fine plus court costs. You understand that?
Yes.
All right. Do you understand what a no contest plea is?
Yes.
Two things about a no contest plea I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest these charges. You understand that?
Mm-hmm.
Yes?
Yes. Yes.
All right. The other thing that you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
All right. You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Barr in the 14A2 District Court.
Yes.
You understand that?
Yes.
All right. Basis for the no contest plea.
Potential civil liability, Judge.
Ma'am, to the charge of operating with a high BAC, how do you plead?
Guilty.
You plead no contest.
No contest.
To the charge of attempted resisting and obstructing a police officer, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
All right. Please look at paragraph 5. Those are your rights which are part of a trial. And by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
Court has been provided and has reviewed Washington County Sheriff's Office report for their case number 24-81414. Any objection to the court having reviewed those reports?
No, Your Honor.
None from defense.
Based on the court's review of the report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Counsel, have I complied with the court?
People are satisfied.
Defense is satisfied, Judge.
Court will accept the defendant's no contest pleas to counts 2 and 3. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be
June 24th at 10 a.m. with Judge Barr.
June 24th, 2025. What time? 10 a.m. before Judge Barr. And will continue.
Thank you, Your Honor.
Okay.
Actually, if I could ask the court to address the court on a bond condition, Judge.
Yes, go ahead.
Thank you. Ms. Lee has been testing faithfully since the onset of this matter. I think she has had nothing but negative tests. We'd ask the court to remove the testing obligation at this time.
I don't need a response. I'm not going to do that. At this point, her bond will continue.
Thank you, Judge.
Okay.
Court does call the case. People versus Megan Moses.
People.
Assistant Public Defender, Shannon Carey, really, Your Honor, on behalf of, but unfortunately not with Miss Megan Moses. Is she on Zoom? Yes, she's on Zoom.
Ma'am, state your name.
Megan Moses.
Thank you.
Judge, we're requesting an adjournment. Our negotiations are requiring that Ms. Moses make some significant payments, so she's working on that, and I just need to talk with the people to see how much time they're willing to give her to make those payments.
Well, is she gonna?
Hello?
Yeah, hang on a second, Ms. Moses.
Okay.
Well, is she gonna, I mean, how much time are we looking at?
Well, Your Honor, I think that I will just be asking for the normal 2-week adjournment, and then once I find out from the people exactly what the terms of the agreement would be, I guess at that point I can present that to the court.
May 29th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court does call the, thank you, Ms. Moses. Court calls the case, People versus Tremaine Pender.
That's for the people.
And back in, we have a Mr. Pender who's appearing to my right. Please state your name for the record.
Tremaine Pender.
He's wearing shorts, Your Honor, yes.
Why?
Saw you looking at his shorts.
Well, I wasn't looking at his shorts. I don't know that that's, should be stated.
Yeah, I was at
I'm just
work.
wondering where the rest of the pant leg is.
No, I'm sorry. I was at work. I'm a carpenter, so I'm in the sun all day. I wasn't really thinking about my court session today. Because I just left work.
You weren't thinking about us.
No, I was thinking about you.
Oh.
I was thinking about you, but I'm outside in the sun all day. It's hot out there. I wasn't thinking, I'm sorry about that. I apologize.
Okay. What are we doing?
Your Honor, we request to set this matter for preliminary examination and all discovery is complete as far as we are aware.
Preliminary examination, well, people have their witnesses available the 27th. Preliminary examination will be set May 27th, 2025, 9 a.m. before Judge Fresh Hour. Bond continue. Thank you.
Thank you, Your Honor.
Thank you a lot.
Court calls case People versus Melton Rucker.
And I need a, an accept that, Your Honor.
Equipment. Will that work for you, sir?
Yes, sir.
All right.
Good afternoon, Your Honor. Marie Pan, Assistant Prosecuting Attorney on behalf of the people.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Rucker, Your Honor. Mr. Rucker, can you state your name for the record?
Melton Rucker. All right.
Your Honor, Mr. Bellinger has submitted to me a very detailed litigation report. I have looked through it. We are in negotiations, but I believe we need a little bit more time.
All right. Will 2 weeks be enough to try to?
I think that would be absolutely fine.
Okay, that works. Thank you, Your Honor.
Probable cause conference, May 29th, 2025, 9 a.m. or as your invite indicates, bond will continue.
Okay.
Thank you.
Thank you, Your Honor.
Thank you.
And don't leave without
Thank
getting
you,
this
sir.
from you. Okay?
Court does call the case, People versus Kirby Snyder.
Andrew Children's attorney on behalf of Michael Gaddy, Assistant Public Defender on behalf of Ms. Snyder, who's making her way to the podium, Judge.
Oh, it's fine. Don't worry about it. I'll let you finish fixing. You okay? State your name.
Kirby Snyder.
Thank you. All right, what are we doing?
Your Honor, this matter, well, we're asking for a brief adjournment. We have submitted the paperwork for the recovery court to Judge Kunke's office. We have not heard back yet. I did Teams Ms. Noveski earlier and to see if they had addressed her today, but I haven't heard back.
All right.
I do have a green sheet, Judge. I'm sorry.
Adjourn this to June 5th, 2025, 9 a.m. Bond continues. All right. Thank you, ma'am.
Thank you.
Thank you, Your Honor.
Court calls case People versus Virgil Stafford.
Brian Bowling on behalf of Mr. Stafford, who hopefully should be on Zoom, you're right?
Yes, I am.
State your name, sir.
Virgil Lee Stafford III.
Thank you.
Judge, Mr. Stafford met with the examiner at the Forensic Center on Monday, so we're just waiting that report.
I have this set for a probable cause. Shouldn't be, should it? Huh? I think it should be set for a competency here. All right. So you met with when?
Monday,
Monday.
9 a.m. Yep.
So let me then set this. We can always move it up, but what I was going is basically to the end of June. Let's see where we are. So June 26th. 2025, 9 a.m. Bond continue.
Thank you, Judge.
Thank you. Calls case of the People versus Kevin Stevenson.
Andrew Children's attorney on behalf of the people.
Stephanie King, I'm here on behalf of Mr. Your Honor. I have a green sheet. Your Honor, Mr. Stevenson is currently being housed at the Calhoun County Jail. A writ was not done. I did attempt to do this by stipulation. However, me and the prosecutor, we couldn't agree on, we wanted the court to pick the next date. Yeah, we were just trying to get the next date. I mean, in a good way though. So we were just looking for the next date from the court. He won't be released until the end of May.
So
Yes, Your Honor.
Oh, so it's not that they couldn't pick a date, they're trying to submit it after the deadline. And we said no. Oh, they didn't submit anything.
Echelon of people.
So it was, so they were like,
No.
That's what was going
No,
on.
so we were working really good on it. I wanted to go further out and she was like, why don't we let the court decide? And I said, I don't mind, that's fine. And so then we came here for the court to decide what date the court wanted to do, knowing that he's not gonna be released to the internet.
You can't reach out to me with the proposed different order, you need to June 12th. I'm sure if the court becomes going quite that far.
I'm not, but I will, with the understanding that he's not gonna be released till the end of May.
There.
So. Does that mean we shouldn't do it?
When we spoke to him, he said he's gonna be released the end of May. So we shouldn't, finally has been down, so I couldn't get that date. Hopefully it gets back up. So, Your Honor, thank you, June 12th will work for us. Thank you.
June 12th, 2025, 9 AM, or as your invite indicates, bond continued. She just left. She didn't even wait for me to finish. She just turned her back and walked away. Sounds like something a supervisor in that office needs to know about. Court calls the case People versus Elijah Stewart.
Good afternoon, Your Honor.
So if you hadn't gotten up in such a hurry to walk away, you would have been there.
I would have been there.
Never mind, go ahead.
I'm slacking today, Your Honor. Stephanie Cannon on behalf of Mr. Stewart, who is present to my right. Please state your name for the record.
It is Elijah Stewart.
Thank you.
Your Honor, we're just gonna ask for a 2-week adjournment, on this matter. We're doing some investigation and we do believe, that we will be fine by 2 weeks from today.
No objection.
Probable cause conference, May 29th, 2025, 9 AM. Bond continued. Bring in lunch.
Thank you, Your Honor. Appreciate you so much.
No, you
Good
don't.
morrow, sir.
What?
Good morrow.
Wow. Wow. Just go. Wow. Court calls the case People versus Courtney Taylor.
Alexander, on behalf of the people, Your Honor.
Assistant Public Defender Jay Ballinger on behalf of Ms. Taylor, who appears via Zoom. Ms. Taylor, can you please state your name for the record?
Courtney Taylor.
Thank you.
Your Honor, we are just seeking to set this for preliminary examination. Discovery is complete to the best of my knowledge.
People have their witnesses available the 27th.
We'll do our best, Your Honor.
Preliminary examination in person, May 27th, 2025, 9 AM. That is before Judge Washington. Bond will continue.
Thank you.
Court calls the case of the People versus John Terry.
And Assistant Public Defender Chinazi Carey, I can really, Your Honor, on behalf of, but unfortunately not with Mr. John Terry.
Really?
But we
What
do
a
have
shock.
an explanation.
Huh?
We have an explanation here.
You
Your Honor.
do?
We do.
Would it have anything to do with his violation?
Oh, yeah.
Okay, so go ahead.
So, Your Honor, I did receive a message from my office today indicating that Mr. Terry called this afternoon prior to the 12 o'clock block, stating that he was having a medical emergency. Unfortunately, I was not able to follow up to find out more details about that. I do understand based on the bond violation that the court is going to put a bench warrant out for my client, but what
I haven't decided.
I'm assuming.
You're assuming that.
That's correct. Well, I would ask, Your Honor, for an adjournment in this matter. Yeah.
No, but go ahead.
So what we were asking, I have been able to speak with Ms. Douglas about this. So what we're asking is that although the court will most likely put the bench warrant, we're just asking that it be delayed to give us an opportunity to get that information to confirm his medical emergency. And I know it is problematic because he's got the bond violation.
I don't need a response. Nice of you to ask me a second, really, but defense warrant will issue for defendant's failure to appear bond $25,000 cash surety. That warrant will issue immediately.
Thank you, Judge.
You're welcome.
Yeah.
And I know you didn't mean that. Thank you. Court calls the case, People versus Delco Thomas.
Hannah Mackey on behalf of Mr. Delco.
As in on behalf of the people, Your Honor.
Is it Thomas Delco? I think it's backwards. Your name, sir?
Yeah, I'm here.
Oh,
Delco Thomas.
Okay. That's not bad.
what'd you say? Uh-oh.
Why did I say that? Because you said it backwards.
Oh, Your Honor, at this time, we are requesting to set this for preliminary examination, and all discovery is complete as far as we are aware.
People have their witnesses available on the 27th.
We'll do our best, Your Honor.
Preliminary examination will be in person, May 27th, 2025, 9 a.m. That is before Judge Fresh Hour.
Wait a second.
Here, yeah.
Oh. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls case People versus Louis Feraldi.
Andrew Childers appearing on behalf of.
Brian Bowling on behalf of Mr. Feraldi, I'm sorry. They should have the waiver.
Louis Feraldi.
Thank you.
Your Honor, at this time, Mr. Feraldi is prepared to waive his right to a preliminary examination.
All right, is that correct, sir?
Yes, sir.
You understand the preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count.
Acknowledge receipt of the information, waive its formal reading and stand mute, Your Honor.
Defendant having waived formal reading, standing mute, court will enter not guilty plea. Pretrial will be set for
July 17th at 1:30 p.m. with Judge Slay.
July 17th, 2025, 1:30, Judge Slay.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Bond continues.
I'll give you the score.
Court calls the case of the People versus Jelani Wright.
And for Douglas for the people?
Mike Gandy, Assistant Public Defender on behalf of the right. Thank you. Your Honor, this is a date and time for, why am I saying that? You know why we're here. Your Honor, I've had a chance to speak with Ms. Douglas. This PCC was set today to see if Mr. Wright could post the some restitution as bond. He's not able to do that. We'd ask the court to adjourn the matter out to allow him to raise some funds. I've talked with Ms. Douglas. She doesn't have any objection to that.
How much time is he gonna need?
Would the court consider 6 weeks?
The only adjournment for this purpose, I don't like going out that far, but I'll adjourn it to the June 26th.
Thank you, Your Honor.
Thank you, Your Honor.
Bond will.
Thank you, Judge.
Court does call the case of People versus Maurice Cahey.
Alexander on behalf of the people, Your Honor.
Ready, Your Honor. Assistant Public Defender Jay Bellinger on behalf of Mr. Cahey who approaches. Mr. Cahey, can you please state your name for the record?
Okay.
Your Honor, we have had time to talk. We are ready for a plea at this point.
All right.
Thank you for your patience.
I think we had gotten to the factual.
That's correct.
All right. And so, sir, I'll ask you again on April 14th, 2025, location of International Drive, Ypsilanti Township, Washtenaw County, State of Michigan. What'd you do regarding a Charita a G?
Yeah. I shoved her against her will and she fell down.
All right. You didn't have permission to do that, did you?
No.
All right. And who is she to you?
My ex-fiance.
All right. And on that same date, well, I guess that's the only charge, right? No, we have a DV. We have the DV. We don't have an hour. All right. That's why if I complied with the court rule, would it be proper to accept this defendant's plea?
Yes, Your Honor.
Satisfied, Your Honor.
Court will accept the defendant's plea count 2, count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing will be
June 30th at 10 a.m. for Judge Washington.
June 30th, 2025, 10 a.m. before Judge Washington. Bond, can you with it?
Thank you, Your Honor. Contact probation. Okay. You're all set. Take care.
Yes, you may.
Good afternoon, Mr. Interpreter. You're in front of the Honorable Judge Simpson out of the 14A District Court of Washtenaw County, State of Michigan. Our number is 1423, and we need your assistance with one matter this afternoon.
Yes, this is the interpreter speaking. I am ready.
Thank you, sir. Can you please raise your right hand to be sworn? Do you solemnly swear or affirm that you will interpret accurately, completely, and impartially, using your best skill and judgment, to translate from English into Spanish and from Spanish into English in the manner now before the court to help you out?
Yes, I do.
Thank you.
And good afternoon, Mr. Interpreter.
Good afternoon, Judge.
Court does call the case of the people of the state of Michigan versus Dalton Castillo.
Bien, esta es la causa de el pueblo del estado de Michigan contra Dalton Castillo.
Ali Zenda, on behalf of the people.
Aquí tenemos a Alisandra a nombre del pueblo.
And Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Mahano Castillo.
Aquí tenemos también a la defensora pública a nombre del señor Castillo.
This is the first probable cause conference. I did fill out a green sheet. I am requesting to adjourn to obtain the 911 call.
La señora está solicitando, dado que es la primera causa probable, obtener la llamada del 911.
However, I would ask if the judge would hear a bond condition request.
También le estoy solicitando al juez una condición para requerir salir bajo fianza.
My client is requesting consensual contact. He indicates his family has told him that the complaining witness in this case wants contact. I don't know if the people have had any contact with her.
Mi cliente lo que está solicitando es un contacto consensuado, ya que no hay ninguna queja en el contacto continuo.
Your Honor, we do not have confirmation that she would want contact.
Mr. Interpreter, she said, we do not have confirmation that she wishes contact.
Lo que sucede es que no tenemos confirmación de que ella desee tener contacto.
In that case, I don't know if the court would potentially consider giving us only a week adjournment. I mean, I will follow up about this, but I know Mr. Mahano Castillo is eager to move this case along.
En ese caso se solicita, si el juzgado lo considera, por lo menos un permiso por lo menos de una semana, de por sí que el señor Castillo quiere avanzar con este caso.
Matter will be adjourned to May 29, 2025, 9 a.m.
Sí, el caso se traslada para mayo 29 del 2025 a las 9 de la mañana.
This bond will continue with the conditions, including no contact.
Sí, las condiciones continúan como están acerca de no tener contacto.
Thank you.
Understood. Thank you, Your Honor.
Gracias, señoría.
All right, folks. We're almost 8 hours in. The entire stream of the Judge Simpson is a grand total of 12 hours. But I think I will save the final 4 hours for tomorrow. Thank you, everybody, for showing up. Thank you for liking. Thank you for subscribing. And I will see you all back here tomorrow around noon Eastern time for the final 4 hours of the Judge Simpson hearings from May 12th to May 16th. Thank you, everybody, and see you next time. Bye-bye.
I'm a regular over at the Trial Watch Clips channel, where you go for clips of your favorite judges and your favorite attorneys and your favorite trials and your favorite cases. I'm a regular over at the Trial Watch Clips channel, where you go for clips of your favorite judges and your favorite attorneys and your favorite trials and your favorite cases. I'm a regular over at the Trial Watch Clips channel, where you go for clips of your favorite judges and your favorite attorneys and your favorite trials and your favorite cases. I'm a regular over at the Trial Watch Clips channel, where you go for clips of your favorite judges and your favorite attorneys and your favorite trials and your favorite cases.